and I would plead that you give directions on its hearing and disposal. Because as we all know, a contempt ordinarily is not permitted audience before purging the contempt. Can we have your directions for that contempt application to be heard and determined? I thank you.
What is the date of the application?
Where are these people with the contempt?
My lady and my lords, my name is Muge for the third petitioner. Now, my lady, that contempt application is dated 9th October 2024.
Thank you.
Yes.
Now, this is how we will proceed in the matter. The matter is coming up today for hearing of the application, that is application for conservatory orders and the one to set aside. We gave directions last week. We will proceed with those applications. At the end of the hearing of those applications today, we will give directions on the hearing of the application for contempt. So for purposes of going forward, those petitioners who file applications for conservatory orders will regard them as the applicants, and each of them will have 15 minutes. If there will be need for more time, we will consider as and when. And then any party in support of the application for interim reliefs will have 5 minutes each. Respondents, who are the applicants in the applications to set aside, will each have 10 minutes. And those in support will have 5 minutes. And then the applicants will have 10 minutes each in rejoinder. Interested parties, we will give them 5 minutes each, and if senior counsel Mr. Dr. Amino is around, we will consider his plea.
My Lord,
My lord, if I may pray, that in view of your directions in regard to the contempt application, we would like it placed on record. In view of the holding in the Supreme Court case of Republic versus Ahmad, Abolathi, Mohammed, and another, that any application for contempt, just like a preliminary objection, should be heard before any other matters. In view of that holding, my lords, we would like that placed on record that you have decided that we hear the potential contemners before the court in the face of that contempt application.
My lord, I think the court has given a direction, and our position on that is that if counsel is unhappy with the directions you've just given, he knows what to do. We have spent far too much time running away from the business of the day. This matter was certified urgent several days ago. It seems on the 9th of October that when the applications before you were certified urgent, we came here, the other side scattered the date when we came with what turned out to be a frivolous issues about to empanelment. When sufficient time had been wasted on that, they came again with what turned out to be a frivolous application on recusal. Now you're being told about the application for contempt. We must take it as beyond argument that when this application came before the court in Kerugoya, whereas the court in Kerugoya fixed a date for the application now before you, it did not fix a date for the application. Now you're being told to jump the queue. And if that be the case, then we must take it. It did not impress the court in Kirinyaga as an application warranting the type of priority that you're now being told. On the issue of whether contempt, if that argument were toward, my lord, we too, the party representatives, filed a PO, and you've not heard me telling you that that PO should start. I'm just following the directions being given by the court. And when all is said and done, my lord, the Swahili say, akili ni nywele, kila mtu akona zake. Nobody needs a brain in this court to know that the reason for all these dilatory tactics is because this side believes, having obtained a final ex parte order, they can now grind the wheels and backpedal and buy time until the conversion of the Jews, or until, as my people say, donkeys grow horns. The court must rein in these tactics.
My lord, permit me, please, to object to the term frivolous. We have been raising issues we believe are serious and weighty. We have no interest in raising frivolous issues. And I believe that is why this honorable court gave leave to appeal. This court will not give leave to appeal against any frivolous points.
Thank you, Senior Counsel.
My Lord Presiding Judge, permit me, speaking on behalf of the 9th petitioner, there is a concern that we have in view of the directions that have been shared by my Lord Justice Mrima, and my Lord, the comments that have been made by my senior, Dr. Muthomi Thiankolu. My Lord, indeed, there is a preliminary objection that we were served by counsel representing Professor Kithure Kindiki, a PU. And my Lord, just to assist us, I remember in the year 2021, when there was a challenge on the appointment of the Chief Justice, my Lord Justice Mrima had, in that instance, given a conservatory order while there was a pending preliminary objection on record. And when the state went to the Court of Appeal, there was direction that was given at the Court of Appeal that when there is a serious attack on the jurisdiction or the authority of the court, especially in view of a preliminary objection, then it is incumbent upon the court to first consider the merit or otherwise of the preliminary objection that attacks the jurisdiction of the court before perhaps we can go to any other matter or business of the court. I have with me, and I will share with the court, the decision that was made after a decision was arrived at by my Lord Justice Mrima and 2 others.
Thank you.
Thank you.
Thank you very much.
My Lord, is it possible that we just proceed?
We
Frivolous is
Counsel, we don't use that kind of language. I think Senior Counsel Paul Mutes fight that frivolous proceedings are not in this court. They may be elsewhere, but not here. My Lord Justice Mrima will give directions.
We proceed as a directed applicants.
My Lord, I was on my feet. This is on behalf of the petitioners on the issues of time allocation. My Lord, the respondents have, throughout this matter that has been going on, sought to have a time allocation scheme whose effect would be to guard the petitioners from presenting their case. My Lord, in the normal course of things, and this is a bench, one of the 50th or 70th bench that we are hearing before, the first business of the court before the directions of hearings are given, which we thought we could do on Friday, has always been what is the estimations of the advocates of the time that is necessary for them to do fair representation within the meaning of Article 50 of the Constitution. My Lord, we are here, we know the urgency of the matter. But as petitioners, on that issues of time allocation, the petitioners wants to plead and beseech the court that each of the application by the petitioners, we shall need 1 hour each to carry out the instructions of our client. My Lord, you have seen the bundle of documents that everybody is having here. This is a court of record.
I'm sorry to interject. Start with your 20 minutes. If they are not enough, we will consider. We're here. You shouldn't worry about time.
My Lord, for purposes of that issue, if I could just finish, the problem that we have, because we need to organize ourselves, that the time that has been given, one is going to do this and the other. Why that is absolutely important is that at this particular stage, because this has been a recurring thing, that there is instructions to be carried out. This is a court of record. We would want a fair allocation of time from the inception so that we are able to feel that at the end of the day, we did not refer to the court as a substandard case or an incomplete case. So it is only the minimum fairness that we should have.
My Lord, may I say something on the issue of time before the court gives directions?
Let time not be the issue here. Advocate Ongaya, please sit down. Let time not be the issue here. Time can be availed. We can be here the whole of this day. We can be here the whole of this day. So let time not be the issue of discomfort. We will give you the time you want.
Thank you so much, my Lord. That's an impressive direction.
My Lord, Your Ladyship, the sole purpose of conservatory orders under Article 23 of the Constitution, which gives this court power to issue conservatory orders, is to preserve the substratum, the subject matter of the petition. Here, what is being preserved is the right, constitutional rights of the Deputy President, who has challenged the impeachment for violating his rights, seeks to have that impeachment vacated and quashed. That is what needs to be preserved, and that is the purpose for which 3 judges issued conservatory orders, or 2 judges issued conservatory orders. But my lords, your ladyship, those 3 judges sitting separately, each one of them made a finding that there were serious, weighty constitutional issues raised that needed to be fully canvassed during the hearing of the petition, for the court to have the opportunity to give a considered decision on those issues, and therefore gave conservatory orders to preserve the subject matter so that the Deputy President remains in office. There is no vacuum, there is no insecurity. My Lord, the best guarantor for security is observance of the rule of law, constitutionalism, and the Constitution. And this is the court that has that weighted duty of ensuring that that happens. My lords, the weighty issues identified by the 3 judges are: 1, the issue of public participation. The petitioner here says the public participation was a sham. We will be going into that through my colleagues. I'm just saying the weighty issues here. The second issue was the constitutional validity of Standing Order 68, giving a period of only 12 days to finish the whole purpose of the impeachment. And I would like to mention this issue of public participation, and indeed the time of 12 days, assumes added importance when we remember the wording of Article 1. The wording of Article 1 is that sovereignty remains in the people of Kenya. They have donated that power, that sovereignty, to your lordships, to your leadership, to the judiciary. They have donated their power to Parliament, the National Assembly, and the Senate, and they have donated that power to the executive. But the people of Kenya remain sovereign. That is why there must be adequate public participation in terms of the decision in the British tobacco case. The third issue was proof, the threshold, serious violations of the Constitution, which the Deputy President says do not exist in his place. Our opponents will be pointing out to you where it is that undermining the President is one of the grounds. My lords, the people of Kenya, in retaining sovereignty in themselves, elected leaders, members of parliament, senators, deputy president, the president, to serve them. They are the employers. The deputy president, the president, the members of parliament are employed by the people of Kenya. And therefore, the people of Kenya have got a right to see how the people they have employed are discharging the duties they have been given. We look up to you, my lords, your leadership, to be the bench, what the judiciary is what the people of Kenya look up to hold the country together in terms of observance of the Constitution and of the rule of law. The people of Kenya, in electing the deputy president and the president and the senators and everybody else who is elected, they were not electing to go back to imperial presidency. And it is for this court to ensure that we do not go back to the imperial presidency, where the Constitution and the rule of law are replaced by the wishes of one individual. I hand over to my colleague Elisha Ongoya.
My Lord, for the record and for the interest of those who are transcribing the proceedings, my name is Elisha Ongoya. I appear for the first petitioner applicant, His Excellency Rigathi Gachagua, Deputy President of the Republic of Kenya. My Lord, I stand here to canvass the Deputy President's application dated 18th October 2024, which in the main seeks that you halt implementation, or put appropriately, further implementation of the resolution of the Senate made on 17th October 2024. Allow me to then also put on record that we have some written submissions that were filed, and I think it's good practice to draw the court's attention to them so that the record confirms that they are part of the record. We had filed some written submissions on 22nd October 2024. We adopt and reiterate the contents of those submissions. When we retire, we urge you to have a look at them. But we also filed some additional written submissions on 28th October 2024. Both of them are entitled Petitioners Submissions on the application dated 18th October 2024. Let me move into the substance of what I want this court to consider this morning. And I want to make some overall observations, my lords and my lady. I prefer to look at this case in this court as an opportunity for our constitutional order. Whereas I know that there may be Kenyans out there interested in this matter, looking at this moment as a challenge to our democracy and a challenge to our constitutional order, I bear a message of hope. I want us to look at these proceedings as an opportunity for our constitutional order. So the challenge for me, my lords and my lady, is how we shall seize and use this opportunity. I look at it as an opportunity for our governance institutions my lords will remember the words of the late Justice Chunlal Magwanda's Madan in that famous case of Githunguri versus Republic, where he urged Githunguri to run unto the hills, face east, and thank his gods that Kenya is a country under the Constitution. I see this as another opportunity. I beseech this court to urge His Excellency Rigathi Gachagua to run to the top of Mount Kenya, face east, and tell the world that Kenya is a country under the Constitution through the opportunity presented by this case. I see this case as an opportunity for the judiciary, and I'll be elaborating on this point in a short while because of the behavior of other organs of government in the recent past. So I see this as an opportunity for the judiciary. I see this case as an opportunity for righting wrongs and not for perpetuating wrongs. I have had the privilege of participating in these proceedings from the National Assembly, through the Senate, through this court. And I thank God and thank my client for that, because out of 50 million Kenyans, I have done nothing special to deserve this opportunity, but this somehow fate has conspired to give me an opportunity to participate and witness these events from the front benches. What this case has taught me is just how perilous we stand as a country if we depend on our legislative and executive institutions, and very recently, our constitutional commissions. Our remaining beacon of hope, my lords and my lady, is this judiciary. I have one question for you, my lords, my ladies. Will you drop the ball, or will you hold the ball to the finish line? A brief history of what you will find in our amended petition, by way of paraphrasing, is that on 18th October 2024, this country witnessed an unprecedented hurry by our executive, legislative organs, and our constitutional commissions to beat our constitutional order. I'll demonstrate this shortly. On that day, 18th October 2024, we witnessed an unprecedented hurry. In fact, I would have thought, speaking for myself, that our country has become super efficient. But I discovered that no, we were still waiting long to get our national IDs. We were still waiting long to get our passports. We were still queuing for long in our hospitals for health services. That this unprecedented hurry was for a specified project to beat our constitutional order. And why do I demonstrate this? A process for which the Constitution of Kenya prescribes 74 days at Article 149, Clause 1 of the Constitution was truncated and executed in less than 6 hours. Clearly, we may have varying definitions of the word hurry, but we can build consensus that this one is undisputedly unprecedented hurry. Why did the makers of our Constitution prescribe 74 days maximum in Article 149, Clause 1? Different analysts may give it different interpretations. I beseech you to find, whatever the scope of interpretations, the following will fit into them. Number one, it must have been to give the process optimum transparency. Number two, it must have been to give the process optimum accountability. Number three, it must have been to give the process procedural fairness. Because whereas we know that justice delayed is justice denied, we also know that justice hurried is justice miscarried. And finally, it must also have been to give public participation in the process under Article 149, Clause 1, some chance. Allow me to submit at that juncture from the very outset that the process undertaken by the President of the Republic of Kenya, by the Ethics and Anti-Corruption Commission, which was mentioned in the President's communique to Parliament, to the National Assembly, by the IEBC, that was also included in the President's communique to the National Assembly, and by the National Assembly itself, did not even pretend to have an iota of public participation. Even the pretense of public participation was now taken away. We will demonstrate to you that the process between 1st October and 17th October, the process between 1st October, when a notice of motion was given in the National Assembly, to 17th October, when a resolution was taken by the Senate, had pretenses, half-hearted pretenses of public participation. That will demonstrate. The process on 18th October, buoyed by any lack of checks, buoyed by the fact that any attempt at checking the institutions had not yielded fruit, now they became brazen. They now undertook a process on 18th October, now completely without any pretense of public participation. There is no single Kenyan who was given a chance to ever say what their take is on Honorable Kithure Kindiki, my law lecturer of yesteryears and a fundamental scholar, my good people, no Kenyan was given a chance to give any thought on whether or not he is suitable to be deputy president. No member of the public, no memoranda was received, no meeting was called anywhere for anyone to give any thoughts. No email address was given to be crushed by Kenyans, as we now know Kenyans can do it. Completely no pretense at public participation. I'm emphasizing these points, my lords and my lady, to demonstrate the point I made earlier, that we have now been taught how perilous it is for us to rely on our executive institutions and our legislative institutions and our constitutional commissions as defenders of our constitution. We are now left with only one institution, this judiciary. I don't know where that noise is from within here. Thank you. If they are doing renovations, they may be told that this is so important a day for renovations. We may defer them to another day. And let's face it. Let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024, in that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable Kithure Kindiki. That night. My lords, history is important, and I may not remind you why our Constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our Constitution. And therefore, when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 and the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared Honorable Kithure Kindiki in the night. I will not say much about KRA because I think KRA can work overnight and we will not complain. But it was that memorandum. The other culprit was the President himself. The President of the Republic of Kenya undertook these clearances overnight and in the morning had a clear proofread memorandum. Exceptional efficiency, we celebrate that. To Parliament. Then the National Assembly itself. Now this is curious. The National Assembly itself had called a sitting prior to the resolution of the Senate. The sitting was called prior to the resolution of the Senate. To sit on a day ordinarily not a day of sitting of the National Assembly to process a resolution of Senate it had anticipated the removal of a deputy president from office and processing clearance or approval of another deputy president. We sit here as judges, we sit here as court assistants, we sit here as advocates representing various parties. I don't know who among us, once we take away the cloaks of the official roles we play, was proud as a Kenyan observing these events as they happened. I don't know who among us was proud now putting on the cloak of citizenship to watch these events unfold at that pace. Fortunately for us, my lords, my ladies, we have a judiciary of Honorable Richard Mwongo that arrested this process in its tracks to give the Constitution a chance to roar. In the far corners of Kerogoya, fortunately for us, we have the judiciary of Honorable Chacha Mwita, His Lordship, that arrested this process to give the Constitution a chance. Today, you sit and I stand before the judiciary of Honorable Ike Ogola, Honorable Esim Rima, and Honorable Dr. Frida Mugambi, that has been invited by the respondents to undo that chance that the Honorable Mwita and the Honorable Mwongo gave the Constitution. We don't begrudge them for that invitation. Because under Article 48, they are entitled to come here and make that invitation. Our question is whether the judiciary of Honorable Gola, Honorable Mrima, and Honorable Dr. Frida Mugambi will be baited by that invitation. That's our only question. Throughout these proceedings, we shall be looking at you in the eye to ask, will you fall for this bait or will you stand for the Constitution? Having laid out our broad attitudinal view of this matter, allow me to address you now on the law and the jurisprudence of conservatory orders. In terms of textual prescription, in terms of the prescription of text of the Constitution, we will find accommodation for conservatory orders in two aspects of Article 23, Clause 3 of the Constitution. Article 23, Clause 3 says, in any proceedings brought under Article 22, a court may grant appropriate relief. So we find accommodation of conservatory orders in the use of the phrase appropriate relief. Because appropriate relief is wide enough to accommodate anything under the sun that is necessary to give effect to a right, fundamental freedom, or I dare say, any other provision of the Constitution. The second accommodation is in paragraph C of clause 3 of Article 23, which says, in any proceedings brought under Article 22, a court may grant appropriate relief, including, say, a conservatory order, expressly. I'm a bearer of good news that in determining whether or not to grant conservatory, to confirm these conservatory orders, my lords, you need not look further than in the files before you. I'll demonstrate you shortly. Just by looking at the files before you, you will see why you must confirm these conservatory orders. Let me go there. Allow me to address the brief issue of your jurisdiction over this matter from the files before you. I would invite you, when you retire, to look at the ruling of your brother Justice Mwita of 15th October 2024 in petition number 550 of 2024. When you look at that ruling, I would invite you to look at page number 7 of that ruling. There is a paragraph 7. The way that ruling was processed was that each theme the judge addresses by beginning with paragraph 1 to the last, then another theme, paragraph 1. So you see a lot of paragraphs 1, 2, 3, then it ends, and we begin paragraph 1 again. So you look at the paragraph 7 at page 7 of that ruling of Chacha Mwita in petition number 550 of 2024. For the benefit of this court, for the benefit of everybody who is listening, Honorable Chacha Mwita said the following things at paragraph 7, that the petitioner also argues that constitutional imperatives in conducting public participation were not met. The claim falls within the scheme of Article 165(3), so that this court has jurisdiction to interrogate whether any of constitutional processes said to have been conducted under its authority met the constitutional threshold. The judge has already established that the argument on public participation raised by the petitioners falls within the jurisdiction of this court under Article 165, Clause 3. Then, paragraph 9 of that ruling on the same page. Justice Chacha Mwita holds, first he observes that the first respondent has pushed an argument that this court has no jurisdiction to hear a matter arising from impeachment of the president or deputy president on the basis of Article 165(3)(c). Then he reproduces the provisions of the article verbatim. I wouldn't want to regurgitate that because you'll read it. He proceeds now to argue that Article 165(3)(c) is in relation to the process of removing the president or a deputy president from office on grounds of incapacity. This process is initiated for purposes of investigating the president or deputy president's physical or mental capacity to perform functions of that office. And here is the clincher. This is a distinct process from that of impeachment in Article 145 as read with Article 150. Article 163(c) excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Honorable Chacha Mwita has made a finding that this court has jurisdiction over a matter or a process undertaken under Article 145 as read with Article 150 of the Constitution. If you turn to page 9 of that same ruling, of Justice Chacha Mwita of 15th October 2024, in petition number 550, page 9, you will find another paragraph 4. I think I explained why these paragraphs run back and forth. Paragraph 4, he says, I'll read paragraph 4 and 5, so for full effect. Paragraph 4, Article 145 lays down the procedure to be followed in cases of impeachment and the timelines for doing so, including affording the person an opportunity to be heard on the charges. I have considered the constitutional provisions on impeachment and read decisions from the Supreme Court and the Court of Appeal, which are binding on this court. These decisions have laid down the position that it is important to let the impeachment process run its course, after which the court would have a look at any complaints on violation of either the Constitution, the law, or fundamental rights, including processes. After which, the court would have a look at any complaints. He's again asserting the jurisdiction of this court at this stage. Then, I would also invite you to look at at page 10 of that same ruling. At that same ruling. And this is the clearest warning that Justice Chacha Mwita was sending to the National Executive and the National Legislative Institutions Parliament. At paragraph 9 on page 10, he observes, in other words, constitutional processes are not about dashing to the finishing line, which is what they were doing. It's not about that. They were being told what we are doing is child's play. And we are not here about child's play. We are here about the Constitution. He says they have constitutional imperatives that must be complied with. And if not, such infractions will not be out of reach of our Constitution. He completes by saying, where there is an allegation that fundamental imperatives in the Constitution have not been complied with, which is the allegation that you have before you, my lords, my lady, the affected person, my client, His Excellency Rigathi Gachagua, has recourse to court, and the court will have to determine whether the state organ complied with the Constitution or the law. Has recourse to court. I began by saying we need not look further than in the files before you to assert that these orders have been confirmed, and I'm beginning by confronting the unfortunate allegation of lack of jurisdiction that has been filed on behalf of the person who was nominated to be the deputy president and who is supposed to uphold the Constitution. At paragraph 10, he gives the most enduring philosophical statement of page 10, paragraph 10, page 10. In that respect, our Constitution offers both hope and promise. Hope that the institutions it has established will comply with its fundamental principles. We now know that that was hope against hope. And promise that the Constitution is supreme, and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is beyond the reach of our Constitution. My lords, I want to speak the truth here. In the face of these pre-existing rulings in these files, you will hear arguments here of non-justiciability of this dispute, political question doctrines, things that have been fished in a cut and paste manner from old American jurisprudence into a transformative constitution of the 21st century. I mean, that's unfortunate. I am hoping that once I'm done with this, those who came to court carrying those arguments of political question doctrine, non-justiciability, will find favor in abandoning them to save us some time. At the same page 10, you'll find another paragraph 1. When I tell you the judge was starting paragraph 1 at every new issue. He says, Article 2, Clause 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by constitutional dictates, for any act or omission in contravention of this Constitution is invalid. That's what the judge is telling us. When you look at the files before you, my lords, you'll also find the ruling of your brother Justice L.N. Mugambi in petition number 522 of 2024, His Excellency Rigathi Gachagua versus the Speaker of the National Assembly and others. Another file that is before you. At page 9 of that ruling, you will find paragraph number 34. In that paragraph, the judge observes, and that was when he was delivering the ruling to send this file to the Chief Justice to empanel the three of you to sit. He says, Article 165, Clause 3, paragraph B or D of the Constitution has been delineated by Article 165, Clause 4 as constituting areas from which substantial questions of law might arise to require composition of a bench. He then goes ahead and reproduces Article 165, Clause 3, B and D. He's saying, before he sends this file to the Chief Justice to empanel a bench, he must satisfy himself that the dispute in question falls within Article 165, Clause 3, paragraph B or D. And he made the determination that the dispute falls within paragraph 165, Clause 3, Article 165, Clause 3, paragraph B and D, and send the file to the Chief Justice to empanel the three of you. The three of you are sitting on this bench on a finding that the court has jurisdiction. In the absence of that, the dispute would have been outside the ambit of Article 165, 4 for empaneling of a bench. Then, my lords, let me not just take you through the jurisprudence of others. Then there is your own jurisprudence as this bench. Days ago, on 16th of October, 2024. 13 days ago, the three of you, my Lord Justice Ogola, my Lord Justice Mrima, my Lady Justice Frida Mugambi, delivered yourselves on this question of jurisdiction. In that ruling, in petition number 522, as consolidated now with the others, in that ruling that you delivered on 16th of October, at paragraph 83, you observed that at the moment, that was at that time, this court is being called upon to anticipate the outcome of a process yet to be completed. The application at this point is premature and anticipatory. In any event, should the petitioners not succeed before the Senate, they still have an opportunity to approach the courts. The applicants cannot therefore say they have no remedy. Now, I was asking myself as I prepared, I'm imagining you now telling us, no, you have no jurisdiction. Having told us this, My lord, how will you look at each other? How will you look at us? You told us yourselves, go to Senate. Once you have finished, come here. Then we come here and you agree with my friend Dr. Mudomi Thiankolu. These are political questions and therefore we cannot deal with them. These matters are unjusticiable. How basic decency militates against at least the three of you, saying you have no jurisdiction. I respectfully submit, my lords, my lady. You observe that paragraph 85, that this court, and I was asking myself, what does the word this court mean? This court means two things. You said, this court has unfettered jurisdiction to check the constitutionality of the process at whatever stage. As such, we are certain that the petitioner's rights are currently well guarded and none of the petitioners stands to suffer any prejudice. You assured us that you have unfettered jurisdiction, that's what we used, jurisdiction, to check the process at whatever stage. I've said the word this court, I understood it to mean two things. One, to mean the High Court, because you are talking about this court. I don't think you had forgotten you are judges of the High Court. So that when somebody comes and says, we ought to have gone to the Supreme Court, they must also justify to you why you are using the words this court in this context. And number two, it means this bench. The three of you sitting here as a bench. You are now this court in this matter. You have unfettered jurisdiction to check the constitutionality of the process at whatever stage. At paragraph 87, you reiterated that you are exercising judicial restraint in order to accord constitutional entities the latitude to deal with their mandates. But then you said, we however clarify that courts can and ought to readily intervene in ongoing processes before any entity in the clearest of cases where there is evidence of flagrant and gross violation of human rights and fundamental freedoms. I began by telling you, the most flagrant is the happening of 18th of October 2024. The most undebatable. The National Assembly received a nomination of Honorable Kithure Kindiki from the President. The National Assembly had in its face Article 118 of the Constitution. In its face. I'm sure some members are sitting here of the National Assembly. They had in their face Article 118 of the Constitution. That article continued to pronounce itself because Article 259 says the law is always speaking. So this article was consistently speaking to the National Assembly. Consistently speaking that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The law continuously spoke. The Speaker called the House Business Committee. They met. Article 118 was speaking to that committee. That you shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. That committee turned a blind ear to this speech by the Constitution. They sat in plenary. Article 118 1B was speaking. That you will facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The plenary turned a deaf ear. 2. This dictate. The most blatant. I want to ask how we cannot stop the confirmation, the assumption of office of Honorable Kindiki on this argument only until we argue this matter fully and settle it at the hearing of the main petition. I want to see. I'm a career learner. If you convince me, I can tell my clients they have convinced me. But I'm trying to imagine the kind of philosophy you will require to convince me. The 50 million Kenyans out there know. None of them was ever called upon to make any view, any thought on the suitability or otherwise of Honorable Kithure Kindiki to be the Deputy President of Kenya. They know. Then, at paragraph 90 of that ruling, you observed, in other words, this court is still able to grant a remedy even after the process in Parliament is concluded. You again asserted your jurisdiction. I want to conclude this aspect of my submissions, my lords, my ladies, by pointing out that it's a high time that we laughed out of this court anyone who questions the jurisdiction of this court in this matter in view of all these prior rulings in the files before you. Allow me to then briefly address you on the other aspects of issuance of conservatory orders. Again, I will not go further than your own earlier rulings. In your ruling of 16th October 2024, at paragraphs 62 to 71, you pronounced yourselves on the principles that govern grant of conservatory orders. We agree with each of those principles that you set out in that ruling without any modification. We agree with each of the principles that you set out in paragraphs 61, sorry, my apologies, 62 all the way to 71. I will address myself to only one aspect of those principles and invite my learned colleague, Mr. Macharia, to address the remaining aspects. This is where you allude to the case of Gatirau Peter Munya versus Dixon Mwenda Gidinji and two others. If I'm not mistaken, this must have been the matter that was argued by my colleague, Dr. Tiankolu, some times back, so he would know it very well. It was among the first cases to deal with this matter. It's actually the first one in the Supreme Court of Kenya. You see, we celebrate Dr. Mudomi Tiankolu for contributing to this kind of jurisprudence. He observes, and I quote, that conservatory orders, consequently, should be granted on the inherent merits of a case, bearing in mind the public interest, caution of values, and the proportionate magnitudes and priority levels attributable to the relevant causes. I want to address myself to the inherent merit of this case, and just on one aspect of public interest. In fact, let me just begin by putting aside the issue of public interest, by asserting as a principle, my lords, that I desire that you hold that the greatest public interest is upholding our Constitution. There can be no superior public interest attributable to politics or other considerations that would outweigh upholding our Constitution. In fact, that is my understanding of Articles 2 and Article 3 of the Constitution. Articles 2 and 3 of our Constitution provide that the greatest public interest is in upholding our Constitution. I can see my learned colleagues jittery. I don't know whether they want to raise an objection. Okay, thank you.
Not me. I would never raise an objection regarding you.
Thank you so much, my teacher and mentor, Professor Gedum Muigai. And I'm sure our other colleagues have taken cue from you, Prof. So that, my lords, when a petitioner raises a matter like the clearest violation I have raised on what transpired on 18th, there can be no greater public interest than giving that matter a chance to be ventilated fully. I can't imagine of any. But having said that, let me now deal with how this petition meets the inherent merits test.
Just a minute. We had earlier on given a time allocation, which Mr. Kibe disagreed with and asked for 2 hours, we will give you that 2 hours and not beyond. You have done 1 hour.
Okay, let me now take 15 minutes to summarize the rest of the argument. Then we see how to wind up that. So let me address the issue of inherent merit, because that's my last argument. Then I can see what my learned colleague, Mr. Masharia, can mop up. We had gotten another indication, my lord, that we have the whole day. That's the last direction you gave before this one. So, that's why your words, my lord. I'm sure the transcript will come out with those words.
That is, we speak as Africans.
Let me do the best I can in view of the new direction, because that has made me now to change my approach. Which can
Certainly, Mr. Ongoya, you didn't expect that we have the whole day. We had given directions on time,
yes,
and on your own authority of Mr. Kibe, he said you would want 2 hours. And we have agreed to that. So let's stick to the petitioner side having 2 hours.
Let me give it my best. We'll deal with the eventualities. Allow me then just to refer you to a few things. On your ruling of 16th October 2024, at paragraph 78, you observed, and I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law. In so doing, a court must be guided by Article 22, Clause 1, and Article 258, Clause 1 of the Constitution, which provisions are on the right to institute court proceedings whenever a right or fundamental freedom in the Bill of Rights has been denied, violated or infringed, or is threatened, or when the Constitution has been contravened or is threatened with contravention." Then you at paragraph 79, you observe, "Applying the above in this matter," petition 522 that is before you now, and without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration. You made a finding that the case has inherent merit. You could see it without much ado. At paragraph 93 of that ruling of 16th of October, you observed that we have no doubt in our mind, your mind was clear, my lords, that this matter raises issues of immense public interest. A matter that raises issues of immense public interest, we argue, is a matter that is infused with inherent merit. When you consider the ruling of your brother, Justice Chacha Mwita, at page 9, paragraph 3, in petition number 550, which is now before you, the judge observes, and I quote, "There is further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency to demonstrate this fact. According to the public participation results for that constituency, the total number of people who participated is given as 43. Those who are in support are given as 70. Out of 43 participants in a public participation event to remove Mr. Gachagua, out of 43, 70 approved." Well, that's the case before you. This is how we have treated His Excellency regarding Gachagua, my client. Those who did not support were 3. They also got those who did not support. Having gotten 70 out of 43, there has some residue of 3 not to support. The percentage of those who support was 162.79%. we used to distinguish law and mathematics by saying that mathematics gives us instruments of mathematical precision. I don't know what the National Assembly will do with this mathematics, but this is curious mathematics. The judge then observes, it is implausible that an attendance of 43 people will produce 70 people in support and 3 in opposition. I submit that there was no remedial measure to this blatant failure by the Senate. There was no remedial measure. This poison has worked with this dispute throughout the process up to the time we come here. I'm making out a case that this case has inherent merit by these findings. At page 11, the judge referred this matter to the Chief Justice to empanel a bench on finding that the issues raised in this petition were immense. Again, that speaks to the inherent merit. When you look at the ruling of Justice L.N. Mugambi of 11th October 2024, all the way from paragraph 38 to paragraph 42, the judge highlights the matters of grave significance that this petition raises as a precondition to referring this matter to the Chief Justice. I submit that this speaks to the inherent merit of this case. And finally, at least for my part, when you look at the order from Kerugoya in petition number E15 of 2024, which is before you, at order number 3, the judge observed that the matters raised in the petition, being of great national importance and urgency, he then referred the file to the Chief Justice. And I have 2 observations to make here. The finding that the matter was of great national importance and urgency speaks to the inherent merit of this case. If you look at order number 5 of the order of your brother Justice Mwongo, he gave the Conservatory order because of the finding in paragraph 3, in order 3. He says, in light of the nature of the matters raised as noted in order 3, a Conservatory order be issued. I want to submit to the nature of those matters has never changed. For you to vacate this order, you must convince yourselves, convince us, and convince the entire Republic of Kenya that the nature of these matters has changed. The matter has remained as it was on 18th of October 2024, which was the basis for the grant of conservatory orders. I therefore submit as follows, that because this bench, Justice Mugambi, Justice Mwita, and Justice Mwongo have, in the various rulings above, already found that this matter has inherent merit. It is not open to the respondents in their application for setting aside to invite this very court to revisit that matter and reach a contrary finding in the face of the principle of res judicata that you considered and applied on 16th of this month. I also submit that because the 4 benches I have alluded to have consistently found that this court has jurisdiction, it is not open to the respondents to argue that this court has no jurisdiction and invite this court to enter a contrary view without violating the principle of res judicata that you used against the petitioners on 16th of October. I trust that my learned colleague, Mr. Macharia, has taken note of the time and therefore he is able to compress the arguments so that we pave way to the other petitioners. I urge that you grant the conservatory orders in petition number 565 of 2024 and in petition number 15 of 2024 at Kerogoya to preserve the subject matter and to give these parties a chance to ventilate themselves on the merits in the main petition. Over to Mr. Macharia.
If it pleases your ladyship and my lord, I will speak to three issues. The first of those issues is an issue raised most robustly by my colleague, I believe it's Dr. Fiankolu, and it is the question of political question. The second issue, my lords and your ladyship, will be the question of fair hearing. And the third one will be jurisdiction in the context of Article 40. Let me begin with the last one. In response to what the petitioners will tell you this morning, you will be treated to the most astonishing claim in our 10 years of the Constitution 2010. You will be told that the National Assembly and the Senate and the Executive have a dictatorship, have an autocracy on political questions, that those questions cannot be questioned by this court. That is the textbook definition of dictatorship and autocracy. The Constitution of Kenya, beginning at Article 1 and going to Article 10 and on to the end, is replete with the word accountability. Kenya is not a presidential democracy. Kenya is not a legislative democracy. Kenya is a constitutional democracy. When we gave ourselves this constitution in 2010, we introduced into it a concept known as limited government. And what that concept means is that those who are accorded powers under the constitution can only exercise those powers within the four corners of the power granted to them. That is number one. And that number two, on account of Articles 1, Article 2, and 3, all those decisions are amenable to judicial review for purposes of confirming compliance with the Constitution. My good friend, Mr. Dr. Fiankolu and his colleagues have in their submission cited to you a case which they have extracted from the Sonko, allow me to call it that, the Sonko Supreme Court decision. They tell you that on the basis of a decision called Nixon versus the United States, you have no jurisdiction on account of the political question doctrine. But what they've done actually is that they cut out the passages and left out the decision that the court actually made. This is what you will find at paragraph 113 of the Supreme Court decision. And so far, it's the only, I think, full decision by the Supreme Court on the question of impeachments. Full decision after an impeachment. This is what they say. In that sense, and and this is now a continuation from where the respondents here have cited in their submissions. In that sense, and in the exercise of these wide political powers, both the County Assembly and the Senate cannot act outside the confines of the Constitution. So that's the first point. The Senate and the National Assembly, even while acting politically, cannot act outside the confines of the Constitution and the law. That's number one. And they then say, and this is where you draw your jurisdiction from, for to do so would invariably invite the court's intervention, which is what we're asking you to do here today. They then cite the case of Nixon, which itself stated that there must be judicial review when state organs or state bodies misbehave. But this is what the court says. Courts are thus permitted to intervene where matters of constitutional violations arise. And that's not the only one, of course. We've cited before you other cases, including the Wambora decisions, where the court, both the Court of Appeal, went to great lengths to explain where you draw your jurisdiction from. So I believe the Supreme Court decision in the Sonko case should put to rest the question as to whether you have jurisdiction even on political questions. The respondents then make another submission. This is that this court lacks jurisdiction because jurisdiction to interrogate the presidency and its appointments or elections lies exclusively within the Supreme Court of Kenya. They don't say so explicitly, but they say so by way of example. And they tell you that under Article 164, I believe it is, Article 163, sub-article 3A, the exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the president arising under Article 140. It's important to linger on every of those words. The exclusive jurisdiction is limited to elections, number one, arising under Article 140. And there's a reason it's worded this way, and here's the reason. Now, not every election is a presidential election. Now, under the definitions set out under the Elections Act, the Elections Act is itself a statute promulgated by Parliament under the provisions of Article 82 of the Constitution of Kenya. It recognizes only 3 types of presidential elections. The first is Article 136. It is that election that leads and that has the qualifications and the mechanism for it under Article 138 that then leads to a petition in the Supreme Court of Kenya under Article 140. There is then another election under Article 139, sub-article 1B, and you'll find this in the definitions of the Elections Act. And the third presidential election understood is Article 146, sub-article 2B. A replacement of a deputy president under Article 149 is not an election. And I must confess that Article 149 was perhaps not worded very elegantly, because what Article 149 does is that Article 149 almost seems to have ended prematurely, because it says within 14 days after a vacancy in the office of the deputy president arises, the president shall nominate a person to fill the vacancy. So it's a nomination. The word used there first is nominate. A person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. It doesn't say anything after that. But one of the things I found when I examined another statute with similar provisions, this is section 32D of the County Governments Act. Section 32D of the County Governments Act is actually a lot broader. It explains how that vote will be conducted, the time periods for it, the threshold for that vote. It's a lot more elaborate. But one of the things it makes clear is that the vote akin to Article 149 is an approval. It's not an election. It's an approval. And if one were to examine the Constitution further, everywhere the word election is used, and just by way of a few examples under the Constitution, Article 86, Article 87, Article 83, all of those articles, including the powers and functions of the IEBC, which my learned friend Mr. Ndegwa will be speaking to later, all of those make it clear that the election contemplated is a contested election with voters under Article 1. 14 million Kenyans. That is what the Constitution understands as an election. That then invites the jurisdiction of the Supreme Court of Kenya under Article 140. So it cannot be that the respondents get to make two opposing arguments. They argue that because this is their argument, this is an election, so you can only go to the Supreme Court of Kenya. But they then argue this is not an election that requires the IEBC. That's one of the things they've argued. Because an election requires the IEBC, as properly understood. So even that argument that the Supreme Court of Kenya is the only one that has the repository of jurisdiction to determine this matter does not find any basis, does not find any grounding in the Constitution of Kenya. You can also look at Article 106(2)(a) for what they discuss when they talk about an election. So Article 149(1) does not envisage any contest. The president nominates one name. And while I'm here, let me deal with an elephant that my learned colleagues will be throwing at you. It's actually more of a monster. In response to what we are telling you, they will tell you there is a public crisis of monumental proportions, not seen since the late Daniel Arap Moi told us that he will appoint a vice president if it increases the sufurias of ugali in our houses. We were told this is the worst thing that has ever happened. There is a vacancy. Answer number one. Article 148 does not, not 148, sorry, I believe I'm talking about the sequencing where the Speaker of the National Assembly is the third in command, so to speak, when there's a vacancy. I have been waiting for my good friend Mr. Milimo, who represents the Speaker, to shoot up to his feet and protest loudly that his client is not a vacuum. Because the Constitution says, when, I think it is, this is Article 146, Sub-Article 2(b). If the office of Deputy President is vacant, or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of the President shall be held within 60 days after the vacancy arose in the office of the President. Two things to note there. In that article, the framers of the Constitution contemplated a vacuum in both the presidency and the deputy presidency. And it is at this point where my good friend Mr. Milimo says his client Anatosha. Maybe you will say it. I am almost certain in the event that my good friend Mr. Kamodo described here a few days ago, when he said the president might go to where people don't come back from, that we will all say we're Anatosha. He did. The record says so. Yeah, but we understood him. He was not wishing ill. So that's the first thing. The second thing, my lord, is that they contemplated we can operate for 60 days, 2 months, without either a president or a deputy president. The world will not collapse. Kenyans made adequate arrangements for the caretaker, while those two are not with us. And there seems to be something magical about these 60 days that Kenyans clearly had. Because under Article 149(1), when the deputy president is impeached or there is incapacity, the president has 14 days to nominate a candidate to the National Assembly. That is number one. And because it is not obvious, or it is not a matter of course, that the National Assembly will approve that candidate, it must be contemplated that the National Assembly can refuse to vote for that candidate. So those 14 days can be repeated, which is what the Constitution says. If Parliament rejects the first candidate, the process is repeated again. And the Constitution seems to contemplate can be repeated almost indefinitely until the President comes up with a name that is acceptable. So that is number one. And there's no crisis. The world will not end as Parliament rejects those candidates. So that's number one. But the President having nominated a candidate, the National Assembly itself has then another 60 days. So we can again operate as a country for 60 days without a deputy president. And so I return to what the Supreme Court said in the Sonko case we must do, and has not been done, has not been afforded to our client, the Deputy President. This is what the court says. This is the Supreme Court again at Article 114. And it's interesting because what had happened in the Sonko case, the court actually found that Sonko was not properly before it. But they then said they converted the proceedings into an advisory opinion. So they're actually giving this as a template for courts, such as this honorable court, to follow. Article 114, paragraph 114. To the question whether due process was followed in the removal of the appellant, the Audi alteram partem rule requires that those who are likely to be directly affected by the outcome of a decision should be given prior notification of the action. So they give a whole list of what must be done. Prior notification of the action proposed to be taken, of the time and place of any hearing that is to be conducted, and of the charge or case they will be called upon to meet. They must be given an opportunity to be heard. Now, it is not a matter in dispute that on the night the Senate, I and my colleagues on both sides were present in the Senate, our client was taken ill. I have subsequently read in the newspapers he had a broken heart for good reason. So he is taken ill, and the Senate then takes a vote. And this was important because the Senate had 2 days left, even in their own self-prescribed time limits. They voted, and this was not an electronic vote. They voted on acclamation to reject a motion to extend time for the Deputy President to appear
My
in
Lord,
court.
if I may, I am compelled to interrupt. My Lord, learned counsel is misleading the court. When on affidavit, it is clear that the Senate votes electronically. Senate does not vote by acclamation. I do not know what paragraph is addressing himself. Perhaps he can point the court to the paragraph he's addressing himself to on the question of acclamation. We can't just sit back and watch Mr. Macharia mislead the court.
I was personally there. Senior Counsel Mwite was there. The entire team, most of them were there. On the question of extension of time, it was by acclamation. All the ayes and all the noes, that's what it was.
And the senator was loud.
Yes. And I would ask him to please wait. He'll be a bit more bothered when I finish with my submission, so he can be bothered fully when I finish. So this is what the court says. They must be given an opportunity to be heard, to call witnesses, to be represented by counsel, to be availed adequate time and facilities to prepare, and if the accusations are proved, to be given the reasons. This is important. The Supreme Court says you must be given reasons for your decision. There are no reasons. They voted on grounds submitted to them by the National Assembly. They did not give reasons for that decision. Of course, beyond there, they are also entitled to challenge the decision. Again, you've been told these decisions are not challengeable. The Supreme Court says the accused must have a right to challenge the decision, if against them, before a higher court or tribunal. At paragraph 115, Article 47 of the Constitution enshrines the right of every person to fair administrative action. The manner of actualization of those rights have been enacted in the Fair Administrative Actions Act. Now, when this Honorable Court retires to do its ruling, I would invite you, with tremendous respect, to pay attention to sections 4 and 5 of the Fair Administrative Action Act. They're important in more regards than one. Senior Counsel Paul Mwite has alluded to the question of public participation, and so will some of my colleagues who will come after me. When the National Assembly conducted what it called public participation, it did not avail to the public the response by the Deputy President. What they did is prepare a charge sheet, a copy of which you will find as Annexure 8 of our affidavit in support of the petition, which for ease of reference is at page 498. That charge sheet asks 3 questions. It first sets out the 10 grounds that the motion promoter had set out, and then asks people, do you agree that the Deputy President should be impeached on these grounds? Do you not agree? And then there was a third one, other. That was it. They were not told what his response was, nor was he given an opportunity prior to this process. Because the only way, and you'll find that this is one of the things the Supreme Court says under the Article 47 and Fair Administrative Action Act, the participants in this public participation must know both sides of the story to make an informed decision as the people who voted in this man. The court then goes on at paragraph 116. In the process of removal of a county governor, and for this case the Deputy President, the right to fair administrative action under Article 47 and the right to fair hearing under Article 50 of the Constitution all accrue, and I'm paraphrasing here, to the Deputy President before a decision to remove him or her from office is reached. An unfair removal is one which goes against the principles of natural justice, just like I've demonstrated, which implies that no adequate notice was given, that there was bias, and where the hearing was not fair. In our amended petition, which you will see in the fullness of time, we have given particulars of how each and every of these issues was violated. The Senate and the National Assembly, first and foremost, constricted the time allowed by the Constitution for themselves. They cut their own time short, and so no one had sufficient time to do anything. We have said they introduced new evidence as the trial was going. There was panel beating as the matter was going on, and as I've said, there was a lack of fair hearing. Though, this is Supreme Court, though a political process, impeachment is sanctioned by the Constitution and the law and is not a platform to settle political scores. This speaks to what Senior Counsel Paul Muite said a few minutes ago. It's not an issue of ticking boxes, going into a room and saying 300 of us have said you're a bad man, you must go. You're a bad woman, you must go. You must comply with each and every of the provisions of the Constitution. Bearing in mind that the removal architecture in the Constitution, the law, and the standing orders are designed to achieve accountability, political governance, and personal responsibility, and are not aimed necessarily to find criminal responsibility. On the question of natural justice, this is what, this was a decision by, I believe, your brother Justice Odunga. It's in our list. This is miscellaneous civil application number 266 of 2017. He cites at paragraph 69 a case, I believe, from Uganda. It is a cardinal rule of natural justice that no one should be condemned unheard. Natural justice is not a creature of humankind. They are asking you to take away a creature, and let me read through what it says. It was ordained by the divine hand of the Lord God. What God has given us, do not allow these respondents to take away from the Deputy President. And that any law that contravenes or offends against any of the rules of natural justice is null and void and of no effect. The rule, as captured in the Latin phrase audi alteram partem, literally translates into hear the parties in turn, and has been appropriately paraphrased as do not condemn anyone unheard. That is what the Senate did to the Deputy President. You cannot allow their resolution to stand. There is a decision, I will not read this for you, but this is a decision of the High Court, a 3-judge bench, Republic versus National Land Commission. I believe this is miscellaneous application number 266 of 2017 at paragraph 109. The decision of the Supreme Court of Kenya in Speaker of the National Assembly versus Attorney General and 3 others, where the court again restated, the Supreme Court, your jurisdiction in these circumstances. And then to the Senate proceedings I've just read out for you. In the Wambora, in the Martin Wambora case, this is what, this is the case, this is, it's cited in the Mike Sonko-Mbuvi case versus Clerk of the Nairobi County Assembly at paragraph 226. I believe this is the High Court decision. This is what the court said about what my good friend Professor Rejoinder was getting a bit hot under the collar over. Although it does not fall within our remit to direct the legislature on how to perform its functions, we are of the considered view that impeachment of a governor is a serious undertaking, just like a deputy president, as the end result can lead to the removal of a popularly elected governor. The deputy president before you and the president who ran for election in 2022 were elected by a vote of slightly over 7 million people in this country, out of 14 million people who participated. It's a very serious matter. For this reason, we recommend that it will be desirable that future impeachments proceed through the committee route as opposed to the plenary. This is what the court is saying. We say so because when the special committee is appointed, it has 10 days to deliberate on the matter, thus giving ample opportunity to the parties to adequately prepare their cases. The Senate chose not to avail itself of this constitutional mechanism. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary. The trial of the deputy president was held entirely in plenary. And a lot of things, when you look at the Hansard, for example, there was a lot of issues raised about a will, about a succession matter that has nothing to do with the Constitution of Kenya. When you look at the Hansard, a lot of things that had nothing to do with this constitution, and here's the problem. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary, which can be perceived to be a mob lynching process, which is exactly what happened. That is our submission before you. It is what my late member of parliament from Kangema, the late John Joseph Kamotho, used to call kura ya makelele. Now, under the grounds for granting a conservatory order, one of the issues the court is called to look into is the question of whether the orders or whether the hearing will be rendered academic or nugatory. Now, at paragraph 20 of our supplementary submissions, which are dated 28th of October 2024, we have cited before you a case by the Court of Appeal, Attorney General versus Matindi and 55 others, where the court explains the following. A successful appeal is not reduced to a mere Pyrrhic victory or paper judgment. Whether or not a matter will be rendered nugatory is determined on a case-by-case basis, depending on the peculiar circumstances of the case. But ordinarily, the court will grant relief if what is apprehended cannot be undone once it happens, or cannot be undone without undue hardship or expense, or cannot be adequately compensated by an award of damages. The court takes into account the respective hardship that grant or refusal of relief is likely to wrought on the parties. I want you to take my colleagues' submissions where they say you cannot undo. Once a new candidate for deputy president is nominated and sworn in, they say the court has no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has been sworn in and has taken office. This is what they're telling you. At any length, they tell you, this is a political question, don't even look at it. That's why they began. Don't even look at this. The president knew what he was doing, take him at his word and at his actions. So that's one side of the balance of the scale. On the other, you have a sitting deputy president who is before a court of law as he ought to be. If, in the unlikely event, his petition were to fail, all he does is go back home and we swear in the new one once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, a deputy president, who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the Constitution of Kenya. The balance lies in granting conservatory orders so that we can do this in a civil manner. Former Supreme Court Judge of the Supreme Court of Kenya, Justice Ojwang, used to call a pacific resolution of the dispute. As I said, the Constitution has given ample time for all of us to interrogate these questions. 60 days is the magic figure the Constitution gave us. Let's not be in a rush to undo the timelines given to us by the Constitution. And finally, the decision of, I believe, Gatirau Munya, the question of the public funds that are expended, swearing in a new deputy president, getting him a whole fleet of cars and workers, and the trappings of power, and as is the custom, perhaps even doing the road to his village home, all these sort of things. So let's hold our hands until we can determine whether the process that led us to this day was done constitutionally. That is the Peter Gatirau Munya decision. My lords and your ladyship, the decision you make in this matter will echo in eternity. It will be a turning point as to whether we continue being a constitutional democracy or a dictatorship and an autocracy. I beseech you, do not let us go down the path of autocracy and dictatorship. Thank you for the privilege of your attention and your time. Unless you have any questions for me, I'll hand over to one of my colleagues. Thank you.
Thank you.
My Lord, my name is my name is Kibe Mungai. The team leader is Paul Muite, Senior Counsel, assigned this application, the one from Kerogoya, to me, Professor Ogada, and Mr. Ndegwa Jiro. As I had already indicated to the court, and with the benefit of the submissions from my learned colleagues, we shall try to do our business within an hour. So I'll start first, followed by Mr. Ogada, and then Mr. Ndegwa, for purposes of presenting that application. My Lord, let me start by thanking the court for the decisions that it rendered on last Friday on the questions of directions that it gave for the hearing of the petitions that are before the court. My Lord, I confirm that the process of amending the various petitions is ongoing and will be filed in accordance with the timelines fixed by the court. My Lord, going by the timelines that you gave, it is also my pleasure and appreciation, and that is in ensuring, with the compliance with the Mutunga rules, that it is possible for your lordships to ensure that in the same way that the month of October we dealt with the political aspects, with the political phases of impeachment, that it is now possible, courtesy of your directions, to ensure that we can be able to have a judgment on merits for purposes of the various petitions that are before you. That would be an absolutely important issue for this court to remember, because it is being made as if it will not giving due process and ensuring substantive hearing of this matter, that we shall be here until forever. My Lord, all these businesses can actually be concluded within the month of November. That being the case, my Lord, by way of introduction, let me say two things in my own words as counsel representing, I believe, the 4th to 8th petitioners who filed the application that is before the court.
The date of your application?
Yes, my Lord, that is exactly the issue. 18th, my Lord. The application was filed on the 18th of October. Yes. Okay. My Lord, 18th, it is supported by an affidavit sworn by Honorable David Munyi Mabenge on the same date. My Lord, for purposes of the documents, let me start there. We have filed submissions. The submissions were filed yesterday. There is a supplementary we filed today, and we have filed various responses to the affidavits to set aside that my learned colleague, Mr. Ogada, will be referring to them. My Lord, that being the case, I wanted to say that by way of an introduction, there are two broad issues that I can be able to say. My Lord, thank you. Yes. My Lord, the first issue is that the petitioners moved the court view of the fact that under Article 3(2) of the Constitution, every citizen of Kenya has an obligation to defend and protect the constitutions of Kenya. That's a broad mandate. And of course, further to the other mandate, that under the Bill of Rights, from Articles 19 to 23, where the Bill of Rights is being violated, they are permitted to come to this honorable court to seek for the appropriate reliefs. And therefore, that is the basis upon which they came and have moved this honorable court. My Lord, the second broad issue that I wish to cover at this particular stage is to point out that what is basically the big thing about the matters that are before you. My Lord, the big issue for purposes of the matters that are before you is that these impeachment proceedings, after you hear us, two possible scenarios are clear. Number one, the Deputy President, who has already argued his application, as his advocates has pointed out, is an elected Deputy President, an election that was conducted on the 9th of August, 2022. My Lord, on account of the vote of impeachment passed by the Senate on the 17th of August, 2024, if the process concludes in accordance to the manner in which it has so far been implemented under Article 149(1) of the Constitution, it would result into Kenya having an appointed president 2 years after one who is elected was put into office. My Lord, that's a big thing, whichever way you look at it, for the simple reason that one of the important devices of the 2010 Constitution was to ensure that the holders of the offices of President and Deputy President have the direct mandate of the people. So, in a matter where that important issue of our constitutions could change, it is our submissions that every absolute care must be taken to ensure that the process and the law leading to this very critical political and legal transformation on our constitution has been addressed. How would this be addressed? My Lord, we shall be arguing together with my learned colleagues that the only way in which this can be done is through the hearing on merits of the petition that are before this court. My Lord, having given those introductory remarks, let me come to the application of the 18th of that day, and by highlighting the issue that we both clearly know. My Lord, impeachment, and many cases, I will not go through them. The many cases that have been cited of impeachment shows that impeachment in Kenya has 4 processes. One, where allegations are made, that is purely political. Muduse went around, collected his evidence, presented. There was a motion, I believe, dated 29th of September, asking Parliament to have this 26th. I'm told 26th of September. That's the stage 1 of the political process. Stage 2 of the political process is the stage where the National Assembly approves by a vote of 2/3 of all the members to allow to reject the impeachment motion. My Lord, that was done. There are various issues that have been raised in the majority of the petitions that will be argued in the fullness of time that shows the significant problems when this matter was at the parliamentary level. Topmost of them being the impartiality of the Speaker and the Deputy, together with the manner in which public participation was handled. Stage 3, my lords, is the stage of the Senate. The law clearly talks about what the Senate should do, how the voting should be done, and again, there is evidence. My learned colleague, Mr. Ongoya, and Honorable Muite, they pointed out at the significant problems that we had there. I am most interested, my lord, in the fourth phase. The fourth phase of impeachment, as it has now been established in our jurisprudence, is where these courts seeks to establish whether there was compliance with substantive law and procedural law by the political organs upon which the mandate of impeachment has been entrusted upon by the Constitution, other laws, and the respective standing orders. Again, my lords, that phase, that where the court is supposed to deal with this issue, it is our submissions that this is the stage that this honorable court must ensure, because it is the court, that all aspects and proceedings are dealt with in a manner that we all had, and I'm happy for the time that the court has agreed to allocate us, so that the court with sober minds can be able to decide, have the laws of our countries been upheld or not. My lord, there are clear guidelines that have been set out by our constitutions for purposes of doing that. And my lord, because we are here because of an applications for conservatory orders, under Article 159 of the Constitutions, this court has an express duty that in exercising the delegated judicial power of the people of Kenya, it is required, the certain guidelines have been given by the Constitution under Article 159, that is besides other provisions of the Constitutions. And one of the most important one is that that the court will do substantive justice. Substantive justice is an important issue, and it has specific meaning through the very many decisions that have been rendered over time by the courts of this country. And the clear meaning in plain English, because it is important we understood in plain English. In plain English, it means a very simple things. That, for example, my lords, if we have a case over a goat, Mr. X and Mr. Y have a case over a goat, this goat should remain alive, and so that at the end of the decision, the court can decide whether it belongs to Mr. X or Mr. Y. That is a very simple meaning of substantive justice. So that, my lord, substantive justice, therefore, conservatory orders, is a mechanism that our laws preserves the goat. Our laws preserves the subject matter of the case. The subject matter of the case, my lord, is the questions of vacancy in the office of the president. Going by the Senate, the deputy president was impeached. On account of the orders that have been given, that office is yet to be filled. So that, my lord, the question, therefore, is easy to define, and can be defined this way. That, as we wait for the hearing and determinations of this case, it cannot be settled at the interim level that the Honorable Kindiki will now be the Deputy President of Kenya, so that as we argue the petitions, there is already the impeachment process has been concluded to the disadvantage of the other people, of the other person who is seeking the same office. So that, my lord, is a simple issue that is very easy to define. So that, my lord, we shall be arguing that when we come to that particular issue, why on earth, because you have before you, because if a conservatory order is the legal mechanism, the legal device that is established by the constitutions to preserve the substratum of the matter, and for this court to do substantive justice, how on earth does the respondents expect that substantive justice will be possible if the trophy that is being tussled over, that is being contested over, is handed over to them. My Lord, all systems of justice would be offended to be told that it is possible at halftime for one team to be declared to be the winner before the matches is concluded. Why can't we wait for all these issues to be concluded? It is a simple meaning of what substantive justice is all about, and the courts, the duties of the court to ensure that the ring is held even for all the parties, so that we do not argue over an academic matter, which would be the worst issues that can happen. My Lord, there is the case of the Gatirao Peter Munya. I'm coming to the applications for conservatory order. The principles are very clear. I just need to go on them as quickly as I'm able to. Under Gatirao Munya and other decisions, we have a big authorities, many authorities. The issues were set out very, very clearly. And there are three tests. The first test is on the prima facie case. My Lord, my learned colleagues have set out the various many legal issues that are there. That from the standpoint of the applications that we are arguing before you, there are 5 issues for purposes of the prima facie case to comply with the Gatirao Munya case. The first one, my Lord, is public participation. I don't need to go into that. It's a substantive issue in the majority of that issue. My Lord, the second issue is what we call the legality of the standing orders of the Senate. My Lord, in the petition filed in Kerugoya as 015, the petitioners, amongst other things, are saying that although the Constitution provided for clear timelines on how, for example, the business is going to be conducted, and specifically said that this investigative committee is the only committee that can be able to discharge that constitutional function, the Senate established standing orders under which the plenary of the Senate can also resolve that issue. The Constitution of Kenya does not provide for a mechanism on how the Senate can discharge that function. But it is very clear on how that investigating committee is supposed to conduct its business, and how the right to hearing is to be given after a finding has been made that there is a case worth responding to. My Lord, I submit that's a big issue on the standing orders that were used to pass the vote of impeachment. The second issue that has been sought in that case is the issue of interpretation and application of those laws on impeachment, 44, all those laws, 48, 144, 144, 149, all those have been raised. My Lord, as you clearly know, this is the first impeachment for purposes of those laws. And therefore, if a question of interpretation has been raised specifically before you, it underscores the necessity to ensure that on merits, this court actually determines and interprets the law, so that the next time we have probably to do it against the president or against Kindiki if he gets there, the law would be clear and we shall not be going through all these things. So a serious issue has been raised by that petition. The other serious issues that have been raised is, of course, the fairness of the Senate proceedings. I will not go into that because already the lawyers for the deputy presidents have raised that issue. And the fifth important issue is the issues of nominations of the Honorable Kindiki. That issues of the nominations, my learned colleagues will say more about that. But as we wait for their turn to come, the only two issues that I need to say at this early stage is to point out the fact that under the constitutions, I believe Article 137 of the constitutions, any person occupying the office of the deputy president or the office of the president must be qualified in accordance with the constitutions of Kenya. under the impeachment articles of the constitutions, these issues of the constitutions on the qualifications are not set out. So that because they are not set out, it is an assumption that when reading the Constitution holistically, this court will go to those other specific provisions of the Constitutions where the issues of qualifications are set out. My lords, those issues of qualifications are many. One, and the body under the Constitution, my learned colleague Mr. Ndego will say more about it, is that the IEBC confirms whether any person has those qualifications or not. I don't think that is a contested issue. I believe it is also not a contested issue that at the time that the President of Kenya appears to have received some letter from IEBC confirming that the Honorable Kindiki is duly qualified to hold the positions of Deputy President, courtesy of Article 149 of the Constitutions, we did not have IEBC. Of course, various arguments can be taken by the parties that are before you. Those arguments cannot be concluded. Those arguments can only be arguments to justify whether or not the conservative orders will remain in place or not. But they'll have to be settled when the petition has been heard. The second important issue on the aspect of the nomination of Kindiki that I need to point out is this, that even assuming the president did the right thing and everything else that he was doing, this court should be concerned by the fact that whilst the case was still going on before the Senate, the National Assembly scheduled a meeting by the National Assembly, which under Article 149 has 60 days, a meeting to occur the following day, within about 7 hours after the vote of the Senate. Why should this concern the court? It should concern the court for the simple reason that under Articles 10 and 118 of the Constitutions, Parliament cannot pass a law or make important decision like approval of the Honorable Kindiki without engaging in public participation. The cases are so many for me to cite them. The jurisprudence is so clear for it to be disputed. So that, my lord, the argument that we shall be putting on the issue of the nominations, on the face of it, unless this honorable court is able to say that at this stage, that public participation does not apply to the nomination and approval by Parliament, then, my lord, it is clear that this is the kind of case in which you are duty-bound to confirm the conservatory orders until this petition is heard and determined. Because the precondition would have to say, we have excluded this process from public participation. You would have to resolve the main issue, one of the main issues, at this stage before the petition has been heard. That would obviously be irregular. Now, none of us expect it to happen. I still wonder how the respondents would expect for them to get such kind of an order. I go to the second test, and this is the test of whether those orders will be rendered nugatory. My lords, again, I will not use the word no-brainer, but my lord, this is not a difficult argument to be able to resolve, and I believe I had a little bit say something about it. But my lord, the whole argument would be this, that if the whole argument, and that has been our case since we first came here last Tuesday, that we cannot, my lord, be able to have a situation in which the petitioners are saying the constitutions of Kenya has been systematically violated, and that all these obsessions with the application to set aside the conservatory orders that are in place are meant to complete the violations of the constitutions. My lord, under the constitutions, your first duty is to defend the constitution. That duty is particularly greater for the simple reason, is it called Meduse? The MP, Metuse, that one. When the mover of the motion had that duty, under the constitutions. President of Kenya had that duty when conducting, making appointment under 149. National Assembly had that duty, and the Senate. But my lord, you are saying in those 5 instances, the constitution has been violated. And because, my lord, the constitution has been violated by individual state officers who are under a duty to uphold the constitution, then the duty of this court to ensure that we do not turn this constitution into a mere platitudes, into a hollow documents, a false prospectus, is all the more greater. And it is for those reasons, my lord, that I would be saying that everything would become nugatory when they can be able to say, mission accomplished. They can go one day after the ruling. They can go to Uhuru Park or whichever other place for them to say, we are swearing Kindiki. That would be a mockery of justice. But there is a greater mockery of justice that I would want to point out. Because this thing, and to break it down for the people, every order in the normal litigations we do with every day, and you say somebody's rights are going to be violated. If somebody is saying I should not be hanged, I was not convicted properly by the High Court, if, my lord, that person is hanged before he has been heard by the Court of Appeal, clearly it would mean that the process of justice had not been completed, yet we have hanged the guy. My lord, in America, they keep on hanging people. Many of them terrible criminals, mass killers. But, my lord, you will observe that at the time when we see these televised killings in America, it is always after they have exhausted judicial process, so that they are sure that process that are irreversible take place after every legal benefit and protection has been accorded. One of those that is important, my lord, is captured under Article 27 of the Constitutions, the right to protection of law. So that the issue, as long as I'm in court, the matter is not yet over. It might well be possible that we might lose this application, the interim application that is before the court. But we might also win it, and we are likely to win it. So that because, my lord, of that issue, that a person may actually succeed at the other stage is the reason why you prevent taking irreversible decisions. And, my lord, what is the scenario that we are talking here? My lord, with the scenario here we are talking about here is simple. Immediately after assuming the orders were lifted, that's the scenario I want to describe. What is it that is going to happen? My lord, we would have a scenario where the Chief Justice, whilst these proceedings are pending before the court, would have to preside over the swearing in of Honorable Kindiki.
My lord, is it in order for my learned friend to keep speculating about the swearing in of Professor Kindiki?
The issue of swearing in is
also, and he's referred to it 3 times.
My lord, I believe that's the law. They have been saying they want to.
And my lord, whereas you allow,
then?
I was to ask my lord, what is the dispute before you? Is it the impeachment and whether it was lawful, or is it the nomination of the second interested party? Because
first of all, it's both, and I would want some protection for me to conclude, so that we are all fair. They will have their time to respond, and I will not interfere with it. My lord, so that the important scenario that we must seek to avoid is a situation, and this is matter, it is also a matter both of the Constitution and statute law. My lord, the issue is that if we get ourselves into a situation in which the Honorable, the Chief Justice, might have to preside over the swearing in of Honorable Kindiki while this petition is pending, my lord, that, to borrow the words of Honorable, my friend Muigai, Senior Counsel, would be the greatest absurdity that we can encounter. Why is it an absurdity? It's an absurdity, my lord, for the simple reason that one of the authorities that we have cited is the Assumption of Office Act, where, because of the experiences that this republic went through in the years 2007, 2008, specific laws had to be made to ensure that not only will this event be a public event, that's number one, but the more important issue from the standpoint of law is this, that before we get there, all legal disputes, contestations over the right to occupy that office would have been resolved. And my lord, that is the reason precisely why they say, after the Supreme Court has confirmed the validity of those two positions, then you do the swearing. My lord, it would amount to taking us back if that aspect, that rule of civilizations, were to be taken away on account of the setting aside of the conservatory orders that were issued, and for very good reasons, by your brother judges. I don't know whether there was a sister, by your brother judges. So that, my lord, the issue, as far as we are concerned, that is an absolutely important issue. We go to the next important issue, public interest. My lord, public interest has been defined in very many cases that are before you. And my lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing. Because we actually have a transformative, one of the best constitutions in the world, for the simple reason that we wanted to be a good example across the world as a leading constitutional democracy. And as a leading constitutional democracy, the issues of public interest is placed at the heart of our constitutional order. I go, my lord, to the definition. This is the only long passage that I will be reading. And this is, I gave the supplementary authorities earlier. This is in the famous case of Murungaro, Christopher Daradhi Murungaro versus Kenya Anti-Corruption. This I'm citing the passage appearing at page 7 to 8. My learned senior, Gethu Muigai, will be familiar with this decision. My lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it said as follows. Lastly, before we leave the matter, Professor Muigai told us that their strongest point on the motion before us is the public interest. We understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Muigai is this. We recognize and are all aware of the fact that the public has a legitimate interest in seeing that a crime of whatever nature is detected, prosecuted, and adequately punished. But in our view, the Constitution of the Republic is a reflection of the supreme public interest, and its provision must be upheld by the courts, sometimes even to the annoyance of the public. The only institution charged with the duty to interpret the Constitution of the Republic and to enforce those provisions is the High Court, and where it is permissible, with an appeal to the Court of Appeal. We have said before and we repeat it. The Kenyan nation has chosen the path of democracy. Our constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. A dictatorship, on the other hand, might be quite efficient and less messy. In a dictatorship, we could simply round up all those persons we suspect to be involved in corruptions and economic crimes and simply lock them up without much ado. That is not the path Kenya has taken. It has opted for the rule of law, and the rule of law implies due process. The courts must stick to that path, even if the public may, in any particular case, want a contrary thing, and even if those who are mighty and powerful might ignore the court's decisions. Occasionally, those who have been mighty and powerful are the ones who have run to seek the protections of the courts when the circumstances have changed. The courts must continue to give justice to all and sundry, irrespective of their status or former status. what orders should we make in the motion before us? So that, my Lord, I make 3 points with regard to what is public interest as understood by the Court of Appeal. Number 1 is that public interest means enforcement of the constitutions of Kenya. Secondly, my Lord, to make the point from what we have cited, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my Lord, it will be the submission that this reinforces the huge burden that this court must undertake. And, my Lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court, to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare ourselves with a dictatorship, that as a constitutional democracy, we can live with the decision. As my learned colleague Mr. Ngoya was saying, we cannot possibly live with a decision in which we would be seeing the Chief Justice, where, if that were to be the case, you would be seeing the Chief Justice swearing on Rapokindiki while we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my Lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a whole of victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the constitutions have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier. The desire of the makers of the Constitution was any person who will hold the office of Deputy President and therefore can potentially become President without an election ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political malice, is held by an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. My Lord, the 5th issue is to do this, that this court protects the constitutions. I've already talked something about it, so I don't have to go much into it. My Lord, there are only two decisions before I sit down that I would like to point myself to. There is the issues of Githunguri versus Attorney General. It is one of the cases that are before you. The facts in Githunguri are notorious. And they are also notorious for the simple reason that that decision, those old advocates who are there, Kina Paul Muite and Dr. Gibson Kamau Kuria tells us that it was largely, though it was a 3-judge bench, it was written in the style of Chief Justice Madan. My Lord, that issue said something that is important to me, the younger advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice is the simplest meaning in plain English. You need to ensure everybody has a fair and square deal. This is to say that at the end of the day, everybody will leave the court and says, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written. And that is why it is celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason. Whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them, it is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my Lord, it is for good reason. All of us celebrate Justice Madan because he strived to do justice. But my Lord, in the same case, the older lawyers also told us about Alan Hancock's, about Dugdale, and even about Chunga. They tell us all these stories. But my Lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock's. So that, my Lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before you, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite, before I hand over to my learned colleague, Professor Ogada, has he gone here? Oh, I thought whether he has disappeared. My Lord, before I hand over to my learned colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how you are going to...
Yes, sir. Yes, my Lord, we are budgeting.
With the remaining,
yes,
no more than 30 minutes.
Yes,
but
my Lord,
who wants
understanding...
submit on your side,
yes,
we'll
try to do our best.
You have no more than 30 minutes.
Thank you. We'll do our best. My Lord, for purposes of this case, is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that will be read by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarize themselves, as Macharia tried to do, with what other courts internationally have said. There is just like a small issue that I want to address myself to. My Lord, in 1928, in the case of Olmsted versus United States, one of the most celebrated justices of the U.S. Supreme Court, Justice Brandeis, says as follows. This is important. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. End of quote. I quote the words of Justice Brandeis in order to make the point that in the matters, the proceedings before this court, we have been treated to a scenario under which an impeachment process that if you read the constitutions clearly, is a process that ought to be a legislative one, a process conducted by the legislative organs of the Kenyan state has been converted into an all organs of government project. With the result, my lord, that if the petitioners turns out to be right, you would then find ourselves in a situation whereby, like in BBI, this process of impeachment of the deputy president may end up being indicted as being a process that ended up being a government project, contrary to what was clearly spelled out by our laws. And my lord, if it turns out that all laws were broken, and virtually out of the constitutions, I was counting them yesterday, it looks at 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken. Then we have a situations that Justice Brandeis had in mind when he talked about the government, which should be the lead in upholding the law, ends up being the principal breaker of the law, the principal violator of the constitutions. It is within your hands, your lordships and your lordships, to ensure that does not become our scenario. My lord, Masharia, my colleague, emphasized something, but I want to finish by adding something. My lord, in June 1982, when Kenya was legislated into saying that Kenya is a single-party state and KANU is the only legitimate organ, this was through a long process. Honorable Rengo, Honorable Mwite, Gibson Kamau Kuria have told me the intricacies of the day, what actually happened. My lord, the month of October 2024, we have experienced events that the senior citizens of Kenya likened to the events of June 1982, when everything in Kenya suddenly changed. Kenya ended up to being it was a restricted democracy, but all the guardrails were removed after June 1982. Your lordships, I urge you that if these petitions, if these proceedings end up in a manner that does not uphold our constitutions, then this constitution may face the same plight that the former constitution faced after the events of June 1982. We must hold and ensure the events of October 2024 remains regrettable and an aberration on Kenya's constitutional order, not the norm. My lord, I am thankful for the time. My learned colleague, Mr. Ogada.
Thank you. How many people are yet to speak?
For these applications, there are two. I was with Mr. Ogada and Mr. Ndegwa. They have heard you when you talked about 30 minutes. They will try to divide the time amongst themselves.
My lord.
My lord, I'm also...
Yes, my lord, I was saying that we are also interested parties in the application and we would require 15 minutes.
We will reach you. Your time has not come.
Your Lordship, the presiding judge, Your Lordship, Justice Mrima, Your Ladyship, Justice Mugambi, I will be brief. A famous quotation says that while the legislature is the will of the majority, the court must always remain the conscience of society. That is the spirit of the Constitution 2010, and that spirit has been reiterated time and again by this court. Mine is two tasks before this court today. I will be going through a panoramic vista of the authorities before this court, and finally, I will go through the political question doctrine, something that has quite excited the other side, and to debunk the myth that the political question doctrine in any way applies in the context of the Constitution 2010. We are dealing here with an application for the preservation of conservatory orders, and insofar as the application in petition E15 is concerned in terms of prayer D and E, extension of those conservatory orders to cover the entirety of the proceedings pending judgment and determination. My senior colleagues have gone through the essence and the reasons why conservatory orders ought to be granted. Mine is just to buttress this, that I will urge this court to look at the decision in David D and others. That was a 5-judge bench decision led by Professor Justice Joel Ngugi as he was then. And in paragraph 39 of their ruling, that is dated 26th February 2024, and in that decision, quoting a decision from the Supreme Court of Appeal in Nigeria, United Cement Company versus Dangote Industries, the court says that conservatory orders are prophylactic. They are intended to save the substratum of petitions. And as been ably demonstrated by my colleagues before me, we will sit at monumental oddity, the perfect storm in the teacup, when we allow certain processes to happen, including the swearing in of Professor Kithure Kindiki, who argued with me the BBI decision, that if his swearing in should go on, then these petitions will be rendered academic. That certainly should not be the legacy of this court. This court, in the context ably articulated by my learned senior, Mwalimu Elisha Ongoya. We have provided a couple of cases in our submissions to buttress what my learned senior, Mr. Kibe Mungai, has articulated in terms of the tests in Getirao Munya. We have the case of Kanyada Kinyanjui, the Norlak case. These have been attached to a list of authorities. They express, in terms of fine legal distillation, what will mean by an arguable case, and in terms of that infamous term that was bandied here before, the term nugatory, it has been judicially defined. You look at what the Court of Appeal in Kangede, Kinyanjui, and Norlake define nugatory to mean. In terms of public interest, we will invite these honorable courts to look at the case of Ethics and Anti-Corruption Commission versus Professor Tomojenda and associates and others, whereby the Supreme Court says that an additional limb to be examined is public interest. And we have labored in our submissions, Your Lordship, the presiding judge, to itemize 7 items of why the Constitution, as was articulated by my learned senior Ongoya, why the Constitution qualifies as the highest embodiment of public interest. We are here to argue for a conservatory order to issue as a prophylactic device to save the Constitution. That's our constant north. It should not be forgotten. Still on the question of public interest, my good friends representing the first petitioner have in their bundle of authorities 2 cases. The Court of Appeal decision in Matindi versus the Attorney General, 2023 EKLR, the CAS case, famously called. And then we have the Ojo case, Ojo versus Agriculture and Food Authority and 8 others, 2024. I am reliably told that that was argued by my good friend, Professor Tomojenda, my senator, Queen's College alumni. And in that case, this is what the court said, in a nutshell, that we need to keep out a nominee from public office so as to protect the Constitution, the integrity of the Constitution. Keep out that nominee. Let them not go into office. That is what we have been arguing. Ojo, Matindi, CS. Oh, I argued CS, by the way. Elisha Ngoya went through certain positions in law as contained in Justice Mrima's decision, Justice Mwongo's decision, your own decision. Those decisions are not idle. They are not mere words in English. They bear legal consequences by the virtue of the doctrine of judicial comity. That when a court declares itself on a position of law, and in the context of these particular petitions, we are dealing with collegiate decisions. Those decisions enjoy protection by virtue of the doctrine of judicial comity. Lord Justice Newberger, in an authority that we have supplied, the case of Willis and Joyce, 2016. This is the two 2018 appeal cases. We've provided that. Lord Newberger says this, that so far as the High Court is concerned, puisne judges are not technically bound by the decisions of their peers, but they should generally follow a decision of a court of coordinate jurisdiction unless there is a powerful reason for not doing so. That creates an honest presiding judge, Justice Mrima, Justice Mugambi, that the other side has to satisfy you that those courts, including yourself, made an error in making those determinations for you to depart from the same. Elisha Ngoya painted a beautiful picture of how odd that will be. We have also provided the case from the Supreme Court of the Parliamentary Service Commission versus Martin Nyaga Wambora. The court there examined decision-making and vacation of the same in the context of a collegiate court. The test has been given there by the Supreme Court. And what the Supreme Court says is that if this court might be tempted to reverse what has been made in terms of decision by a collegiate court, then the error has to be substantial. It has to be demonstrated. It does not simply amount to a question of mere allegation, huffing and puffing. It has to be shown demonstrably to the satisfaction of this court. I want to move quickly to the question of political question doctrine. My good friend, my brother, Mr. Gumbo, has spent a lot of ink, black and white, submitting on this. And he submitted to this court the authority of Baker versus Carr. To him and those on that side who submit in that line of thinking, we say this, that the political question is an American constitutional emanation. It is a function of separation of powers unique to the American constitutional context. That's number one. In the context of the Republic of Kenya, that doctrine has been morphed and understood to mean justiciability and non-justiciability. And in our context, it has been understood to yield to notions such as ripeness, mootness. And this was done by no other than His Eminent Grace, the Lord Justice Mrema, in the case of Anthony Miano and others, was the Attorney General, 2020 EKLR. Thirdly, the political question focuses on limitation by courts, on the court restraining itself from dealing with matters within the responsibility of the political arms of government. Now, in terms of the US context, And I have said that Mr. Gumbo has submitted on this case, and we wish to respond to him. This is what they did not tell you in terms of Baker versus Carr. Baker versus Carr 1962 lays down 6 factors that can be used in identifying what a political question is. So the political question within the American context is not a general rule of application. It is applicable, yes, but within certain parameters. And the context in which that political doctrine question principle can be used is where, number one, there is lack of a judicially discoverable and manageable standards for resolving the dispute. In other words, the judiciary does not have the wherewithal to deal with that question. Number two, the impossibility of deciding the dispute without being to the detriment of a political policy determination that has been made. Number three, the impossibility of the court undertaking such independent resolution without expressing a lack of respect to the branches of government, the political branches. Number four, the unusual need for unquestioning adherence to a political decision already made. Number five, the potential embarrassment from multifarious pronouncements by various departments on the same question. And sixth, a textually demonstrable commitment to the issue of a coordinate political department. Those are the 6 circumstances according to Baker versus Carr. So the question, Your Lordship, Presiding Judge, what will be the usefulness of this doctrine in Kenya? The Constitution of the Republic of Kenya, David D. and others, the Constitution of Kenya has an internal theory. As Elisha Ngoya articulated, and as was articulated in BBI, the Constitution is a transformative Constitution, such that our tenor, our tone in terms of Constitution is radically different from the American. From the text of our Constitution, this is what the Court of Appeal in the BBI decision said at paragraph 139 and at paragraph 144. At paragraph 139, the Court of Appeal said that the Superior Court, being this court, by virtue of Article 22(1), 23(1), and 258(1) of the Constitution, had jurisdiction to complete and incomplete breaches of the Constitution. Your Ladyship, Your Lordships, the substratum in the BBI case was a bill that was stopped in its track before signature. That is important in terms of this context. At paragraph 144, this is what the Court of Appeal says, that when matters involve a threat to breach constitutional rights, justiciability requirements are satisfied and hence the court is allotted with jurisdiction. The court is seized with jurisdiction when a breach of the Constitution happens. From the constitutional text, plain reading, Article 4(1) read with Article 4(2) together with Article 1 provide an interface between law and politics. I repeat, 4(1), 4(2) as read with Article 1 provide an interface between law and politics. The requisite of power ultima, sovereignty in the people, and the requirement by the Constitution that government and governance must be in accordance with the Constitution, Article 2(1), our supremacy clause, ensures that politics are subordinated to the rule of law and constitutionalism. Article 3, the preservation clause. Everybody is enjoined to defend the Constitution. And that provision has normative significance in establishing a legal and moral commitment to uphold and protect, defend the Constitution. Article 232, an attempt to establish government, including appointments otherwise than in conformity with the Constitution is unlawful and unconstitutional. Article 2, Sub-Article 2, no person may claim or exercise state authority except as provided under the Constitution. In conclusion, your lordships, your ladyship, in an old story, and it's probably even true, when the authors of the American Constitution declared after months of work in Philadelphia that they had finally reached consensus, a lady by the name Mrs. Powell shouted a question to the revered Benjamin Franklin, an American statesman, who was then 81 years old. And this is what Mrs. Powell told Benjamin Franklin. Dr. Franklin, what have you given to us? A monarchy or a republic? And this is what your lordship, your ladyship, Dr. Franklin answered the lady. A republic, if you can keep it. The judiciary must stand as the unyielding guardian of the Constitution, the protector of the republic, for when it falls, the pillars of justice and democracy begin to crumble. I submit. Thank you.
Thank you. You, Bananjeru.
Yes, my lady, my lords.
How are you?
I'm well, my lords.
You have 10 minutes.
My lord, I'll try to do the best within the time allocated.
All right.
My lord, my lady, my lords, permit me to join issues with the earlier submissions made by my learned friends, and permit me, my ladies, my lords, to submit that my submissions will majorly deal.
Can you join issues on the same side? Join issues? We haven't submitted.
What problem do you have with that, Professor Gender?
My lord, join issues means he's on the opposing side, but he's supporting the applications as framed. So I don't know whether it is simply a question of not knowing that we haven't spoken, perhaps. He's running low on sugar.
My lord, the presiding judge, you made an important point that we are Africans.
I think let Njiru proceed.
And he will have his time to speak the right English when his time comes. My ladies, my lords, my submissions will deal with the aspects of public interest in respect to the reason why the court must sustain the conservatory orders as granted by his Justice Mongo and Justice Mwita. Your Lordship, permit me to begin by drawing your attention to the dictates of Article 3, which requires every person to uphold and protect the Constitution from being violated. My lady, my lords, the Constitution that we are here to protect this afternoon is a document that is progressive in nature and that seeks to protect individuals who either serves in government or out government in whatsoever organ. My lords, in my address, I'll majorly deal with the question of the purported nomination of Professor Kithure Kindiki and whether the lifting of the conservatory orders will culminate into his swearing in and what that means in respect to the provisions of the Constitution. My ladies, my lord, it is clear that a purported process took place in Parliament that culminated into a name being forwarded to Parliament for voting. My ladies, my lords, it is important for us to interrogate the circumstances that led to the forwarding of this name, and whether or not that process is confirmed with the dictates of the Constitution. My ladies, my lords, on the 18th of October, we walked to what my learned friend Mr. Ongoya submitted on a memorandum by the President. The said memorandum, my ladies, my lords, indicates that the President sought approval and confirmation from the Independent Electoral and Boundary Commission. And the answer that he got was sufficient enough to afford him the courage to forward the name for voting in Parliament. But the question, my ladies, my lords, that begs an answer is, did the IBC possess the requisite constitutional capacity to submit or approve the said name for purposes of voting in Parliament? My ladies, my lords, the answer to that will be found in Article 88, as read together with Article 99 and Article 137 of the Constitution. Article 88, my ladies, my lords, creates the Electoral and Boundary Commission. And in the same article, my ladies, my lords, creates the functions of the said commission. You'll also find the same answer, my ladies, my lords, in the amended IBC Act. Most importantly, Section 10 and Section 11, which I'll be dealing with in the near future. My ladies, my lords, Article 99, as read together with Article 137, provides the qualifications for an individual to hold the office of the President, and by extension, the office of the Deputy President. It is important to note, my ladies, my lords, that in the event anything happens and the current President is incapable of executing the functions of an office of the President, the purported name, if sworn in, will be the person to take over. But will he have met the necessary requisite qualifications? And who is mandated to ensure that these qualifications are met? We submit, my ladies, my lords, that the only constitutional organ capable of executing that functions is the Independent Electoral and Boundary Commission. The court will take judicial notice, my ladies, my lord, that the commission as currently constituted falls lack of the commissioners. And the question therefore, my ladies, my lords, in the event the commission is called upon to evaluate the qualifications under Article 99 and Article 139, so that then, my ladies, my lords, a name can be submitted in Parliament for voting, who then is capable of doing that in the absence of the commissioners? My ladies, my lords, we submit that IBC as currently constituted can only execute administrative functions, and it has no capacity or ability to execute the function under Article 99 as read together with Article 137 of the Constitution. My ladies, my lords, the Constitution as read together with the IBC Act has created distinct functions, that for the commissioners and the secretariat. And you'll find that, my ladies, my lords, in the decision, consolidated petition number paragraph 347, this is what the court had to say. From the foregoing provisions, it is clear to us beyond peradventure that the membership of the Constitutional Commission is between 3 and 9 members. In other words, the composition of the Constitutional Commission ought not to be less than 3 and not more than 9. The court goes on to say that if the secretariat, and in this case the CEO to the IBC, would then be seen to execute the functions of the commission, it would then mean that the commissions would go beyond the constitutional dictated number of either 3 or 9. The court said that paragraph 348, the said members, otherwise known as the commissioners, are empowered to appoint the commission's chief executive, known as the secretary. To contend that the secretary, who is an appointee of the commission, is part of the commission, would mean that the commission would, where commissioners are 9, be composed of membership of 10. The court said one only needs to mention this to realize how ridiculous this argument is. It is therefore our submissions, my ladies, my lords, that the name that was submitted to Parliament is not capable of replacing, in the event this court dismisses our petition and upholds the impeachment, the Deputy President of the Republic of Kenya. The court further said at paragraph 353, I refer the court to have a look at paragraph 353 and paragraph 354. But of the most importance is what the court said relied in the case of petition number 46 of 201. The court relied in a Ugandan case, and this is what the court said. It is clear to us that under the Constitution and under the legislations, the foundation of the power of a secretariat is the existence of the commission. A secretary and the secretariat can only carry out the powers vested in their offices when the commission is in place, exercising its powers since they implement what the commission has approved or resolved. Again, I urge the court to look at paragraph 356 and also 358. But most importantly, my ladies, my lord, is what the court is saying at paragraph 362. This is what the court had to say. We therefore also agree with the petitioners that any decisions purportedly transmitted to the DPP recommending the prosecution of the petitioners without the sanction of the commission would not be in compliance with the law and the Constitution. We urge you, my ladies, my lords, to find that the name that was submitted in Parliament is not capable of replacing the Deputy President of the Republic of Kenya. Why is that important, my ladies, my lords? Because if the orders are lifted today, that will be the next course of action.
My lord, that's not a finding you can make in your ruling on an interlocutory application.
Why, my ladies, my lords? Because this is a train with many compartments and many stopovers. The next stopover that we shall land on, my ladies, my lords, if the orders are lifted, is to have a person who was not duly appointed in accordance with the Constitution taking over the office of the Deputy President. My ladies, my lords, permit me to draw your attention to paragraph 365, 336, and 337 of the same judgment. And this will be my final submissions in respect to this judgment. At paragraph 367, the court is saying, whereas a commission may be disabled in its ability to perform its functions, such disability does not automatically render the commission extinct. Such an event, in our view, only places the commission in a state of dormancy until such a time as it is able to carry out its functions. My ladies, my lords, I have perused the replying affidavit filed by Marjan on behalf of the IBC. He makes no reference to the memorandum filed by the President. My ladies, my lords, he technically makes sure that he does not make reference to that so that he may not be seen as if he has devolved into the functions of another organ. My ladies, my lords, permit me to draw your attentions to section 6 of the appointment point. I beg your pardon. Paragraph 6 of public appointment parliamentary approvals. And as you look at paragraph 6, also look at the definitions contained at paragraph 2 of the same act. What an appointment means and what a candidate means. And for avoidance of doubt, a candidate means a person who has been proposed or nominated for appointment to a public office. Section 6 creates the criteria upon which Parliament must follow so as to satisfy the need for public participation. It also creates the time within which this must be executed. It has been submitted that this was executed in a supersonic speed, that took approximately 6 hours, and the Republic of Kenya had a new deputy president proposed. But the question, my ladies, my lords, is, can this be done in the absence of the exercise of the sovereignty of the people of Kenya? If we were to allow this, my ladies, my lords, what will be the import and what will be left of Article 1 of the Constitution? Will it be to mean that Article 1 of power belonging to the people will be meaningless? Additionally, my ladies, my lords, what will be left of Article 10 of the Constitution that requires state organs to be bound by the provisions of Article 10 whenever any of them executes the functions bestowed by it by the law? My ladies, my lords, the question of public participation, even in the process of the nomination of the said candidate, is paramount. That under Article 118, Parliament is enjoined, together with Article 10, to carry out public participation. And that is the only way, my ladies, my lords, that Parliament can be said to have exercised the sovereignty of the people of Kenya through the delegated democracy concept. That is to mean, my ladies, my lords, if we were to sanction whatever happened on the 18th and allow it to pass, and the conservatory orders are lifted and is sworn in, we'll have let the people of Kenya down. They will not enjoy the provisions bestowed upon them by Article 10, Article 1, and Article 118. Article 118 creates and dictates that these individuals cannot be left out. Finally, my ladies, my lords, let us look at the question whether we have made out a case that deserves the granting of conservatory orders, and one that also deserves the dismissal of the applications by the respondent. My ladies, my lords, the National Assembly handsets have been brought before you, and I will draw your attention to page 45 of the said handsets. And most importantly is the submissions that were made by Honorable Millie Othiambo, the Member of Parliament of Suba North. At page 48, she makes observation that public participation had only two...
Do you have the Hansard as part of the affidavit?
Yeah, they have been filed.
They have been filed?
Yes, yes, my lady.
Where do we find them?
Is it part of the application?
It's part of the petition, my lords. That is 522, the Hansons.
Part of the application or part of the petition?
Petition.
Yes, then that's that. I mean, that is something different. We are dealing with the application.
But most importantly, my ladies, my lords, it went on Hansons that only 200,000 people purportedly participated in that process. That is to mean, my ladies, my lords, for Honorable Mutuse to have the guts and the audacity to move the motion, he had the backing of 200,000 people as against a population of 50 million Kenyans, or as against the population of over 14 million registered voters. What begs question for determination, was that a qualitative and a quantitative public participation? Was it meritocracy? Does it deserve or could it convince that public participation that was adequate was conducted before the motion was moved? My ladies, my lords, to afford us an opportunity to bring this case out, we beseech you, my ladies, my lords, that you sustain and allow the conservatory orders sought and dismiss the application by the respondents. Finally, my ladies, my lords, I invite you to look at the submissions filed by the Attorney General in support of the application. Of most importance, my ladies, my lords, the Attorney General at page 6 of her submissions invites you to look at a conservatory order, sorry, not page 6, my ladies. That is page page 5, as one that is meant to maintain the status quo. And she tells you, my ladies, my lords, that the status quo to be preserved is a status quo ante. That is to mean that the status quo that the court needs to preserve is the approval and the voting of Mr. Kindiki. That is, according to her, the status quo that she needs to be preserved. And she makes out a case that the conservatory order needs to be set aside so that that status quo can be sustained. There can never be anything that is far from the truth, my ladies, my lords. The orders of Justice Mwongo stayed each and every aspect that took place, including the implementation of the resolution by Parliament to consider the first petitioner as impeached. She further tells you in her submissions that conservatory orders are only capable of being granted under Article 23 of the Constitution. And she argues that Article 23 only relates to the Bill of Rights. And then she further argues that if the petition is not premised on violation or infringement or denial of a human right, then conservatory orders, according to her, are not capable of being granted by the court. But my ladies, my lords, we have put up a case that a right to a fair hearing was denied. We have put up a case that the Senate of the Republic of Kenya decided to abrogate Article 25 of the Constitution. If that is not a question that relates to a Bill of Rights, what then does it relate to? Further to that, my ladies, my lords, under Article 258 of the Constitution, to which we are saying that the Constitution has been abrogated and violated by the respondents, what remedy can the court issue in the circumstances that a case is brought out that the Constitution has been abrogated and violated by the respondents, if it's not a conservatory order? My ladies, my lords, finally, as I pen off, I invite you to look at the principles of public interest. It is in the public interest, my ladies, my lords, that these orders be sustained so that the Republic of Kenya can have the opportunity of the court pronouncing itself whether their democratically elected deputy president was justifiably removed and lawfully removed from office. That is to mean, your ladies, my lords, that under Article 38 of the Constitution, the people who supported the deputy president have a legitimate expectation. A legitimate expectation that their deputy president, as elected, will be subjected to a proper and accountable and transparent mechanism of removal. They also have a legitimate expectation that if any organ constituted by the Constitution does fail to abide by the dictates of the Constitution, that this court will uphold that position and that this court will set aside the impeachment. And the consequences of that, my ladies, my lords, is that if this court is convinced by our argument to set aside the impeachment, the question will then be that the deputy president will assume office. Number two, my ladies, my lords, you'll be urged to set aside the conservatory orders on the basis that there is constitutional crisis that is looming. But who has precipitated and created this constitutional crisis, if it does exist, if not the respondents? If they followed the law to the letter, and we feel satisfied that our client was justifiably removed from office, we would not be before you, my ladies, my lords. We would have taken an ample pie and go home. But we are here before you, my ladies, my lords, because a situation has been precipitated and created by the respondents. Finally, my ladies, my lords, if the respondents are the ones who are at fault, do they deserve your mercy? What is the position of equity if they come to you with dirty hands? Do they deserve your mercy? He who comes to equity must come with clean hands. They are the transgressors and the violators of the Constitution. And therefore, my ladies, my lords, they cannot come before you as though they are saints. I so urge you, my ladies, my lords, to dismiss that application and uphold the application for the maintenance or for the retaining of the conservatory orders. I am most humbled.
Thank you. You have 4.
My Lord, I appear for the 9th petitioner.
You will have 5 minutes.
My Lord, presiding judge, my Lord and my ladies, if it pleases you and in keeping with the notices affixed to the walls of this wall, permit me to reintroduce myself. My name is Wamboi, Shadrach Wamboi. I appear for the 9th petitioner. My Lord, for the purpose of the court record, we equally have a pending application dated the 18th day of October, 2024. And to assist the Honorable Court, we have filed submissions dated the 29th day of October, 2024, and a list of authority dated the even date, the 29th day of October, 2024. My Lord, we rise in support of the application as urged by my colleagues and my seniors to confirm the conservatory orders that have since been issued, and in any event to allow our request to have a suspension of the decision arrived at by the Senate on the 17th day of October 2024. My Lord, we take a very simple approach on the complex matters that lie before you for determination, and the manner in which we look at whether the court should grant or disallow the requests that are prayed is that this honorable court is invited by the Constitution to be imaginative. The grant of orders of conservatory orders require that the court goes over and above probably the circumstances that are drawn that have necessitated the filing of a petition before court, so that the court can either, in the words of Article 22, arrest a threat to the violation of a right or a fundamental freedom. My lords and my lady, a doctor, for you to imagine the circumstances that would be if the orders are not confirmed by this honorable court, then, my lords and my lady, you must, and I say this with tremendous respect, reflect on the assumption of the Office of the President Act in order for this honorable court to be alive to the prejudices or the prejudice that the petitioner and the Honorable Deputy President Rigathi Gachagua will face if the orders sought are not confirmed. My lords and my lady, we make the submission that to disallow our application will lead to a wastage of public resources, which this court is joined under Article 201D. My Lord, this court is empowered or given the obligation under Article 201D of the Constitution to ensure the prudent and responsible way of the use of public resources. So that, my lady and my lords, the denial of the reliefs that we seek will automatically prompt the swearing in of the person of Professor Kithure Kindiki to assume the office of the Deputy President Rigathi Gachagua. My lady and my lords, pursuant to Section 12 of the assumption of the office of the President, this must be done first within the capital city of the Republic of Kenya, which is in Nairobi. And secondly, on that date when we are supposed to have the swearing in of the Deputy President, must be a public holiday. My lady and my lords, while being treated to a public holiday might not seem to be a bad thing, as it will give the court and councils an opportunity to rest, it's a bad thing for one that, firstly, Kenyans who live from hand to mouth will have to take a rest. Secondly, at a time when this honorable court is expected to be doing its business, this honorable court will be forced, my lord, to retire and perhaps to add on to the backlog of cases that we face in the Republic of Kenya. So that, my ladies, my lords, as I conclude my very humble submissions, so that I can pave the floor to my senior, is, my lords, you have an opportunity of arresting a situation that will lead to the use of public resources in a public ceremony that may, in the fullness of time, end up be declared as unconstitutional for the very grounds that we will be persuading you when we come to making arguments in support of the petition that lies before court. My lords, that should be all from me. I will pave the floor to my colleague Wanjiku.
Thank you.
Thank you for the 9th petitioner. Thank you.
My lord, may I just for housekeeping, my lord. My lord, is it possible that at least the court is told who appears for who? Because we may have, I do not know how many advocates are supporting. We may sit here to the end of time because each person is taking 5 minutes, and my concern is that the advocates who are appearing for the same client taking 5 minutes each, and then we do not know what we are dealing with, my lord.
You appear for which party?
For the 9th respondent, for the 9th petitioner, my lord and my lady.
The same person?
Yes.
You had 5 minutes to share between the two of you. Mr. Wanjiku, Wamboi has taken more than that.
Sorry. I don't know, should I go? Because I'm for the 2nd petitioner.
Yes.
My name is Kimoto Teresia Wanjiru Makazi, Tess Kimoto and Company Advocates from Kerugoya. And on behalf of the 2nd petitioner, we wish to say that we support the application for conservatory order to remain in force. And the reason why we are saying so is that if you look at our petition, the prayers that we are seeking...
Sorry, my lord, with your permission, my lord, with your permission, I'm sorry, because Ms. Kimodo was submitting, and it was our understanding that for the 9th petitioner, because she is not representing the 9th petitioner, it was our understanding that the minutes that were allocated to us, initially, Mr. Shadrach Wamboi has taken, and we were to compress the same so that all parties appearing, because we are 4 of us, were to iron out those issues and submit, because it's only submitted on one point. So that before she submits, we're requesting kindly for accommodation so that we can air 1 or 2 issues that were left out by Shadrach. Because I was to do a minute, and Mr. Omari was to do another minute as we conclude for the 9th petitioner. We are sorry about that, so that when she takes up, she'll take it up from a standpoint of...
Does it also not bother you that most of the points or the principles you are putting forth have already been put forth even more eloquently and recorded?
My lord, that much we agree, but 2 issues that were left out, that is why we wanted to seek for your permission so that we can air all those that...
I think we still believe in the old doctrine that a council can stand up and say that I adopt wholly the submissions of a counsel who has gone before them, because I think these arguments have been put very eloquently, and we have recorded them.
Very well, if those be the directions, my lord.
But I'll give you 2 minutes.
2 minutes.
After Ms. Kimoto has finished.
We are most obliged. We share 1 minute each with Mr. Mari. Thank you.
Yes, sir.
People are yet to come, including the respondents. I hope you take note of that. There's no need for a petition, absolutely none.
Yes, sir. The reason why we are in support of the conservatory orders remaining in force is that when Richard Mwongo was issuing these orders before Kirugoya Law Court, he had in mind petition E013 and petition E014. So he knew very well what he was doing, because we appeared before him several times and we tried to stop the impeachment proceedings. However, it was not possible, and he consolidated the files. Therefore, if you look at our petition E013, what we are asking for is an apology by the Deputy President of Kenya, Honorable Rigathi Gachagua. So if these conservatory orders are lifted, what are we going to do? Are we not engaging in an academic exercise where our petition has been consolidated, but we are not being given a right to fair hearing, so that the court can understand why we need this apology? And this petition was filed first. It was filed on the 25th September, before the impeachment and after the impeachment. So we are praying that we be given a right to fair hearing. We be heard first. We have nothing against Professor Kindiki. However, once he assumes office, he will now become a deputy president, and therefore we do not need an apology from Kindiki. We need an apology from Rigathi Gachagua. And we need an apology from him when he's at his official residence. No. They will have, no, allow me to.
My lord, may I just interfere? The petition by Kimoto and company required the deputy president, then, now impeached, to apologize to the National Intelligence Service, NIS, completely overtaken by events. I don't even know why she's here.
No. That is uncalled for, and I hope the bench will protect me.
I think Ms. Kimoto is rightly before the court.
Yes, thank you. Thank you, Judge, for protecting me, because I almost quoted the paragraph 110 of the disposition of this court, where you assured us that we are going to have a fair hearing. So therefore, thank you, Justice Charo. So what I'm saying is that, yes, so what I am saying is that we need an apology from the Honorable Rigathi Gachagua, him being the Deputy President of Kenya. So what we are saying is that we want him, at least we are going to support even the issues of how he was impeached, so that we can get to the bottom of this. And we still have a chance, because he has not left office. And if he has not left office, then we have a chance to be heard in our petition, E013. So allow us to be heard, so that after we are heard, the court can decide if our petition has merit or not. And that's why we are in support of this. And we do not want a kienyeji apology. Our apology is very clear from our pleadings, because these utterances he made when he was in office, and they carried weight. Why we are insisting is that the NIS team, and especially my client who is affiliated to the NIS, he was affected. In fact, where he stays in Kirinyaga, he cannot stay anymore because of those utterances. No, these issues are in our petition. The respondents have not responded. In fact, our petition is unopposed. So therefore, we are insisting, if at the interim stage, the conservatory orders are lifted, what it means is that we will not have a chance to get what we are praying for in the final stage. So it will be in our view, we will have been overtaken by events at that particular moment. Therefore, when we remove this conservatory order, it only means that we'll have a final order in the interim, because now there will be a new deputy president, and we sued Honorable Rigathi Gachagua when he was the sitting deputy president, as a deputy president, not as the Honorable Rigathi Gachagua. So we are praying that the court do look at this. There was also an issue of public participation. Once we were consolidated, those are the issues that are also in petition E014, on how the public participation was conducted, which we, of course, we support. It was hurriedly done. So we did not even have a chance, or many people and many Kenyans did not have a chance to give their views. So again, just 1 minute. Again, this is what we are saying. It will now go to an academic exercise where we just appear before the court and expect just to be told you have no right anymore, and you're overtaken by events, just like some councils were trying to say. That's all. Thank you.
Thank you. Your Lordship, for the third petitioner.
Sorry, my Lord, I was to take cue. My name is Sam Nyaberi. You gave indications and directions earlier that we take 2 minutes. I wish to call upon Waithera, who was on her feet before, so that I donate my time to her in the spirit of nurturing young talent, and so that she can also raise a fee note to be paid.
Ms. Waithera, how are you?
I'm fine, thank you, my lord.
You have been donated time, so take it and make your submissions.
Thank you, my senior Mr. Nyaberi. My name is Wanjiko Waithera, for the 9th petitioner. And taking off from where my senior Mr. Wambui left off, I wish to submit on the issue that the respondents raised in their responses, that is separation of powers, in which they are seeking to have the applications dismissed on account that Parliament has the respondents, that is the Senate and the National Assembly, have privileges to conduct their proceedings, and such proceedings must not be challenged in court. And I wish for this court to be guided by the decision of Justice Lenaola in the Commission for Implementation of the Constitution versus the National Assembly of Kenya and 2 others, 2013 EKIR. And I will quote part of the passage where the court said that, to my mind, the separation of powers is not an absolute, to my mind, the separation of power principle contained in the Constitution is not absolute, and the courts, as defenders and protectors of the Constitution, have to be allowed to interfere where there is a violation or threat of violation of the Constitution. The court further went on to say that the primary duty of the court is to the Constitution and to the law, and which must apply impartially and without fear or favor or prejudice. The Constitution requires that the state to respect, protect, and promote and fulfill the Bill of Rights. My lords and my ladies, what is challenged before you are the proceedings that were undertaken at the Senate, and amongst what we are challenging is the right to be heard that was denied to the first petitioner, which forms a cornerstone under Article 47 of the Constitution. And therefore, my lords and my lady, this court stands at crossroads of history with a rare opportunity not to merely interpret the law, but to define it in a way that will, echo through generations. The decisions of these proceedings have the potential to set a benchmark that will solidify principles of accountability and strengthen our democratic foundation. We therefore invite the court to allow our application and issue the conservatory orders as prayed, and in so doing, we will be cementing the constitutional principles of this country. Thank you.
Thank you.
My Lord, having had that, we organized Ms. Omari will do a wrap for 30 seconds or 1 minute.
I hope you meant 30 seconds.
My Lord, I didn't want to talk, save that to bring to the attention of the court that the public participation was done on Saturday, which is contrary to Article 37. Number two, the public participation was supposed to be done at the polling station level. Deputy presidents and presidents tallying ends at the polling station. Third, the notice of the constituency public participation. The court gave the orders at around 4:30. There was no notice sufficient for people in the villages to go to the constituencies. Therefore, that completely made people not to participate because they were not aware. The notice that was initially given was a notice at the constituency levels. Can that be the position that this court will uphold? I beg that the court extends the grant of the Conservatory orders. Thank you very much, my Lord, my Lords and my Lord.
Thank you.
Your Lordship and my lady, my name is Sakimpa. For the third petitioner, we'll be sharing time with my colleague, Mr. Wathuta. Your Lordship, you've already stated that the principles of conservatory orders have been eloquently espoused by my learned seniors, so I'll only put into context in our petition. Your Lordship, in the case of Peter Munya, the issue of inherent case is what I want to address using the ruling that was delivered by Justice Richard Mongo in petition E014. Your Lordship, and this is what the learned judge found upon perusing the documents, that on my motion I had perused the file and considered that the matters being considered on impeachment of the Deputy President of the Republic of Kenya are novel. That is the first issue. The other issue by the judge was that there exists no statutory or subsidiary legislative framework for impeachment of the Deputy President. The learned judge also said that there exists no statutory framework for public hearings and public participation in respect of impeachment of a Deputy President under Article 145. The learned judge also identified another issue, that there have been several bills on public participation and also on the question of impeachment in Parliament, but such bills have never been passed. And then finally, the judge says that the law on these questions has not been settled. It is our submission, therefore, Your Lordship, that based on these issues that have been framed by the judge, this is a proper case for issuance of conservatory orders so as to preserve the substratum of the petitions. Your Lordship, the last issue I want to address is the issue of public participation. Mr. Omari has pointed out the issues which we have in our petitions, and also finally the issue of the Senate. Your Lordship, in our petition, we have questioned the legality of the Senate having taken the position that it was open for them to use the plenary route as opposed to the committee. On that basis, therefore, Your Lordship, these are serious issues that warrants issuance of a conservatory order. Your Lordship, my colleague will conclude. I thank you.
Thank you. Yeah, thank you. Thank you very much. Very briefly, my Lord. I'll just be making some remarks on the two applications for setting aside of the conservatory orders, starting with petition number 565. And looking at the prayers that are sought in that application, my Lord, that application is moot. I say so because the substantive prayer, prayer number 2, was that pending the inter partes hearing of this application for setting aside, that the orders issued by Justice Chacha Mwita be varied or set aside. My Lord, we already passed that stage, and therefore that prayer is not available. Then prayer number 3, that in the alternative, This Honorable Court be pleased to set aside, vary or discharge the ex parte orders issued on 18th October 2024. My Lord, those orders lapsed on Friday, that is the 25th of October 2024. So just to make the court's work easy, there will be no need to consider that application. Having said that, and in view of your previous directions, that this application will be treated as a response to the application for conservatory orders, I would just like to make 2 or 3 remarks with regard to the content of that application, my Lord. And I would just like to mention that paragraph 7 of the supporting affidavit sworn by the Solicitor General. Actually, it is in the ground, but then it is reflected in it is in ground number 7, my Lord. It says, Article 1 of the Constitution provides that the sovereign power belongs to the people, and that where there is a conflict between public interest and private interests, the scales of justice to tilt in favor of the public interest. To that, my remark is, the question that is before you is not about a private right. It is a more elevated constitutional question of impeachment of a president or a deputy president. Again, paragraph 8 states that the Constitution does not envisage a vacuum in the office of the Deputy President, and as such, it is in the interest of justice that interim orders be stayed, varied, or set aside. My Lord, Article 149 and Article 150 make very clear provisions on the vacancy of the office of the Deputy President and how that is treated, even about the vacancy in the office of the President and how all that is dealt with. The Constitution is self-sufficient with regard to vacancy in the executive offices. Just 1 minute. I would like to make a remark, still to make the court work easy, in a petition number 15. And my Lord, again, that application is moot. I had to check the one that is on CTS just to be double sure. And the substantive prayers that are sought are prayer number 3. It was an interim order pending inter partes hearing of that application. My Lord, again, we are beyond that stage. We are already at the inter partes stage of the hearing. So the remaining prayer is prayer number 4. And allow me to read it verbatim. That this court be pleased to set aside, review or otherwise vary grant the ex parte orders issued on 18th October 2024 by Honorable Justice Mwongo Richard Mururu in Kerugoya Constitutional Petition number 15, pending the hearing and determination of the appeal. My Lord, what the National Assembly clearly did not disclose is that after these orders were served on them, they went and filed an appeal. And then filed this application to stay the conservatory order or set it aside pending the determination of the appeal. That has not been disclosed to the parties. It has not been disclosed to the court. So you have no prayer for setting aside of the conservatory order pending the hearing of the petition or pending the hearing of the application for conservatory orders. So again, that application is moot. Turning to the content of that application, in as far as it is a response to the application for conservatory order, firstly, the decision or the subject of the petition before that court was the proceedings before the Senate. Then again, the National Assembly was not necessarily the aggrieved party, but again, they cried louder than the bereaved. Again, if you look at paragraph 6 of the supporting affidavit, sworn by paragraph 6. The applicant is aggrieved by the order of 18th October 2024 and seeks for the order to be temporarily set aside. Not entirely, my lord. Temporarily set it aside, pending the hearing of the appeal. My lord, that is not an appropriate ground, because no appeal has been placed before you. At paragraph 7, which is a serious misconception. Yes, my lord.
You had very few minutes. I think you have exhausted them.
Judge, I beg only two. Only two, Judge. Thank you. At paragraph 7, you realize another basis of making this application, which is a very serious misconception. And it says, a presidential system of government works based on the doctrine of collective responsibility. This is a constitutional democracy that we have. The doctrine requires members of the cabinet to work in unison for the sovereign and promote the collective policy agenda. In pure presidential systems, which is not ours, the president retains the discretion to dismiss a member of cabinet who falls short of the expectation. My lord, one of the reasons why we have the current constitution is to prevent this very mischief. So, we can clearly now see the underwriter of all this impeachment process. It is the president who decided a member of the cabinet should not be here. So, this is a process that is...
Objection, that is evidence from the bar.
I'm just picking a paragraph in the supporting affidavit.
Mr. Watuta.
Yes, yes.
Please conclude your remarks.
Very well. Thank you. Yeah, and even more worrying is paragraph 8. Additionally, reinstatement is inconceivable where the member of the cabinet has lost confidence of the sovereign and parliament. My lord, Article 150 sets the ground for impeachment of a deputy president. Lack of confidence is not one of them. Lack of confidence by parliament in the deputy president is not one of the grounds. So we can clearly see the reason why we have the impeachment process. Who is the sovereign? The people. When did the people say we have lost confidence in the deputy president? So all these other grounds, as we will demonstrate at the hearing of the petition, is just a facade, it's just a face to hide the real intention of members of parliament saying we have lost confidence in this particular person. I do not want to go to paragraph 9, but again, those are matters that we'll deal with at the petition stage. But all in all, my lord, you only have two applications to consider, the ones for conservatory orders. The one for setting aside the conservatory orders, my lord, I've made your work easier. Most obliged. Thank you very much.
Thank you.
May it please the court. My name is Dr. Eboso. I'm from Vihiga, and I'd like to...
Dr. Eboso, you'll address us for only 5 minutes, please.
My lord, I will do my best, but I promise I will not repeat anything that has been said. My Lord, I'll go straight to the points. One, what is on trial or what is at stake in the setup of an interim conservatory order? My Lord, I'd like to inform the court that what is on trial is a Bill of Rights. Article 38 of the Constitution provides that a person has a right to vie and be elected for office, and if elected, has a right to hold that office. My Lord, that is one of the things that is on trial, but I will ignore that for now. What is at stake, because a conservatory order is supposed to preserve the substratum, is a right to a fair trial. My Lord, the components of a fair trial include the tribunal that is independent. It includes the process and the outcome. My Lord, the outcome includes the remedies that are available by law to the individuals before the court. One of the remedies, the material remedies that the parties before this court are seeking, is reinstatement of Deputy President RIGATHI Gachagua to office. Therefore, and I will demonstrate when I talk about the Wajir case at the end, that once a new person assumes that office, that remedy is completely taken off the table. And that means these conservatory orders are actually at the heart of a fair trial. And a fair trial is among the rights under our constitutions that cannot be limited. It is not that a fair trial is absolutely not limitable, but that the state through its action or any person through their deliberate action cannot limit the right to a fair trial. Why do I say this? During a trial, the witnesses may die naturally. COVID may happen and cases are delayed naturally. That is extrinsic and it may affect a fair trial. But the court must never do anything deliberately that would impede a fair trial or that would be imputed as limiting the right to a fair trial. So, my Lord, by lifting this conservatory order, you will be actually limiting the rights of the petitioners to a fair trial by taking away a very material remedy to the remedies that are available to them. I'd like to talk about what is the place of the Bill of Rights under our Constitution and the concept of public interest, because it has come up very much. Now, our Bill of Rights under our Constitution is very fundamental. The Bill of Rights, the chapter on the Bill of Rights, is the only chapter under our Constitution that has its own doctrine of interpretation. And the Bill of Rights is enjoyed individually as per Article 19, is by individuals. It is actually antithetical to the concept of human rights and individual human rights to say that the Bill of Rights will be enjoyed at the behest of a public interest. They are actually specified there expressly, especially to be enjoyed in spite of the public interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24, and I would have read the entire article for us to see. But the provisions that it provides is that the Bill of Rights will not be limited except by law, and then only in a manner that is reasonable and justifiable. My Lord, the public interest that has been propounded by at least the response by the Attorney General or the application that by the Attorney General did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My Lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My Lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it can actually be justiciable or it's justified within a democratic society. My Lord, I saw in the response by the National Assembly, the public interest has been a bit defined and has been stated as the fact that we do not have an IEBC. My Lord, that is not a legal question. the other issue was that we cannot stay without a deputy president. My lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IBC is a political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IBC if really there is a political crisis. Finally, my lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case. Because they kind of explained how conservatory orders ought to be interpreted. And my lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time. Because one of the things that is considered by all parties in this case is that an impeachment did happen. And it's presumed to have happened lawfully until this court finds that it did not happen lawfully. By that, the Constitution is very express that the office will fall vacant. And so that one, however much a court attempts, it cannot constrain an edict of an imperative of the Constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done, as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my lord, I want to talk about the Wajir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wajir case relates to a governor who was impeached. The deputy governor assumed office and then even nominated a new deputy governor, and then later on the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the 2 cases. In the Wajir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is the question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the holding of BBI in the BBI case, the presidency is absolutely immune. No amount of court order will be issued that will be able to be enforced against it. Because who will enforce the court order declaring the office of president vacant? My lord, it's the political arms of government that can deal with that. And that might be one of the issues that are political questions that the court cannot really address. So, my lord, as far as the office of the deputy president is concerned, such an order cannot come from this court. We cannot allow the conservatory order to be lifted, and then we imagine that we will be able to enforce an order removing Professor Kindiki from office. My lord, thank you very much. I'd like to ask my co-petitioner, I think petitioner number 12.
I wish to make an application under Article 57 of the Constitution. All the members of the society. The owner is now 2:30. Some of us have to eat at 7 intervals. Also, I'm mindful of the court. We have been sitting all the time. We must be now very tired. Let us adjourn and resume the afternoon.
I think those who are angry can leave.
My Lord, I would like to support the request, very polite request from Dr. Haminwa. Dr. Haminwa is the #1 longest serving member at the bar. And yours truly is #2. So, my Lord, breaking for an hour or so is a very appropriate thing to do. And I ask the court.
We want to break by some order.
Yes.
We want to complete the applicant's case. Then we can break.
Okay. We will persevere.
You are the last one.
Yes, my lord.
How much time do you want?
I need 5 minutes, but I would appreciate it if you don't knock, because I have dyslexia, so it will make me start rapping instead of delivering
So
my
you take about
submissions.
5 minutes, please.
Yes, my lord.
Your name?
My name is Wanjiro Mwangi. I am the 12th petitioner in consolidated file E65 of 2024, and together with the 11th co-petitioner, Dr. Eboso, we asked to be enjoined as interested parties in this matter. My lord, unlike most people in this room, I want to disclose that I have a learning disability or ability called dyslexia, so I ask for time, not to rush me, so I can articulate myself properly. My lords and my lady, I would like to ask this court to deem myself and Dr. Eboso being properly on record, for the sole reason that in other courtrooms we have made submissions and been told that we are not properly on record, and would like our submissions to remain on the record. My lords and my lady, I only have 5 questions today that I want to task to the judiciary and to the members and to the public and to everybody else. Question number 1, the judiciary on trial. My lords and my lady, the only questions you're on trial for in the eyes of the public is a simple one. Is the judiciary truly impervious to the reach of the corrupt and the political class, locally and internationally? If the answer is yes, the Bill of Rights must be respected and upheld. For this, I rely on Article 159(2), justice shall be done to all, irrespective of status, read together with Article 27(2), which states, equality includes the full and equal enjoyment of all rights and fundamental freedoms. Question number 2, the Constitution on trial. My lords and my lady, the second question the public will be asking is, when our Constitution is on trial, because it is no doubt on trial, will the judiciary bend to the insurmountable political pressure, or will jurisprudence, the Constitution, and the rule of law prevail in such adversity? If the answer is yes, then the conservative orders must be stayed. For this, I rely on Article 27. Every person is equal before the law and has the right to equal protection and equal benefits of the law. Question number 3, the laws on trial. My lords and my lady, the third question that is important to the public is that once a court clearly states that a right is absolute, as this court did on the 23rd of October 2024, then the public will be interested to see and know if the court will uphold its own directions. If the answer is yes, then this court must respect and uphold its own directives and guarantee all the petitioners, especially those who prayed for conservative or injunctive orders whose applications have not been heard and determined, including us laymen, the right to a fair trial as specified in Article 50, which reads, every person has a right to have any dispute that can be resolved by the application of a law decided in a fair and public hearing before a court. Read together with Article 27(3), women and men have the right to equal treatment, including the rights to equal opportunities in political, economic, and cultural spheres. Question number 4. Immunity of the office of the President is on trial. The inadvertent question we as a society have to ask ourselves is a moral one. Does the court have any real authority to successfully reverse the impeachment and reinstate Rigathi Gachagua? Based on the truth we know, the truths we have been shown, and the truths we are constantly reminded of by the political pandemic we have been suffering, what confidence does the public have that if the conservation orders are lifted, the court will have any real authority to successfully reverse those orders? Then, under the same assumption, the ascension of Professor Kindiki will succeed after that in a manner of what we expect to be ours, despite the numerous legal ambiguous questions, ambiguous queries about gazette notices in the middle of the night and a lack of IBC commissioners to vet or validate the public participation in that manner? The answer is no. The court will be unenforceable, will be unable to enforce on the office of the president as enshrined in the Constitution and affirmed by the Supreme Court. The court does not have jurisdiction to force Kindiki, if he's sworn in, to recuse him, to impeach himself. That is the real conundrum in a nutshell, and is as simple as the deputy president assumes office, and if the president is unwell, does the judiciary in fact find the impeachment and end if the, sorry, let me just say it again, please. The real conundrum in a nutshell is as simple as this. If the deputy president assumes office, and then the president is unwell, and the judiciary does in fact find the impeachment process was flawed from the National Assembly due to violations of the Constitution, what then? Will the acting president impeach himself as a deputy president? Can he even, is it even possible, and who would enforce those orders? The conservation orders cannot be lifted if they will be rendered a nullity, null and void. For this, I submit Article 27. The state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, region, conscience, belief, culture, dress, language, or birth. Question number 5, and my final question today, is our system is on trial. My lords and my lady, on this final note of mine, I humbly stand before you as a layperson with arguably what I hope to be some of the best legal minds in this country. As our nation is once again at the precipice of a revolution, as the spirit of our nation is reawakening, I submit to you one of the most progressive documents in the modern world, our Constitution, a document which guarantees even terrorists due process, whose preamble starts with "We, the people of Kenya," and ends with "Adopt, enact, and give this Constitution to ourselves and to future generations." It is time to take our place. It is time for the Constitution to prevail. It is time to no longer allow political urgency to override judicial processes. Our country will still be intact in 30 days, and it will still be intact in 60 days without a deputy president. Our Constitution went so far to envision not only the vacancy of the deputy president, it planned for the eventuality of both the president's office and the deputy's office being vacant. Kenya will be fine. We, the people, will be fine. Let the natural cause of justice prevail. It is what we envisioned, and it is what we envisioned for an independent judiciary. Thank you, my lords and my lady. I submit the floor.
Thank you. It is now 2:30. We will adjourn. I want the assurance that we are coming back for the respondent's case.
Yes. Your Lordship, that's not correct. My name is Muraro Moke, Counsel. I'm the 43rd petitioner. I'm the 43rd petitioner, and I understand from your direction on Friday that you would hear all applications for conservatory orders. I would like to be guided on that issue.
Which one is your application?
My application is to be found in the petition E027 of 2024.
My Lord,
filed in
that
Eldoret.
petition is not consolidated with this.
Hello?
It is consolidated, Your Lordship. Mr. Wanyama, just hold your horses. The petition was consolidated by an order transmitted to me on Friday by the Deputy Registrar, indicating that the 2 additional petitions had been consolidated. Can you kindly confirm that?
I informed all parties that we continue to receive petitions in this matter. We received petitions as late as yesterday, and by the very nature of those petitions, they seek invariably the same orders and the same prayers. But when a petition comes after we have given directions on other petitions, certainly you would not expect us to go back on the petitions which are not before the court.
Your Lordship, if you allow me to read the order that I was given, perhaps it can shed more light.
Yes.
The order said that that petition had been consolidated, and I'm required to follow the directions issued on Friday in the in the other petitions. That's what the order states.
My Lord, unless I'm mistaken, we were here to hear applications, two applications in petition, one in petition 522, one in petition 565. Equally, we were here to hear two applications from this side that my Lord directed will be treated as the responses to the applications on the other side. If my colleague's file has been consolidated with these files, it does not necessarily follow that his application also had been scheduled for hearing today. And lastly, my Lord, while I'm on my feet, I know we started by giving directions and the court being fair and allowing the parties to drag on and on, but we are concerned on this side that unless the court is able to fix a stop at some point, the other side is committed to proceeding on and on, as I said, until donkeys grow horns. And
we object to that.
Mr. Omoke, how much time do you want to submit on your application?
Your Lordship, I always speak very briefly. I will take only 5 minutes.
Proceed.
And I'll do it right away.
We will be disadvantaged slightly with Mr. Omoke's application because he has filed written submissions that he only served on us late last night that we have not responded to.
Your Lordship, the submissions I filed, they raise the same cases that we all know about. That's the case of Gatirao Munya, which I believe we are sufficiently aware of.
Submissions in 5 minutes on points of law.
These are the directions we are giving. Mr. Omoke, your petition, we gave directions that it has been consolidated with the petitions before the court. But the fact of consolidation does not mean that your application will be heard. However, because your application raises the same issues as the application before the court, we will give you 5 minutes to canvass that application. And after that, we will adjourn to come back to consider the respondents' responses. Thank you.
Thank you, Your Lordship. My application.
I have a problem. I represent, I'm holding brief for my Prime Minister Ashford Muluki Muguku. He represents a political party, I represent a political party by the name of Maendeleo Democratic Party. And we filed an application, and our understanding was that Mr. Muguku was to be heard today. I wonder if you could take that into account also. Maendeleo Democratic Party.
Which petition?
Which petition is that?
It was not really a petition, it was a motion application.
In which matter?
In which matter?
Yeah, it was being joined in the
Is it cohort 2 or cohort 1?
E565 of 2024. Maendeleo Democratic Party.
My Lord, that's not a party in both cohort 1 and cohort 2.
Maendeleo Democratic Party is not a party in any of the two cohorts. It's not a party in any of the two cohorts.
I see. That's interesting.
Okay, Mr. Omoke.
May I say something again?
But Dr. Kamino, you know you appear in cohort 1 in your own right.
Yes.
Remember that. So if you want to submit in your own right, we will allow you. But for the person who are holding whose brief, we don't appear to see where he
I
is.
think Ashford himself, I don't know.
Just look for him so that he can prosecute his case. But in the meantime, let's have Mr. Omoke.
One final word, my Lord. My Lord, I like being human, and I like taking care of the interests of the judges when they are sitting. You are human. Why don't we adjourn tomorrow?
Dr. Kaminwa, please.
Being human.
It's okay. We are very human.
All that I'm saying, can we start tomorrow?
Let's have Mr.
My Lord, I think the cat is coming now out of the bag.
Mr. Omoke, you have 5 minutes.
What's cat now?
All right, Your Lordship, if I may proceed, I would like to indicate that I support the application of the first petitioner, and I also submit in support of my own application, which is dated 9th of October 2024. I wish to rely on the affidavit sworn on the same day, my submissions filed yesterday dated 27th of October, and the list and bundle of authorities. In summary, I would like to state my, Your Lordship and my lady, Your Lordship, Presiding Judge, Your Lordship.
What's the date of your submissions?
27th of October. I confirm that I personally attended the public participation at Kiambu Social Hall on 4th of October. And that, from what I observed on that day, I was convinced that I had a responsibility to come before you under Article 3.1 to defend and protect this Constitution. That there are serious violations which this court must consider, and in line with the Gatirao Munya case, there is public interest at stake. Gatirao Munya. There is an inherent, there's a case that you need to consider here, where we must look at all those issues on public participation. Was there proper public participation, not just on the day when the Parliament was conducting it on 4th of October, but even prior to that, under Article 10, I would call upon this court to issue the conservatory orders so that we can have an opportunity to re-examine Article 10, which for a long time has been seen as though it is something that is aspirational. And I would like to urge the court to consider this to be something that is binding on all persons and all state organs. So such that for the move of the motion in the National Assembly, at the time he was seeking to bring that motion before the National Assembly, he actually was bound by Article 10 to observe all the values contained therein, including public participation, go around the country and speak to the people. And I'm here to tell you, my lords and my lady, that the people of this country are angry from what I observed on that day, on 4th of October, and they are sick and tired of how the Constitution is being violated.
Well, as counsel is testifying, maybe he can take to the dock so that we can all have an opportunity to cross-examine him on this testimony that he is.
Yes, in response to Professor's objection, I am a party personally, and I saw an affidavit, and I've made all those averments therein. And if I'm required to be examined, I'm very much happy to do that, if you require that. So perhaps Prof can confirm, and I'll take the doc very happily. All right, so I'll carry on. He has agreed that he wouldn't like to examine me, so I'll continue with my presentation. Actually, at that very same public participation, I did meet some of the people from his famous home, Ndumberi, otherwise known as Danbury, and they were very, very unhappy with the way the process was being conducted. And that's why I've come here, not to, just to speak for myself, but also for all of these people. I would like to tell you, your lordship and my lady, I'll close my presentation here because I know that we have an opportunity to examine these issues at a later time.
Thank you. These are the directions we are giving. It is now 20 to 3.
His address to you. And I thought I would mention make a reference to Justice Madden. I knew Justice Madden very well. I made several appearances before him. But one great quality I thought he had was that he was able to appreciate and take care of human nature. He understood human nature was very important in administration of justice. I recall I appeared before him during the time when a lot of arrests were being made in the country by President Moi. And I made an application for bond pending arrest. There was no provision in the Criminal Procedure Code. There was no provision or a decided case in court in the country at all. But still, I made this application before him. And to my pleasant surprise, Justice Madden gave me the order of bail pending arrest. And bail pending arrest became law of the country. It helped very much a lot of people who were being arrested during the time President Moi was in power. My Lords, what you have before you, I'm inviting you very respectfully that you have to take into account what is happening in the country. Here it is, Deputy President of the country. The executive is asking for the conservatory order to be lifted. Deputy President is not a small position in the hierarchy of Kenya at all. He has overwhelming political following. Himself and our President, President Ruto, worked together jointly, and they won the election. One of them became president, another one became deputy president. In the country. There could be trouble in the country. Currently, I'm advised the poll rating of our deputy president is 70% in the country. He has won a lot of sympathy votes from those even who didn't like him at all. 70% is quite a big percentage. I've taken the trouble to read the jurisprudence of the United States on impeaching. The first country was the United Kingdom, and thereafter it was taken up by America. And there is a lot of write-ups, a lot of cases where a lot of people have been impeached, a lot of officers of the state have been impeached, but none of them has succeeded at all in impeaching a president. No president in the United States we have got our own problems. Problems of extreme poverty. Our people now are wallowing in poverty. They cannot get a meal. Those of us who happen to be in a certain class are lucky. People like Camino can talk about going for lunch. There are some people in this country who can talk about going for lunch at all. Our people are in a very poor kind of situation. We have problems of tribalism. We are still a tribal society. We cannot pretend that we are more sophisticated at all. We have problems to do with the conservation. We have got problems around ourselves. Our neighbors are not doing very well. Somalia, Sudan, and etc. They are not doing very well at all. I am submitting to you very respectfully. These are factors that you cannot afford to ignore. You cannot afford to ignore them at all. And it will be a disaster. It will be devastating for this court to proceed and lift the Conservatory order and bring in Professor Kindiki as Deputy President. I don't know very much about Professor Kindiki. I have nothing against him. He has never wronged me. And I don't think that he has ever said anything anywhere against me at all. I have nothing against him. But all that we are very much interested in at the moment is to make sure that we have one country. May I remind you, the court, the Honorable Court, very respectfully, whenever there has been a great departure from the Constitution of Kenya or from constitutional jurisprudence, there has been a problem around. In 1980s, 81 and 82, that's a time when a lot of people were being thrown into detentions. People like Paul Mwite were hiding somewhere else in embassies, I think in embassies offices and so on, because of what was happening there to take a cover. I was personally in detention at that time. That is the time when we had a coup in the country. In the year, I think it's 2007, we more or less had also chaos in the country. The point I'm trying to make to you, my honorable judges, what we have before you, a conservatory order, may look a very small matter, but it's a very big issue when it is looked at and is examined, analyzed in relation to the present position in which we have in Kenya. If I may say so, and this, I wish the Attorney General was here, I would tell her very bluntly. Those who want the Deputy President out, let us assume he's kicked out. They will be the same people who will come and say, President, you must go. President Ruto, you must go. There will be the same people who will say that. That will be opening chaos in the country. My lords, these are factors that you cannot ignore. In American jurisprudence, they never ignored that at all. When Clinton was charged with the offense of moving around with then whiskey and other women, he had quite a number of women that he was having sexual relationship with and so on. Somehow, as the state continued to adduce evidence, the Americans found that Clinton was becoming more and more popular in the country. Those who wanted to see Clinton impeached had to abandon the idea of impeachment because he was becoming a very, very popular president. And moving him out of the position of president could have brought chaos and misunderstanding in the country. So, my lords, I'm saying to you again very respectfully that please do not try to lift the Conservatory order as my land friends are asking for. I hope my little girls have brought my the law relating to impeachment is no longer fair or an American fair. It touches on the rule of law. It touches on human rights in our country. It touches on democracy in our country. It touches on supremacy of the Constitution, the Bill of Rights, leadership and integrity, separation of power, and the role of the judiciary in administration of justice. My lords, may I, with your permission, read to you one provision from a commentary in the Constitution of Kenya, page 150. May I read it to you? 492. This is a commentary in the Kenyan Constitution by our jurists here. And this is what they say. They say some able word, eye-opener. May I read it with your permission? This article, that is the article that is being referred to, is Article 150, dealing with the removal of Deputy President. This article, which sets out the situation that a Deputy President can be removed, protects the Deputy President from arbitrary decisions. From arbitrary decisions. What has been taken here is an arbitrary decision by Parliament, by the Senate, and that should not be taken by the court at all. Arbitrary decision of the President in the field Constitution. If I may pause here, there is a mention of the President. A lot of problems we've had in this country have been caused by the executive, have been caused by the President. We normally have found ourselves in this hostile area because of the acts and behavior of the President. We must tell it as it is. President Moi caused detentions. He acted rashly by putting people in detention. We have had extrajudicial killings because of the presidency. We have had some other ills because of the presidency. May I continue, please? In the repealed Constitution, the Vice President could be removed very easily, merely by the instruction of the President. That is true. That's how my great friend and my great client, Jaramogi Oginga Odinga, found himself having to resign because of what was happening. Karanja, Professor Karanja, faced a similar kind of problem. He was kicked out by the President by the roadside. The Vice President could therefore have been said to be at the mercy of the President, who appointed and dismissed them at will. The current state of affairs enables the Deputy President to sit a heartbeat away from the Presidency, yet enjoy constitutional protection against whimsical section of the President. Let us not forget those wise words, my lords and my lady. I'm inviting you very, very respectfully. Read those words, page 492, and if it becomes necessary, incorporate them even in your own ruling. What is going on now is that the Deputy President and the President probably are not getting on very well at all. In my own humble view, for the years I've worked, a person or persons with whom you are working are not always friends. Sometimes you disagree very, very vehemently, very, very strongly. You may even end up by probably abusing one another, but you still continue to work. You still continue to work. You do not have to be friends to work together. Husband and wife, is there a problem? Husband and wife, and I've handled such cases. Husband and wife may be people who do not get on very well at all. They cook separately, food in the house. They sleep in different rooms and so on. But they have made up one decision. They do not want divorce. They want to make sure that the children are brought up in a family. Russia and America are not getting on very well at all. But if you go to Moscow, you will find American lawyers, American medical doctors, American businessmen. If you go even to New York, the same thing, you'll find Russians. To have a relationship, you do not have to be friends at all. The fact that the President now and the Deputy President do not talk to one another, it does not matter. At the beginning, they were talking very well. They were talking to one another very well. Rachel and Rachel and Dorcas were great friends. Some of us were very happy that you could see two wives, two presidents, all of them looking like people of the same family. That is the culture we want. That is civilization we want. That is the peace we want, so that we make sure that we can develop our economy. But not this kind of quarrels and so on, and where one now is able to convince others that we cannot work together, therefore we must divorce. My humble submission, Mr. Lord Eric Ogola, who is, as you are presiding over the bench, please come up with a judgment or come up with a ruling that you are not going to lift these conservatory orders. If you do so, you will be opening a chapter for this country which we may not be able to handle at all. Currently, let me remind you again, the Deputy President is enjoying poll rating of 70% in the whole country. He has attracted sympathy votes from people who like him. And the Parliament or National Assembly, which actually impeached the Deputy President, if you go through what happened, was a disaster, was disappointing. It is not something to be emulated at all. If you go to the other house, the Senate, again was a disaster. Can I continue, my lord?
Please wind up your submissions.
I'm winding up. I'm winding up. And I'm winding up on this note. My lords and my lady, I have lived enough in this country. I've lived long enough in this country, and in particular in Nairobi. When you hear a rumor, do not be so small-minded and dismiss the rumor at all. The rumor usually has got some truth. So that when you hear Paul Mwita has been bribed, don't dismiss it quickly. There may be truth in it. When you hear Kibe was seen with so-and-so, don't dismiss it quickly. There may be truth in it. This is the ability that Justice Madden had, and that's why he was able to rise to where he was. The ability to be able to know what's going on in the country and so on. We are a corrupt country, and Besha still controls the country. It controls Parliament. It controls Senate. Let it not be said it controls petition. Thank you.
May it please you, Lord President of the Court, and the members of your court, we are happy to reply to our colleagues. Somebody has come from the woodworks.
My name is Mosongo. I am here for Dr. Sharia alongside John Mariri. Sorry. I was just requesting for 5 minutes.
I'm on high demand, so I beg to leave the court. I'm going to deal with some other matters.
My Lord, just a clarification whether Kituo cha Sheria was enjoined. Last time Dr. Minwa made an application for Kituo cha Sheria to be enjoined, and then you enjoined Dr. Minwa himself.
Yes, yeah, that was done.
Yeah.
Yes, Kituo appears now as seventh interested party. I proceed?
You
5
have-
minutes.
Your name?
My name is Mosongo. I proceed?
Yes, please.
Thank you so much. Your Lordship and your Ladyship. At Kituo cha Sheria, our slogan and motto is that we care for justice. Our intention at all times is to uphold the Constitution and ensure access to justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, I'm not 50 years, but I do stand on the shoulders of giants who have been there before me. And I want to just bring out 5 points in my few minutes. Why you shouldn't vacate the orders or fail to ensure there is conservatory orders. Number one, in promoting justice and the interest of justice, we have petitioners who are saying that the right to fair trial and constitutional rights have been contravened and violated. And it will be so painful for them, genuinely speaking, that conservatory orders be lifted, vacated. Then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal playground. Our argument is that your Lordships and your Ladyship, to ensure that their constitutional right to fair trial, even including during this process, so just preserve the few days that you guys will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest.
Judges are not guys.
My apologies. My apologies. My apologies. Your Lordships and your Ladyships. your lordships and your ladyship, if I may proceed. It is indeed in public interest, genuinely, that, and for stability, that for sure status quo be maintained, not only for the current president, vice president, or even the nominee of the president, because you know it said, ukiona cha mwenzako, kichwa cha mwenzako kimenyolewa, chako kitie maji. It is critical even for future vice presidents, deputy presidents, to have their rights safeguarded, and at least the courts provide a guideline on how Article 145 is to be exercised. And for sure, we also think that and argue that procedural integrity and legal precedent that you are at this point making, your lordships and your ladyship, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately when now you make a finding that for sure the entire process could have been flawed. We argue that to also avoid arguments that possibly there would be potential bias, we encourage the lordships and the ladyships to really consider that, as I wind up, that before the final outcome of this honorable court, I humbly pray that the lordship is not affected. Thank you so much. Ordered that one final bullet, last chance to be able to benefit their rights before the final outcome of this honorable court. I humbly pray that your lordships and your ladyships, please do not vacate the orders. Thank you so much.
Thank you very much, Presiding Judge and the members of your court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may very well use half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are. That's where we need to start. What are the facts that are relevant to you determining whether conservatory orders should continue in force or should be vacated? It is my humble submission that the pertinent, the material facts are as follows. On the 17th of October 2024, the Speaker of the Senate gazetted the removal from office of the former Deputy President, the Honorable RIGATHI, by dint of Article 157, sub-Article 7. It is important for us to go there, my Lord, and it will take half a minute. What is the language of 145, sub-Article 7? It is this: if at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. That's the language. Shall cease. This doesn't disappoint my learned friend Teresia Kemodo of Teresia Kemodo and Company Advocates, who wants an apology. The Deputy President ceased to hold office. But something else happened. An intervening fact is that on Friday the 18th of October, via a special sitting of the National Assembly, the Honorable Professor Kindiki Kithure, pursuant to Article 149(1), having been nominated by His Excellency the President, was confirmed by the National Assembly. It voted on his nomination. One person has ceased to hold office, another person has been appointed, has been nominated, and the body entrusted in law in affirming that nomination did so. That was at 1:30 p.m. on Friday the 18th of October 2024. What then did the honorable judges of the High Court of Kenya conserve? What were they conserving? There was nothing to conserve. In the logic of the law, we've been told that, a lot about why the Constitution is very important, why it's very special, why it's very transformative, why it's not like the Constitution of other countries. It may very well be all that. But the Constitution is a law to be interpreted the way we interpret all law. When we read a will, we don't start searching for the spirit of the will, because the will is speaking. It is saying, I leave my assets to my son, to my daughter, to my uncle. So a person reading a will doesn't tell the family, before we read the will, if we read a tenancy agreement, we do not say, let us capture the spirit of the tenancy. The tenancy agreement is speaking where is the ambiguity when the Constitution has said, shall? Our first submission, there is no ambiguity, there is no reason to search for any other meaning, any other spirit, any other constructiveness. The petitioner is aware of that. There is an affidavit here called supplementary affidavit in support of the petition. What does it say in paragraph 22? In this case, however, Kithure Kindiki was unqualified because he had not been a member of UDA political party for 3 months preceding the nomination. He was ineligible for nomination to the elective position of Deputy President under Article 37 on the 18th of October 20, when the vacancy arose. This is not the Attorney General's affidavit, it is the petitioner's affidavit. So he is acting contrary to his express instructions, because he has sworn an affidavit in which he acknowledges that that office became vacant. It is our second submission that when the so-called conservatory orders, and my colleagues will demonstrate that these are not conservatory orders, these were mandatory injunctive orders of a nature not contemplated by the Constitution in this circumstance. At 1:31 p.m., when the conservatory orders both were issued, both in Kerugoya and in Nairobi, there was nothing available to conserve. The substratum of their complaint had been overtaken by events. And so much so, my lords, that, and my learned friends will take you through this, there are several judges who were approached to give conservatory orders, including this bench. And you said there are matters here already overtaken by events. That news may not have reached other parts of the country. Very briefly, I will argue the public interest. My lords, this constitution is a constitution to protect everybody. Sometimes it is cited as if it was tailored only to protect a section of the society in Kenya. It is for everybody, including the institutions that it establishes. It is to protect the judiciary. It is to protect the legislature. It is to protect the executive. We are told continuously that the executive is a problem. The executive is a problem. The executive is also protected by law. The president has a power donated by this constitution to nominate a deputy president. He did that. He has a power to send that name to court, to parliament. He did that. Parliament has a power to vote on that vote. It did that. But it is being suggested that that in itself finds no protection under the Constitution. What finds protection in the Constitution is the Conservatory order that came from Kirugoya. Kirugoya, yeah. A place called Kirugoya. We were told, my lord, and this is true, that the impeachment process is a special process. It's sui generis. It is neither civil nor criminal. It's a process sui generis. And that is why, and this cannot be said many times, enough times, that is why the framers of the Constitution do not say that a vice president will be brought to the Supreme Court of Kenya and tried for violations of the Constitution. It is a political process. It goes to a political chamber. Senate sits as a political body. That's what happens in there. When Dr. Kaminwa says impeachments are never successful in the United States, it is because of the peculiar politics of the United States. Because the impeachment process, even there, is more political than it is here. So we must have fidelity to law, my lords. It is our submission. If you read through the case of Kiriro Ngugi, it is in our bundle, and I will not. And if you read the case of Martin Wambora, Kiriro Ngugi is instructive. This is what the court said, and I'll be very brief. A court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. Thirdly, the ripeness doctrine. Actually, much was said about justiciability. This is not new law. This is old law. It is thousands of years law. It's thousands of years of English law. The first thing the judge would ask is, what is your course of action? You must have a course of action. The court is not a forum where litigants can hold an academic debate. The judge will always ask, what is your course of action? Okay? Now, so the doctrine of justiciability may sound new, but it is as old as the common law. What is the political question doctrine? We are not going to argue it. But it is actually straightforward that the Constitution recognizes that it has donated power and authority to several institutions. And each institution should keep to its lane. We have developed a constitutional law, or we are developing a constitutional law here, that actually invites contravention of the Constitution. And it is this, that every conceivable social, political, cultural, economic grievance is capable of a constitutional resolution. How is that? How is that? It is not possible. And that is why in our political social system, we have a million other ways of resolving conflict. Not all conflict is justiciable. Not all grievances are amenable to a constitutional solution. Now, let me go to my second last point about I want to take you to the case of County Government of Kisii and two others versus the Independent Electoral Commission. It is a 2024 decision, and this is the last thing I'll say before I invite my colleagues to come in. The gracious lady will not have to bang her gong. This is what the court said in that matter. While guided and applying the foregoing, in this case, the law does not anticipate that the office of the Deputy Governor shall remain vacant indefinitely for whatever reason. Having so held that gazettement is a mere administrative formality, and taking into consideration the circumstances of the instant case, whereby nomination and approval by the County Assembly of Kisii was undertaken way back in April 2024, it would be unconstitutional to further delay and postpone indefinitely the filling of the vacancy of the office of the Deputy Governor of Kisii. That's what that court said. Finally, because I'm still within time, the Wajir case shows that our Constitution has self-correcting provisions. What happened there, my lords will remember, yes, is that the governor had been impeached. During his impeachment, the deputy governor assumed the high office of governor. After a long litigation, the court found his impeachment was wrong. And then the court said, reverse the order. Just to use an expression by my learned friend, I think it was Mr. Kiba Mungai, the law is organized. The heavens didn't come down in Wajir. The law said, go back to your office, and the rest of you go home and do something else. That is how to ensure certainty, predictability, stability. That is what we should have here. We are here. I am told on behalf of the Attorney General to assure you that for as long as this matter is litigated, the law will be observed. If a day comes when anything needs to be reversed, that will be reversed. But for now, the public interest is in continuity. Thank you.
Yes, my lord. Your Ladyship and my lords, let me dive right into my submissions, and I will demonstrate, my lords, that contrary to the submissions made by my learned friends, Articles 47, read together with Articles 50 and Article 25(1)(c) on the right to a fair hearing, were complied with. And I will show, my lords, that as of the time that notice was received in Senate by the Speaker on the 9th of October 2024, notices were issued to the petitioner to file all the documents as prescribed and to defend himself to every question that was raised in the National Assembly, which, my Lord, you recall, had voted by 282 members to impeach the Deputy President. The right of fair trial, fair administrative action under Article 47, and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted as the dates when the Deputy President would be heard, and that would be the Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged, then commenced. And all parties were aware that the Senate investigations would take 2 days. Your Ladyship and my Lords, parties were then invited to respond to every allegation. This was a two-tier trial, my Lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no-brainer. The Senate, as a trial chamber, my Lord, Articles 94 and 95, donating powers to Senate and to the National Assembly, respectively. The Senate then proceeded to afford an opportunity. And I want to just demonstrate, my Lord, that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1. Because the people may either access their powers directly or through their elected representatives. So my Lord must read the Constitution in the sense that the Constitution then, speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My Lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question, that the petitioner participated in the entire trial. Only the petitioner, my Lords, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented its case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body, each senator considering the allegations and bundles served to every senator prior to the trial. My Lords, it was on the 17th, and this is an important distinction, at 2:30 p.m. after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mwite presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness but did not reach him. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. My Lords, there's a curious point here, and this is important, my Lords. The provisions of Article 145, 5, and 6, and I want to refer to those articles, provide, my Lord, that at an impeachment hearing before Senate, a party may be represented, 145.5, the President or Deputy President shall have the right to appear and be represented before the special committee during investigations. This article was wholly satisfied because the Deputy President was present throughout the trial. My Lord, then Article 145, 6, A and B then step in. If the claims have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. My Lord, Senate accorded the Deputy President an opportunity to be heard. How was that accorded, my Lords? That was accorded, my Lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my Lord, he was present during the entire presentation of the case by the National Assembly. But third, my Lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My Lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submissions, and it goes like this, my Lord. At 5 p.m., my Lords, the Deputy President, the counsel for the Deputy President, Senior Counsel Paul Mwite, submitted or told Senate that he could not trace his client, but that he had been admitted at Care Nostra. He neither presented a medical report nor a report from any doctor. And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the Deputy President, my Lord, Counsel and his team, Senior Counsel Paul Mwite, Eminent Counsel Elisha Ongoya, and the entire team proceeded to walk out. And why did they proceed to walk out, my Lord? Perhaps they did not read the wording of the Constitution and or the standing orders. Because a party, my Lords, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my Lord, every opportunity was presented to the respondents to present, but they opted, my Lord, not to proceed and not to provide any document to Senate at that point to, my Lord, confirm, my Lord, at the point that their client or the Deputy President in that matter was unwell and admitted. Senate then proceeded, my Lords, to vote on that question. My Lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my Lord, under Standing Order 85, senators on a procedural motion may vote by acclamation. That vote was carried, and Senate then voted to proceed. My Lord, the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we had to proceed, that Senate proceeded, my Lord, the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time-bound and were to conclude in 10 days. The last day, my Lord, that the proceedings were to conclude was the Saturday the next day. My Lord, unfortunately, Senior Counsel Mwite, and the Hansard will demonstrate this, my Lord, had applied for an adjournment to the following Tuesday. My Lord, we have demonstrated that the petitioner dragged the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disappearing. My Lords and your leadership, the petitioner had taken part in the cross-examination of all the parties. No case, my Lord, has been presented before you that one, there was a violation of the standing orders of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were proffered against the Deputy President. My Lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend Mr. Macharia made before this court, that there was additional evidence that was entertained by the Speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my Lord. My Lord, that was a substantiation of a charge on economic crimes that failed. Only, my Lords, 5 out of the 11 charges proffered against the Deputy President petitioner hearing succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my Lord. That out of the 6 charges, my Lord, the Deputy President was convicted on the gross violation of Articles 10(2)(a)(b), 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is live before this court, my Lord, that is on violating his code that requires him to undertake certain function and undermining the function of the National Security Intelligence Service. Ms. Kimotho of Kimotho and Company Advocates would want the Deputy President to apologize on that count. That's a live matter. But my Lord, in the grant of conservatory orders, I submit, and this because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority in this area, clearly. My Lord, on the principles that the court considered, the Supreme Court considered in the Munya case, public interest, I think on the scales, weighed highest, that this court must take into account the import of a conservatory order issued ex parte against public interest. My Lord, this is a country that is built on the Constitution of Kenya 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the Deputy President, my lords and my lady, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a Deputy President sworn in because of the dictates of Article 131 of the Constitution. My lady and my lords, a conservatory order is therefore inconceivable in the terms defined in the Munya case. A conservatory order of the nature issued by Justice Mwongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect Munya. This court would only use that authority to support the appointment of His Excellency Honorable Professor Kithure Kindiki, so that this country moves to the second level. I would urge you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic of Kenya. My Lord, wherein would his remedies lie my learned friend Nyabodi will submit, if it is a salary of 1 month, that would be compensable by damages. If it is a week salary that is 6 that I should have been or to have been deputy president, that would be compensated in monetary terms. But this country, my lord, cannot be at a standstill and be held through litigation, because we need to have that position filled. My lord, if I move to the other point, my lord, we have submitted that since every opportunity was accorded to the deputy president to present his case, and that he failed to present his case, my lord, every argument before this court by my learned friends on the import of the processes of an impeachment fall on their back. They fall on their back, my lord, because the authority in Mike Mbuvi Sonko and Nairobi City County Assembly, and again I argued this one, my lord. In part, I was in this matter. In this case, my lord, the impeachment was upheld. In this case, Mike Mbuvi Sonko had sought to fault the process leading to the impeachment because there were no reasons given for the impeachment. The Court of Appeal rightly stating that 1, there was the Hansard that contained reasons. 2, my lord, in terms of an impeachment, my lord, Mike Mbuvi Sonko was challenging the approach where the Senate sat as a whole, as a committee of the whole. The court finding, my lord, that that is an option that is open to Senate and cannot speak to the lawfulness or otherwise. Counsel on the other side submitted that there was need for a committee. Senate, in its proceedings, my lord, in its wisdom, had voted to proceed through the whole House and accorded the petitioner all his rights that were due to him at the initial stage, only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My lord, we submit, my lord, that unless the processes of Senate are faulted by my learned friends, the impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, Rigathi Gachagua, stood impeached henceforth. Unfortunately, my lords, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. And that is why we have the law of succession. Rights and remedies then come into question. My lord, set aside the conservatory orders. Let us move on, my lords. The bigger public interest tilts in favor of the appointment of His Excellency Professor Kithure Kindiki, a very good man. Thank you, my lords.
Thank you.
My lord and my lady, my name is Modomi Nkolu for the second interested party, and to that end we have filed a notice of preliminary objection dated the 24th of October, the year 2024. We have in addition to that filed a list and bundle of authorities on that preliminary objection, and that list and bundle is dated the 25th day of October 2024, and pursuant to your directions, those are the bundles, my lord. I would suggest you hold them close to you because I'll be referring to them shortly. We have in addition filed written submissions, skeleton submissions dated the 27th day of October 2024. Before I delve into the PO, my lord, a suggestion was made to you. I had forgotten to tell you, my lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my lord, is that unless I am mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me why we have raised this PO and you find that I deserve to be laughed at, it's okay. My lord, our PO makes only 3 interrelated points. The point number 1, which you'll find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution, to confirm whether anything. I'm here to tell you very shortly, my lords, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the President and the Deputy President. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the President or the Deputy President of the Republic. And that is the point made in paragraphs 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the President and the Deputy President. But if we are wrong in that submission, my lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. My lord, why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lords, are set in paragraph 6 of our submissions. And the simple point is this, that our Constitution denies this court, the High Court jurisdiction, on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. it is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone were to come here and say that he was denied his Article 38, which is a human right under that election. My Lord, it is clear by dint of Article 58, sub-Article 5, that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My learned friend, Mr. Ngwe, talks of the word decency. We are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear if you have a dispute as to that matter. Never mind that it has abrogated the entire Bill of Rights. The court you go to is not the High Court. It is the Supreme Court. My Lord, property is a matter of the Bill of Rights. Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my Lord, I'm here very humbly to tell you, the mere fact that someone has run to you screaming Article 23, Article 165, does not without more mean that this court has jurisdiction to hear that matter. In other words, my Lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about Kindiki. So the substratum of the dispute before you is impeachment. And our point, my Lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which reminds me of Professor Gidu Muige's issue about justiciability, then you have no jurisdiction. Luckily, my Lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you. Which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my Lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bado, my Lord, the Bado of Authorities. We have produced you, or rather before you, extracts of the Boma's constitutional, the Boma's draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether this matter should be handled in the court and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other court, including this one, A, Roman 2, disputes arising from the process of the impeachment of the president. So when we were having our debates through the Boma's process, there was a decision, it's there in black and white, that there will be judicial review, not before this court, but in the Supreme Court. Of course we know, my Lord, the Boma's draft was one of many. The next draft that was generated in that process is at page 7 of our Bado. the harmonized draft constitution. At page 8, again, clause 201 of that draft constitution, it is clear there in Article 201, sub-article 4, that the Supreme Court has, paragraph A, exclusive, underline exclusive. We moved from that document, and luckily, my lords, the bench, to me, should be familiar with this process, to a document that went to the 2005 referendum, which was the WACO draft. We have produced it at page 10 of our bundle. This document is special, my lord, in the sense that it was subjected to a referendum before the people of Kenya. And again, you'll find there, Article 184, Kenyans were still toying with the idea that the courts can interfere with this process. But what I want you to mark again on page 11 is that the court that had been envisioned is the Supreme Court, not the High Court. We all, of course, know that draft was rejected by the people of Kenya, and that must mean, because this is the draft that reached the referendum, that the people of Kenya also rejected this rule of judicial intervention in this problem before you. Why do I say so? The next document is now the official constitution we have today, which is the Constitution of Kenya 2010. And it has no clause conferring jurisdiction on this court or even the Supreme Court. And since that rule was always on the table, my lord, but was dropped from the final draft, we must take it that the final decision the people of Kenya made at the referendum of 2010 was that there would be no judicial intervention in the dispute of the nature before you. You are told that we have cited Article 144. Yet it is irrelevant. Let's see shortly whether it's irrelevant. We have produced Article 144 on page 13 of our bundle. My lords and my lady, you can only remove the president and the deputy president through two routes. Either the route of Article 144 or Article 145. We are only mentioning 144 to help us answer, in the absence of express jurisdiction, whether there is inferred jurisdiction. And when you check 144, one of the curious rules it tells you, 144, Article 144, 8 of our Constitution, is that the report of the tribunal shall be final and not subject to appeal. And if the tribunal reports that the president is capable of performing the functions of the office, the speaker shall also communicate. And of course, it goes on to hold that if it finds the president is either insane or suffers an infirmity of body, then the Senate shall vote. Something curious here, my lord, that our Senate can vote to retain a president found by a medical tribunal to be insane, and our Constitution says that decision cannot be challenged in any court or tribunal. Those are not my words. But more curiously, this rule is also repeated, my lord, in Article 165. And for me, what is notable, my lord, is, the Constitution speaks to an issue once. It has spoken about this issue of 144 in 144.9. And when you go to 165 again, it says this court has jurisdiction to hear an appeal from a tribunal on removal from office, except the tribunal under 144. I don't know, but it must count for something that those who drafted our Constitution decided to deny jurisdiction not just once, but twice. So the million-dollar question, my lord, if this court has been denied jurisdiction twice for the process under Article 144, on what basis can it assume jurisdiction for a process under Article 145 in the absence of express conferment of that jurisdiction and in the face of the multiple ousters I took you through, where the Constitution says in black and white, this matter may be about the Constitution, this matter may be about the Bill of Rights, but the High Court has no jurisdiction. That's what we mean when we say in our PO, my Lord, that there is Supreme Court jurisprudence in this country. I'm addressing you now on the authority in advisory opinion number 2, I believe, of 2011. I don't know whether Professor Tom Ojeda was involved. But my Lord, we are told in that decision that jurisdiction cannot be arrogated through the craft of interpretation. What the petitioner and those in support of his cause are inviting the High Court to do is to arrogate to itself jurisdiction of a dispute or by the impeachment of the president through the craft of interpretation, through the craft of stealth, through the craft of sophistry. Jurisdiction is something the court either has or does not have. It cannot be inferred. Professor Ojeda is telling me other things one must either have or not have. There is no middle ground. But I suppose he wants me to fall into trouble with the court, so I won't mention them. My Lord, let's go to the decision in Nixon versus United States, which is at page 20. Again, you are told to laugh at me because this decision is from the 19th century. I will invite you to note it's a decision issued in the year 1993. I was in upper primary school in 1993, and my students say I'm still fairly young. So this is not a decision from the 19th century, my Lord. But I also want to point to you, 1993 is so recent, coming from the United States, a country that has had a constitution running for close to 300 years, now and counting. Why this decision is important, my Lord, is several reasons. One, it is a decision from the United States Supreme Court. Two, our law on impeachment, and I hope again we have to quote my good friend Ongoya, the decency to agree that it is from the United States Constitution we borrowed Article 144 and 145. Even if you take the rule now in issue, Rule 11 here, Rule 11 in this decision of the Senate. So, this decision, to the extent that it comes from the highest court of the country from which we got this idea now before you of impeachment, must surely be persuasive, even if not binding on you. But more important, it is also about impeachment. What happened in this decision, my Lord, is quite interesting. The person who had been impeached was a judge of a federal court in the U.S. He was sent to prison, but refused to resign from his judicial office. And because in the U.S. judges hold office for life, to the extent that he refused to resign, it meant the U.S. Treasury was bound to continue paying his salary and emolument while he was in jail. And of course, that absurdity was not going to be let go. The United States Parliament, called Congress, the House of Representatives and the Senate, took up impeachment and impeached this judge. But when you follow the holdings in this case, my Lord, they say at page 20 of Wabadu that a controversy is non-justiciable where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department of government, or when you lack judicially discoverable or manageable standards or remedies for resolving it. I don't need to belabor the point. When you read the case, the Sonko case and the Wabora case, that is exactly what our Supreme Court has said, following this decision that impeachment is textually committed. Those are not my words. They are the words of the Supreme Court of the U.S., the Supreme Court of the Republic of Kenya. And, my Lord, we submit under Article 144, or rather 145, impeachment is textually committed to the Senate. But they also say the language and structure of the Constitution confirm that textual commitment of this dispute. More importantly, which is what the Attorney General, Emeritus Professor Mwege, if you go to page 21, my Lord, you are told justiciability is also refuted by the lack of finality inherent in exposing the country's political life, particularly if the president were impeached, to months or perhaps years of chaos during judicial review of Senate. We already know, I've been telling you how the other side wants to grind the wheels. We are told by the Supreme Court, my Lord, this specter of the country being held on tenterhooks as this matter is fought here, is fought in the Court of Appeal. The average lifespan of a case in our Court of Appeal is 3 to 5 years, the last time I checked. Then going to the Supreme Court, we are being told the political life of a country cannot be held at ransom awaiting judicial determination. And more importantly, lastly, because my seniors are telling me I've been talking too much, so that I take my seat before they reprimand me, I want to refer you to page 32 of our Bado. And the reason I'm referring it to you, my Lord, is many people will genuinely be shocked by this idea that a dispute like this is not justiciable. But there are good policy reasons for it. And if you read our page 32, which is that decision in Nixon versus United States, it tells you in black and white, there are sufficient safeguards embedded in the Constitution, including majorities, minimum voting thresholds required at every stage of that process, including the holding of a trial, including calling and cross-examination of witnesses. And because those safeguards, especially at the Senate, are in the nature of a trial, that's why Chief Justice Rehnquist tells us here that nobody should have to make every weather of the idea that this type of dispute is not justiciable. Lastly, you are told about political question doctrine and many things. I will invite you to note the courts of Kenya endorsed this doctrine as early as 2005. Again, the authority is on page 51 of our Bado. I don't have time to take you through it. We have produced the Sonko decisions. We have the citations, the quotes we've lifted in our written submissions. And all we are telling you, my Lord, when all is said and done, is to do either of two things. Hold, you have no jurisdiction. The consequence would be that these petitions must be struck out. The conservatory order must fall by the wayside, having been issued by a court lacking jurisdiction. But if my lords find that too heavy and too radical, and therefore unacceptable to this court, I am giving you the alternative. If we must infer jurisdiction, because that's what you're being asked, let's infer it at the Supreme Court, which is the global practice, so that the matter is held of this nature is handled once and for all without subjecting the country's political life. That is the public interest we have just been told from the Supreme Court of the United States. That's all, unless there is a question for me.
Thank you. My Lord, My lady, if it may please you, my name is Milimo. My lord, I'm here to address you on 3 grounds. Specifically, my lord, one on public participation. The second issue, my lord, I'll be addressing you on is fair hearing, with reference, my lord, to the National Assembly. And lastly, on the nominee, my lord, the deputy presidential nominee. My lord, on the first point of public participation, you shall note first, my lord, that there is no one in the petition before you who has alleged that they were denied an opportunity to participate in the public participation exercise. The second point, my lord, is that it's common ground to all the parties that public participation was an essential ingredient in the impeachment proceedings. And that is, my lord, dictated by Article 118B of the Constitution. And my lord, on the boxes to be ticked in reference to the public participation exercise, I invite you, my lord, to refer to the Supreme Court BAT decision. And specifically, my lord, at page 45 of that decision, which we have attached, my lord, to the first Respondents supplementary list and bundle of authorities dated 28th of this month. My lord, the second authority that I will refer you to on matters public participation is the recent authority, my lord, that was rendered last week by the High Court in the affordable housing decision, my lord, that is petition number E154 of 2024, and specifically, my lord, at pages 178 to 179, rather to 184 of that decision. My lord, if you are to refer to the replying affidavit of the National Assembly, you will note that the National Assembly, my lord, undertook an unprecedented public participation exercise. None of that nature and magnitude, my lord, has been undertaken in the history of this country. And my lord, I will refer you to the annexed public participation report, and specifically, my lord, at pages 427 to 555 of the replying affidavit of the National Assembly. And my lord, very quickly, you note that over 224,000 people my lord, over 224,000 people were involved in the exercise, where they volunteered to give their views. And out of those, my lord, you shall note that 65% of the people who rendered their views were in support of the motion.
Is this submission for the lifting of orders or for petition?
My lord, I'm trying to establish the fact that heavy weather was made, my lord, on the fact that there was no public
We have
participation.
noted those heavy weathers, but you know, we need to be, because we are all lawyers and judges, we need to be specific to the issue before the courts. Some of the things which you say here are actually not meant for this forum. We've been trying not to intervene, but you know very well that a lot of submissions which have been made here are not for the proceedings today. They are meant for another proceeding altogether. So if you can just avoid them, the better for us.
Yes, my lord, I stand guided. And then that...
In other words, Mr. Milimo, you may spare us the submission on the sufficiency of the public participation.
Correct, my lord. Yes, my lord, I stand guided, and I was just going, my lord, to refer you to one authority that we had, my lord, attached as authority number 1 in the supplementary list of authorities, if you are to look at page 4 of that authority, my Lord, the sufficiency or otherwise of public participation exercise, my Lord, is to be determined at the main trial. And, my Lord, therefore, I would agree with you that all I need to do, my Lord, is to refer you to the report that I've indicated, my Lord, that it appears at page 427, specifically the findings, my Lord, to 455 of the replying affidavit. But, my Lord, allow me just to pick one thing out of that report. You are particularly, my Lord, referred to one of the constituencies, specifically, my Lord, Keio South constituency, where my learned colleagues, my Lord, raised issues that indeed the figures did not tally. My Lord, first, you shall note that the figures that were quoted by the petitioners, my Lord, are contained nowhere in the public participation report that have been submitted before you. My Lord, I want to believe that my learned colleagues got that information from sources other than the report that was submitted at the National Assembly. My Lord, Keio South views, my Lord, are submitted are to be found firstly at page 289 of the report, my Lord, and it appears as item number 95. And this goes specifically, my Lord, to the hand-delivered and email views, where it was indicated that, my Lord, there was a total of 465 responses, and out of those, my Lord, 455 were in support. That is what, my Lord, is contained in the report as the first limb. The second limb, my Lord, is for those who participated in the public hearings of the 4th, my Lord, of October, and is found at page 331. Same Keio South constituency. And, my Lord, it's indicated that a total of 355 people did, my Lord, attend that public hearing. And out of those, 352 persons, my Lord, supported the motion. Lastly, on that point, my Lord, is to refer you to page 440 of the replying affidavit, my Lord, where you shall note, not 440, my Lord, I'm sorry, page 439, where, my Lord, you shall note that the total responses in respect of Keio South constituency were 820. And that out of those, my Lord, in support were 807. So, my Lord, the views are submitted, or the submissions are submitted by my Lord colleagues, my Lord, do not find any favor in the report, and therefore, my Lord, I'll urge you that you do ignore them. My Lord, I also need to point out that public participation, my Lord, is not a referendum, as well understood, my Lord, and that in the words, my Lord, of your learned brother, justices and sisters, my Lord, in the affordable housing decision, public participation does not, my Lord, necessarily mean that everyone in the country must give their opinions. My Lord, that is paragraph 175 of the affordable housing decision. And that, my Lord, all that the National Assembly was required to do at paragraph 176 is to give the public an opportunity, my Lord, to submit their views. And, my Lord, you shall note that in the report, all that was done by the National Assembly. And therefore, in the fullness of time, my Lord, we shall demonstrate before you that there is absolutely no arguable point, and the public participation exercise that was conducted, my Lord, by the National Assembly was not only meaningful, but was sufficient both qualitatively and quantitatively. My Lord, the other issue that was raised was by my learned colleague, Mr. Omari, on public participation, where he indicated, my Lord, that elections are conducted at the polling stations. My Lord, that submission is not true. The presidential, my Lord, elections are provided for in terms of being conducted, my Lord, at Article 138(2), where it states, my Lord, that the elections are at the constituency level and not at the polling station. My Lord, the other issue that arose from this submissions from my Iranian colleagues is whether, my Lord, the first petitioner was given an opportunity to present his reply to the public prior to the public participation. My Lord, my answer to that is simple. That first, my Lord, the public participation exercise commenced on 2nd of October all the way to 5th. And my Lord, by the time the public participation commenced, the first petitioner had not submitted his response or lodged his response to the National Assembly. And therefore, there's no way, my Lord, that that response could have been availed to the public. Secondly, that, my Lord, the National Assembly only avails what is in its possession. And therefore, at that point, my Lord, the National Assembly could not have been accused of not, my Lord, presenting to the public what had not presented to it. But more important, my Lord, there is no legal requirement, and none was cited by our land colleague, that dictates that the National Assembly had a duty to present, my Lord, that response to the public during public participation. And last, my Lord, nothing stopped the first petitioner, my Lord, from himself presenting that response to the public, as he did, my Lord, on the eve of the hearing or proceedings at the National Assembly. The last point, my Lord, on public participation was whether, my Lord, the Senate ought to have conducted the public participation exercise. And, my Lord, my answer to that is this, that under Article 118b, my Lord, of the Constitution, Parliament is, yes, required to conduct public participation. But, my Lord, Parliament under Article 93(1) refers to both the Senate and the National Assembly. And, my Lord, you shall note that the impeachment proceedings are two-tier. That the first stage, my Lord, is conducted by the National Assembly, and the second one, the trial chamber, is the Senate. The Senate sits as a quasi-judicial organ, my Lord, in respect of the impeachment proceedings, and that it's not required to repeat the public participation exercise. Because if that were to be so, my Lord, then it means that even this court sitting in exercise of a judicial function, it could be required, my Lord, to undertake the public participation exercise.
Mr. Melema, we only entertained you on these submissions because we had entertained other people earlier. That is the only reason we are listening to you.
I thank you, my Lord. But I'm winding up on that, my Lord. Yes. My Lord, the second issue that, my Lord, I'll invite your attention to is on the subject, my Lord, of fair hearing. My Lord, and of that limb, there was a challenge, my Lord, to the standing orders of the National Assembly. My Lord, my answer to that is simple, that there is a presumption of constitutionality of those standing orders, my Lord, and that at this stage, being an intellectual stage, this court, my Lord, has no power to invalidate those standing orders, my Lord. In the fullness of time during, my Lord, the main hearing, we shall demonstrate to you that those standing orders, my Lord, reflect Article 145 and 150 of the Constitution, and that their simple duty, my Lord, is to implement those articles of the Constitution. The other issue, my Lord, that was raised was about impartiality of the Speaker of the National Assembly, my Lord. Yes, and my Lord, you shall note that the Speaker of the National Assembly, my Lord, has no vote in the proceedings, and that is, my Lord, under Article 122(2)(a) of the Constitution, and that submission, therefore, my Lord, is not a valid submission. And, my Lord, more importantly, my Lord, you shall note also that at the National Assembly, the first petitioner was given an opportunity to both appear and be heard. And, my Lord, he did file a substantive response to the notice of motion. And more importantly, my Lord, he was given 2 hours to present oral representations. That opportunity he took, my lord. And therefore the question of there having, my lord, been a breach on the elements of fair hearing does not arise whatsoever or at all. My lord, my last point is on the nomination, my lord, of my good teacher, Professor Kindiki. And my lord, the issue was whether there ought to have been, my lord, an approval process at the National Assembly, and whether, my lord, there ought to have been public participation, as well as, my lord, the timelines that were invoked, my lord, to process the good professor. Yes, my lord, all I need, my lord, to bring to your attention is there was a ruling, my lord, by the Speaker of the National Assembly that we attached to the first respondent supplemental list and band of authorities, dated, my lord, the 28th of October this year. And, my lord, you shall note that in that communication, the Speaker did address all those issues, my lord. The communication, my lord, is communication number 54 of 2024, and it's dated the 18th October 2024, where, my lord, the Speaker did address in giving guidance to the House all those issues, and I will invite you, my lord, to refer to it when you retire. My colleague, Mr. Macharia, my lord, on a light note, told the court that, my lord, I would have said Weta Tosha. My lord, I will say that in 2032 when the right comes. I thank you, my lord, unless your lordship have any questions.
My lords and my lady, I'll proceed from where my learned friend Mr. Milima stopped. Permit me, for completeness of record, to say that the second respondent has filed an application dated the 18th of October 2022. We have filed submissions in support of that application, again dated the 18th of October 2022. And we have a replying affidavit sworn by one Samuel Joroge on the 21st of October 2024. My lords, we also have submissions in response to the application seeking conservatory orders dated the 27th of October 2024. And finally, the list and digest of authorities dated 27th of October 2024. I'm reminded by my colleagues that I forgot to mention my name for completeness of record. My name is Eric Gumbo. My lord, that said, I would want to start by bringing all of us to the same pedestal in understanding the application and the prayers that are currently live before the court. Permit me to draw your attention to the application filed by our learned colleagues in the matter 565 for 2024 for just one purpose only. The application has a total of about 13 prayers. The prayer number 1 all the way to prayer number 10 have been spent. In other words, they've been overtaken by events. The last prayer, which perhaps would have been relevant for purpose of understanding what I'm trying to get to, is prayer number 9, which talks about that pending the hearing and determination of a petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of a person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William Samoei Ruto, to fill the vacancy of the office of the Deputy President of the Republic of Kenya. That prayer is equally overtaken by events. The last prayer is for deletion of what they call falsehoods to various persons and institutions. It then follows, my lords and my lady, that the petitioner, His Excellency Rigathi Gachagua, has no prayer that is live before you in relation to the question of conservatory order. Looking at the application number A015, the only prayer that is live before you is prayer number C and prayer number E, both of which deal with the question of swearing in of the second interested party appointed by the President and approved by the National Assembly, they say, from assuming the office of the Deputy President. It then is our submission that the threshold question, the arguability question, the negatory question needs to then address the issue of swearing in. I will then straight go to the issue of swearing in. My lords and my lady, we've spoken to the provisions of Article 145.7. 145.7 very clearly indicates that if at least 2/3 of the members of a Senate vote to uphold any impeachment charge, the President shall cease to hold office. May I add to the submissions that have been made previously that that provision is a self-executing provision. You do not need more. It is not an action of the Senate. It is an action of the Constitution itself. The first question that then we would want to ask ourselves this afternoon is, in light of view of such an express provision of the Constitution, is it tenable that an order of this court would issue to stop it? Let me take as one step further to remind us that at the point at which the Deputy President was impeached, he then acquired a constitutional blemish. And they say a constitutional blemish because under the provisions of Article 150, all the charges that were substantiated as against him, including the question of gross violation of the provisions of this Constitution, serious reasons to believe that the Deputy President committed a crime under the national or international law, and gross misconduct, then were issues that would be said to have informed his constitutional standing. Now, where am I going with that? I'm trying to make the point that when the Constitution, therefore, has put a dot or a blemish on you, then certainly you become unsuitable to hold office by dint of Chapter 6 of our Constitution. That is, specifically, I would draw your attentions to the provisions of Article 73, Subarticle 1, which says, talks about leadership and integrity, responsibility of leadership. It says, authority assigned to a state officer is a public trust to be exercised in a manner that, 3, brings honor to the nation and dignity of the office. To the extent that those grounds were established under Article 150, it simply means that the person of His Excellency the Deputy President therefore lost the capacity. And why that is important is then, as you consider this question as to whether to grant the conservatory orders or not, would he be one person who would possibly be considered for that situation? And our answer is a simple no. Permit me to speak to the issue of now Article 149. Article 149 reads, within 14 days after vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. First point I would want to make, just to complement what my learned friend Mr. Mudomi has spoken to, as to the justiciability. If the Constitution says that within 14 days of coming into play of Article 145(7), is it practical, is it tenable that within those 14 days, if a party were to have come to court, then going through the hierarchy of the High Court, the Court of Appeal, and the Supreme Court, any dispute touching on that question of nomination would have been resolved? That then speaks to the architecture of our Constitution, to the extent that it is not contemplated that the person who has been impeached would therefore be able to run or even express interest for nomination for purposes of Article 149. Let me then take it one step further to relate Article 149 and 148. In particular, let me start this conversation from one step behind. Our Constitution at Article 1, Sabbatical 2, speaks to how our sovereign power is to be exercised. In particular, it says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, we then relate this to the events of first Article 94, Sabbatical 2, which says the role of Parliament shall be, Parliament manifests the diversity of the nation, represents the will of the people, and exercises their sovereignty. What point am I trying to make? A lot of heavy weather has been made about the candidate who has been presented for purposes of approval under this Constitution. Now, one of the issues that has been raised is that there was no public participation in relation to the candidature of Professor Kithure Kindiki. My lord and my lady, allow me to just take us very quickly to the provisions of Article 149 to provide some bit of context. That within 14 days, allow me to just read it again, within 14 days after a vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days. Vote is the word used. I want to persuade you, my lords and my lady, that the action that the members of the National Assembly would be taking pursuant to this 149(9) flows from the delegated authority under Article 1, Sabbatical 2. It also flows to the role of parliamentarians under Article 94, Sabbatical 2, to exercise the will of the people of Kenya, to exercise their sovereignty. In other words, that is a choice that the National Assembly is making as the representatives of their people. And why that is important is the very question that follows, is when making that decision, is public participation an imperative? Our answer, my lords and my lady, is a straight no. And so that then I give you context. Let me give us what happens in the ordinary elections, and which will be at Article 148. Article 148, Sabbatical 1, reads, each candidate in a presidential election shall nominate a person who is qualified for nomination for election as president as a candidate for deputy president. Then it adds at Sabbatical 2 that for purposes of Clause 1, there shall be no separate nomination process for the deputy president, and Article 137, 1D shall not apply to the candidate of the deputy president. What then do we read from that? It means that a simple reading of Article 148, which is what happens in our ordinary elections, does not call for public participation for the position of the nominated person to occupy the office of the deputy president. Now, if we are to agree and we have seen it in real life, that is what happens. We don't then subject them to public views around what people think about them, sending memorandum. Once that nomination is done, there is no more that follows, other than the declaration after the election itself. Now, why is this important? It is important because of a submission that was made earlier in relation to other provisions of the Constitution which call for public participation. Examples would be in Article 132, for instance, under the functions of a president, Article 132, Subarticle 2, under the functions of a president, the Constitution says, the president shall nominate and with approval of the National Assembly appoint or may dismiss A, cabinet secretaries, B, attorney general, C, the secretary to the cabinet in accordance with Article 154, and the principal secretaries in accordance with Article 155. It is in that instant that then public participation is called for. So that then when the Constitution talks of approve, it means give an opportunity to the parliamentarians to also interrogate the person that is to be approved for whatever position we have. In this case, it is a submission that the Constitution says vote, meaning elect this person. And the test to be derived from that is first past the poll. In other words, at the point of voting, do the parliamentarians vote to support or a majority of them support the nomination? That is the simple question that will be presented before you for determination. Permit me then to move on to speak to the place of public interest in relation to this process. Now, it would be expected that pursuant to the provisions of Article 146(2), that when a vacancy occurs in the office of the president, the deputy president shall assume office as president for the remainder of the term of the president. Number 2, that is Article 2B, that if the office of deputy president is vacant or the deputy president is unable to assume the office of the president, the Speaker of the National Assembly shall act as the president, and an election to the office of the president shall be held within 60 days after the vacancy arose in the office of the president. What is the public interest question? The public interest question is, it is expected, it is a legitimate expectation by the people of Kenya that they'll have a president. In the absence of a president, they will have a deputy president. In the absence of a deputy president, that will have a situation where the speaker would be able to steer the country into an election. The public interest question that we want to ask or present to the court, would it be in the interest of, now that it is clear that there is no occupant of the office of a deputy president, would it be in the interest of the public to expect or to push the country to a potential election under this article because we want to issue orders that would stay the filling of that office? In our understanding, my lords and my lady, that would be pushing the Constitution a little too far. It should not be lost on us that this same petitioner, the mover of this very petition, during the discussions around the motion itself, we had terms like kufa dereva, kufa makanga. What stops him from filing yet another impeachment motion against His Excellency the President tomorrow? It shall be processed. If it is processed, we'll have walked straight into a constitutional crisis. Now, that militates against public interest. And we're saying crisis because we live in this country, and we know that as a matter of fact, we do not have a duly constituted electoral commission. Even if it was the case that we have a deputy president as of today, then pursuant to the provisions of, again, Article 134, which speaks to temporary incumbency, such person would not be able to appoint the Electoral Commission. What then does that mean? It means potentially that the first person to get to Uhuru Park and get sworn will be the president. My lords and my lady, is that a position we would want to allow the country to get into? Permit me to add by saying this, that these constitutional principles are exercised within a particular context. It is a political context. Political context by its own nature, and I had my learned friends speak to the fact that we live in a constitutional democracy, is a competition. In that competition, there will be those who will be for one party and those who will be for the other party. Naturally, it follows that when one party loses office, there will be some measure of discomfort. What then does the court do? It is in those occasions that the court rises to steer the country through that process, so that then the competing interests are balanced in a way that ensures the stability of the country. And because they're deep, it's very interesting and very, something to be very proud about to be Kenyans today, that we are talking about such sensitive issues in this sort of a civil environment. My lords and my lady, in other places, when we talk about this sort of transitions, these are constitutional transitions, they end up subjecting the populace to more difficult positions. Now, because we have this opportunity, what then would the court be considering in whether to grant the orders that have been sought or not? My lords and my lady, the Constitution, constitutionalism, speaks to something we call utilitarianism. Utilitarianism dictates that the court helps maintain what I would call constitutional homeostasis. That means that we then ensure that whatever decision we take is such as to ensure that there is stability within the country and that the country is given an opportunity to move on. My lords and my lady, these are jurisprudential discussions that have found favor with those who have been there before us. We've been told in our learning of jurisprudence about Jeremy Bentham, about Arthur Stuart Mill. They were great proponents of utilitarianism as a concept of constitutionalism. May I also invite you to the works and findings of Roscoe Pound, who postulates that the law is supposed to be a tool of social engineering, and that then, in its implementation, that social engineering is supposed to help to bring stability within the nation. My lords, my lady, it only follows that for us to achieve that stability, then the orders that were issued and that there are ex parte are orders that are supposed to be set aside, the country allowed to move aside. I am most obliged.
Thank you.
My Lord the Presiding Judge, as I settle down and begin to make my submissions in opposition to the notice of the motion before you, may I kindly request the court to ask that that light, which is a bit blinding, be either angled further up or turned off completely.
The light has had.
I guess that makes it a smart light, my Lord. It can understand and react. My Lord, the applications before you for conservatory orders this evening are opposed. For the record, I am Paul Nyamodi. I am on record together with my learned friend, Mr. Gumbo, for the second respondent. And my Lord, I wish to commence my submission by saying that the task before you this evening is a rather simple task. Listening to my colleagues making their submissions, one would be forgiven if they formed the impression that what was for hearing before you was the petition proper. It is not. What is before you for hearing are two applications for conservatory orders. And my lords, it is my submission that the criteria, which you will no doubt consider when you retire to consider your decision in this matter, is straightforward. Do the petitions before you disclose inherent merit? Would those petitions be rendered nugatory if the conservatory orders that are sought are not granted? And lastly, and most importantly, is it in the public interest to grant the conservatory orders that are sought? I wish to state that the purpose of a conservatory order, or the ultimate beneficiary of a conservatory order, is the court, and not the party that seeks the conservatory order. I say so because the purpose of a conservatory order, my lords, is to preserve a situation so that the orders of the court upon conclusion of the hearing of the petition are efficacious. That is not achieved by returning anybody to office. That is merely achieved by maintaining a certain status quo for the benefit of the court. So anybody who seeks to persuade you that they can be returned to office by a conservatory order, then perhaps has misunderstood what indeed a conservatory order is. My lords, just to pull the strands together from the submissions that have been made by my learned colleagues for the respondent, and the context in which I urge my lords, my lady, to view those submissions, is that they have spoken to the first ground. They have spoken to the first ground in Peter Munya. They have spoken, or they are responding to the question, is there inherent merit in the petitions that are before you? All the submissions about public participation, all the submissions about the Article 50 rights are all in an attempt to persuade you that there is no inherent merit in those petitions. And I don't wish to go back on those, but I wish to just put two issues before you in respect of the question of inherent merit. My lords, my lady, when you retire to consider your decision in this matter, I'm sure you will need no reminding that the issue of, or a merit review of the impeachment process is beyond the ability of this court. So reject any requests from the petitioners to conduct a merit review of the impeachment. What this court is able to do, and I believe that is the decision of the Supreme Court in Sonko, is to carry out a process review. And so that you are, so I then submit that in determining whether there is inherent merit, this court must then constrain itself to carrying out a process review. My lords, my lady, the second point I wish to make in respect of inherent merit is this. These petitions arise from a concluded impeachment process. In that impeachment process, as you have heard, there were 11 grounds for impeachment. From those 11 grounds, the Senate rejected 6 and confirmed 5. Out of those 5, 3 grounds, and those are grounds 1, ground 5, and ground 6, turned on the conversation or the issue that has come to be known as the shareholder narrative. Now, the first petitioner does not deny that he said those things that he is alleged to have said. It is my submission that there being no denial as to those utterances from the first petitioner, he acknowledges that he said them. There is an admission from the petitioner that he said those things that he said. Now, those 3 grounds of impeachment flowing from facts that the petitioner has admitted, can there be any inherent merit in a petition that seeks to challenge grounds that he has admitted. Ground 1, ground 5, and ground 6 all flow from the shareholder narrative. It is my submission that there can be no inherent merit in those petitions. The finding by the Senate flows from an admission, and that then takes away the ability of the first petitioner to challenge the Senate's finding. My lords, my lady, I wish to move on to the second ground, or the second issue that you would need to consider when you retire to consider your decision in this matter, and that is the issue of whether the petitions would be rendered nugatory if the conservatory orders that are sought are not granted. And I wish to submit on it with the conjoined issue of what is the appropriate remedy in the circumstances of these petitions. My lords, my ladies, in my preparation for my submissions before you this evening, I came across a pitch of a decision. And I wish to persuade you that the applications before you are for dismissal. And I wish to persuade you by reference to the notices of motion that are before you and to decisions of this court that have been rendered in respect of similar matters. My lords, there is a decision that is in pari materia with this one completely, and I say so for these reasons. The decision, and we have filed it as in a supplementary list of authority, is the decision of the High Court of Kenya in Constitutional Petition number 4 of 2024, Purity Mora Kerira versus the Senate and 8 others. It is a decision of the High Court of Kenya in Nyamira. And it is a decision of your sister, Justice Wilfrida Okwany. We have filed it as a supplementary authority, but I have taken the liberty, because it is important to our submission, to make copies available to the bench, which I wish to just walk you through quickly during my submission. My lords, I submit that that decision is in pari materia with this one for the following reasons. It arises from our impeachment process of the Deputy Governor of Kisii County. As I will demonstrate in a moment, the impeachment was preceded by litigation. The impeachment of the first petitioner in this matter was preceded by no less than 29 petitions. My lords, in that matter, a conservatory order was issued in a petition brought by a surrogate litigant. And perhaps I might want to explain what I mean by a surrogate litigant. Our Constitution enables constitutional litigation by a person other than the direct beneficiary of the order sought. And for the purposes of my submission, I seek your Lordship's permission to refer to that sort of litigation as surrogate litigation. In this matter, a conservatory order is issued in a petition filed by a surrogate litigant. Subsequent to the impeachment of the Deputy Governor of Kisii by the County Assembly of Kisii, the matters are then, or the various matters are then directed through the office of the Principal Judge to Lady Justice Wilfrida Okwany, sitting in Nyamira. And Lady Justice Okwany is then faced with an application such as the one before this court this evening, where a party who has obtained ex parte conservatory orders wishes to persuade the court to confirm those orders. My Lord, I wish to start my reference to this decision in paragraph 63 of that decision. Paragraph 63 is to be found on page 17, and in her usual succinct style, Lady Justice Okwany holds as follows. My attention is drawn to the use of the term "and" in the above cited decision, which connotes that the parameters set for the granting of conservatory orders are to be considered conjunctively and not disjunctively. The decision she's referring to is the decision of Wilson Kibera versus the Judges and Magistrates Vetting Board. It is in paragraph 62, and it sets out the criteria for the grant of a conservatory order. She goes on to conclude in paragraph 63. This means that the failure to satisfy one parameter leads to the collapse of the entire application for the failure to meet the threshold set for granting of conservatory orders. And is used between the threshold issue, between the issue of inherent merit and nugatory. We have submitted sufficiently on the issue of inherent merit. I will not add to it. I will leave it to your lordships and your ladyship to decide. But I wish to state that in the petition before you, the petition would not be rendered nugatory if the conservatory orders sought were not granted. And I wish to commence that submission by reference to the notices of motion themselves. The first notice of motion I wish to refer the members of the court to is the notice of motion in petition 565 of 2024, where the first petitioner, the deputy or the former deputy president of the Republic of Kenya, is the petitioner. My learned colleague, Mr. Gumbo, has gone through the prayers that are spent and those that are live. But I want to focus on prayer 6 and prayer 7. Prayer 6 and prayer 7 of the notice of motion. Prayer 6 reads, pending the hearing and determination of the petition, a conservatory order be issued staying the effect, implementation in any way, including by gazettement and by any person, of the vote resolution made by the Senate of Kenya on the 17th of October 2024, upholding the impeachment charges against the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua. Prayer 7 says, pending the hearing and determination of the petition, a conservatory order be issued staying the implementation in any way, including by way of transmission to the National Assembly or the President of the or to the President of the Republic of Kenya, the vote/resolution passed by the Senate of Kenya on the 17th of October 2024, upholding the impeachment charges against Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua. My lords, my ladies, I wish to refer you now to the other notice of motion before you. That is the notice of motion in petition number 15 from Kerugoya. And I wish to refer you to prayer D in that notice of motion. Prayer D in that notice of motion reads as follows. Pending the hearing and determination of this petition, this Honorable Court be pleased to issue a conservatory order staying the implementation of the resolution passed by the Senate and published by Gazette Notice number 13,400 on the 17th of October 2024, removing the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, from office by way of impeachment. Those three prayers seek to stay the impeachment. Mr. Gumbo has submitted about the effect of the impeachment. I wish to refer you now to the finding of your sister, Lady Justice Wilfrida Okwany, in respect to those sort of prayers. My Lords, paragraph 71 of Justice Okwany's decision reads as follows. In the instant case, I note that the impugned impeachment process has already gone full circle, has been concluded, and a final resolution made by the Senate to impeach the 9th respondent. And again, here the Deputy Governor was the 9th respondent, and the petitioner was the surrogate respondent. 9th respondent, as at the time the instant petition was filed. It is instructive to note that the impeachment proceeded despite spirited attempts by the 9th respondent to stop the process through applications made in similar petitions that are still pending before various courts. That is not too dissimilar to this, and those are the petitions that are before you under the first cohort, petition 522. Paragraph 72. The question which arises is if this court can issue orders whose effect will be to stay the decision by the Senate to impeach the 9th respondent pending the hearing and determination of the petition. My finding is that since the Senate has already made a resolution, the court must exercise restraint and limit its intervention in the impeachment to hearing the merits of the petition. I further find that issuing conservatory orders to stay the Senate's decision will be akin to directing or interfering with other organ/arm of government in exercise of its mandate. My lords, my ladies, in respect of the two prayers, or the three prayers that I have highlighted, I urge you strongly to adopt the same finding as Lady Justice Okwany in paragraphs 71 and 72. My lords, my ladies, Lady Justice Okwany then goes on substantively to deal with the consideration on the second ground of nugatory. In paragraph 73, she states, the other pertinent question is whether the instant petition will be rendered nugatory or worthless if the orders sought in the first application are not granted. Now, she then begins to reflect on the nugatory consideration. My lord, in paragraph 74, she states, the answer to the above question is to the negative. And she starts straight from the beginning by saying no. I find that the applicant's claim that the petition will be rendered nugatory to be misconceived and unfounded. My finding is informed by three main issues. And she goes on. Firstly, the applicant's petition is still pending for hearing and is therefore possible that the court may, after hearing the petition, arrive at a finding that the impeachment process was flawed. Very much like in this matter. She goes on. In such any eventuality, the court may grant the petitioner and indeed the ninth respondent various remedies, including, and this is important, compensation for wrongful removal or reinstatement. Compensation for wrongful removal. One of my learned colleagues suggested that compensation or 1 month's salary is a remedy. That is a remedy as confirmed by your sister, Lady Justice Okwany. And she also states that reinstatement is possible. She goes on. I find guidance in the decision in Mohammed and 6 others versus the County Assembly of Wajir. This is the decision called the Wajir decision, where the court ordered for the reinstatement of the governor who had gone through the entire impeachment process up to the Senate. The court rendered itself thus, and this finding is important, and I submit that when you retire to consider your decision in this matter, go through the Wajir decision and see the entire raft of relief that 3-judge bench sitting in Meru did. And the relief was as follows. As appropriate consequential relief, an order of mandatory injunction is granted against the 8th respondent, Ahmed Ali Mukhtar. This was the deputy governor who had been sworn in as governor after the impeachment of the governor, compelling him to hand over and restore the office of governor of the county of Wajir to the 7th petitioner, Ambassador Mohammed Abdi Mahmoud. That is the appropriate remedy. And I had stated at the beginning that a conservatory order is given for the benefit of the court, not for any party. And if the court then has that ability, then there is no need, I submit, to then issue a conservatory order. My lord, to explain herself further, I refer you to paragraph 77 of that decision. Lady Justice Okwany states as follows. She states that this court takes the view that an impeachment process can be likened to an election process where, for example, a governor and his deputy are elected by majority votes. Following such an election, the will of the majority voters prevails and is acted upon within the timelines set under law. This is done through the gazettement and swearing in of the deputy governor, and his deputy, within the set timelines, irrespective of the existence of a petition challenging. In other words, the outcome of an election cannot be stayed through a conservatory order. Suffice it to say that if at the conclusion of the election, petition challenging such an election, the election court finds that the election process was marred with irregularities, then the election will be nullified and the aggrieved party granted suitable reliefs. Importantly, in paragraph 78, in similar fashion, and as I have already stated in this ruling, if upon hearing the merits of the instant petition, this court finds in favor of the petitioner, Then the ninth respondent will get appropriate remedies, which may include reinstatement to his position of deputy governor, as was held in the Wajir case. And I urge you to substitute deputy governor with deputy president. There is no difference in the position. He is a deputy to an executive office created under the Constitution. She concludes, I am therefore not persuaded that the instant petition will be rendered nugatory unless the conservatory orders sought are granted to the first applicant. My Lord, this is the same as in this matter. There are effective remedies. There is reinstatement. There is damages. My Lords, reflecting further on the issue, in paragraph 79, the last sentence, or the second last sentence beginning on the third line from the bottom, Lady Justice Okwany says the following: I further find that since the office of Deputy Governor is a public office, it does not belong to a specific individual. It follows that once the office holder is impeached, he has to give room to the next office holder, unless and until such impeachment is overturned or nullified by an order of the court. There is no difference in this matter. The office of Deputy President is an office in the public service. It has been submitted that it is a trust. It does not belong to, there is no right post-impeachment that the first petitioner can claim to that office. But profoundly, in paragraph 80, she concludes as follows: I find that in the circumstances of this case, the rights stroke interests of the people of Kisii, I urge the court to read the people of Kenya, to be represented and served by a duly appointed deputy president. Read deputy governor, read deputy president, following the 9th respondent's impeachment, far outweighs the prejudice, if any, that the applicant herein will suffer if the orders sought in her application are not granted. My lords, my ladies, at this juncture, I wish to refer you to prayers 8 and 9 in the notice of motion in petition E565 and prayer E in the notice of motion in petition E015. Prayer 9 says, pending the hearing and determination of the petition, a conservatory order staying the President of the Republic of Kenya, His Excellency William S. Ruto, from nomination of a person to fill the vacancy in the office of Deputy President. And 8, pending the hearing and determination of the petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of the person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William S. Ruto, to fill the vacancy in the office of Deputy President of the Republic of Kenya. Prayer E in the notice of motion from Kerugoya is the same. In light of the findings of your sister, Lady Justice Okwany, in paragraph 79 and 80 of her decision, I submit that those prayers are untenable. To express myself slightly differently from Lady Justice Okwany, what she acknowledges in paragraph 78 and 79 of that decision is the public interest. The third limb of the considerations that you would need to consider when you retire to consider this decision. It is not in the public interest for somebody who has been impeached to come to court, for the court to maintain a vacancy in that public office pending the hearing and determination of a petition challenging their impeachment. That is quite apart, my lords, my ladies, from the fact that this court can fashion appropriate remedies. It is not in the public interest. As recognized by your sister, Lady Justice Okwany, the people of Kenya have an overwhelming right to have that office of Deputy President occupied during the pendency of the first petitioner's challenge of his impeachment before you. And that right is acknowledged as being infinitely larger than any prejudice that may be occasioned to the first petitioner if that office is filled. My lords, my ladies, there was a submission that it would be impossible to remove a deputy president if he is sworn in because of an immunity that is enjoyed under the Constitution. I believe that the immunity under, I believe it is Article 143 of the Constitution, is to the president only. And I submit, my lords, my ladies, that it is possible for the orders of this court to be efficacious without reference to the president. Mr. Mudhomi's client is and remains amenable to the orders of this court, and that remains so even if he ascends to the high office of Deputy President of the Republic of Kenya. My lords, my ladies, the conclusion of your sister Lady Justice Okwany, and I wish to conclude just by referring you to paragraph 82 of her decision, where she says, flowing from the above advisory opinion, and she is quoting the advisory opinion of the Supreme Court in the Speaker of the County Assembly of Embu. And because we are acknowledging matters that we argued, I must acknowledge that I did argue that matter. Quoting that advisory opinion, she says, I find that the moment the Senate made the resolution to impeach the 9th respondent, the office of Deputy Governor immediately became vacant, thus setting the stage for the filling of the vacancy within the stipulated timelines. My finding is that the public interest in this case supports compliance with the constitutional and statutory timelines set for the filling of the vacancy in the office of Deputy Governor of Kisii County. There is an argument that has been made by the petitioners that the Constitution creates a timeline of 74 days for concluding the process. The Constitution, yes, does provide 74 days, but there is nothing wrong with concluding the process in a faster time frame than 74 days. Nobody has suggested that that is unconstitutional. Nobody has, other than expressing surprise as to the speed at which it happened, nobody has said what's wrong with it. Going by the finding of Lady Justice Okwany, I trust that I have persuaded you that the two notices of motion before you this evening are for dismissal. They should be dismissed, and you should then enable the public interest and the people of Kenya to then have a deputy president as entitled by their constitution. I am most obliged. I will take my seat unless my lords, my ladies have anything you wish me to clarify.
Thank you. How many people do you have who are here to submit?
My Lord, I am taking the least minimum the time. I believe there are two more from our side to answer your question. My Lord, there are two more.
Two more from this side?
Yeah, two more from this side and very short submissions.
Okay.
My Lord, of Rule 3.2 of the Mutunga Rules, which require you to apply the constitutional doctrine of proportionality in the grant of conservatory orders. So that, my Lord, it is a delicate balance. The court will be balancing the scales of justice to grant that remedy for conservatory orders. And there are factors then which you will consider when you are balancing the scale for the grant of these conservatory orders. And one of them is that you will have to look at the decision that is being challenged from a prima facie perspective. What is the decision that is being challenged in court? For purpose of laying basis for this doctrine of constitutional, the doctrine of proportionality from a constitutional angle. And then that will determine whether that remedy for conservatory orders is effective or not. Now, the first petitioner was impeached. The first petitioner was impeached on 5 major grounds. That is important for you to determine the effectiveness of the remedy and the prima facie case threshold. He was impeached on gross violation of the Constitution. On that limb, there were 3 grounds which were confirmed on gross violation of the Constitution. Secondly, the first petitioner was impeached on the ground that there are serious reasons to believe he's committed crimes under national law. In this case, crimes under the National Cohesion and Integration Act. And the last ground, he was impeached on gross misconduct. Now, in determining the effectiveness of this remedy, the petitioners are arguing that you issue conservatory orders that reinstate this person to office. And our position is that you cannot issue conservatory orders that reinstate this person back to office because of the reasons why he was impeached. So you have to examine the grounds for impeachment. Secondly, what is the decision that is before court? What is the decision that is before court? Have the petitioners amended their notice of motion application to reflect the grounds which they are not happy about? Because, my lord, we presume, my lady, that they are, of course, not complaining that the Senate dismissed some of the grounds. We presume that they are complaining about the decision of the Senate which is aggrieved to them. So which they are aggrieved. So, my lord, if you look at the motion, you will find particulars of matters which relate to allegations which the Senate dismissed. And they are laying that as a basis for the grant of conservatory orders. You will find dominantly material with respect to ground number 7, which the Senate dismissed. Then they are saying that is a basis for the grant of conservatory orders. And we are saying, my lord, to that extent, they have not completed the test in terms of putting an arguable case in court. They ought to have amended their pleadings to reflect the correct complaint which they have before court and which they ought to lay before court. Thirdly, in determining the threshold, in determining the arguability threshold, I just need to mention 2 decisions from the Supreme Court that you will have to consider. In determining whether they have a prima facie case, you will, of necessity, look at the decision of the Sonko, the Sonko judgment that has been famously described as the Sonko judgment. Now, this Sonko judgment contains principles when it comes to the threshold for all these 3 grounds that the Senate found to have been confirmed. So for purpose of determining an arguable case, the petitioners have not been granular. They have not complained for purpose of laying a basis with respect to these grounds on why, for example, when it comes to the question of threshold, are they complaining that these grounds don't meet the constitutional threshold? So I invite you to look at the case of Munya as well. And lastly, on the question of the grant of conservatory orders, the Kariuki Mate decision. There is a reason why the Supreme Court, in the Justice Kariuki Mate case, has asked the High Court to apply the doctrine of judicial restraint. in granting ex parte orders. And we are arguing that if you look at that decision again, the same reasons why the Supreme Court informed the court not to grant conservatory orders with respect to active parliamentary proceedings, those same reasons are available when you are determining the effectiveness of the remedy of conservatory orders. And it's our firm submission here that conservatory orders, if you look at the four corners of the Constitution, the provisions of Article 23, should not be granted in a manner that reinstates the impeached deputy president back to office. Because then what will be the purposes of granting that conservatory orders? He goes back to office, he's been impeached for violating national values and principles of governance. So where does the test lead to? We submit that the remedy for the grant of conservatory orders that reinstate is not available to them. The reason is that conservatory orders is a highly and ineffective remedy. Conservatory orders will mean then that this court intervenes on matters which are dominantly political. And in the Munya decision, there is a finding that you cannot intervene on matters which the Supreme Court has stated are supposed to be properly before the other arms of Parliament. It is only the Senate and the National Assembly, as it were in the first instance, that can determine the question of impeachment. Impeachment is about policy, political accountability, and governance responsibility. So to that extent, I wish to submit that the petitioners have not, in terms of the effectiveness of this remedy, laid before court enough material. And I wish to stop there and ask my colleague Mishemi to complete our other parts of the submissions. Thank you.
My lords and my lady, my name is Michael Mushemi, appearing for the 9th respondent. On our part, we rely on two affidavits, one sworn on the 22nd of October, a supplementary affidavit sworn on the 27th of October, and submissions and list of authorities dated 27th of October. My lords and my lady, permit me to address you on two critical issues. One is the issue of public interest, and the second is the legal theory of realism as to why conservatory orders cannot issue, especially as to sustain the first petitioner in office as deputy president. On the first issue of public interest, my lords and my lady, you have been told this morning by the petitioners that the office of the deputy president can remain vacant for a period of even up to 60 days because there is no function that would not take place in government. It is our submission first, my lords and my lady, that the deputy president is mandated to chair the Intergovernmental Budget and Economic Council, which is created by Article 6, subsection 2 of the Constitution and Section 187 of the Public Finance Management Act. And the Intergovernmental Budget and Economic Council coordinates government policies, legislation, and functions as between the national and county government. My lords and my lady, the law prescribes that the chair and convener of this council can only be the deputy president. There is no other person in law that can convene the Intergovernmental Budget and Economic Council. Secondly, my lords and my lady, under Article 240 of the Constitution, there is established the National Security Council. And one of the members of the National Security Council is the Deputy President. And it is our submission that pursuant to Article 240 of the Constitution, there is no other person or holder of any other office who can substitute the Deputy President as a member of the National Security Council. This is important, my lords and my lady, because the National Security Council exercises supervisory control over national security organs. This is a critical function of the state. In the absence of the Deputy President, there is legitimate reason to believe that the National Security Council is not properly constituted. And again, this is important, my lords and my lady, because if you look at Article 240, subsection 8, the Council may, with the approval of Parliament, deploy national forces outside Kenya for either regional or international peace support operations or other support operations. So that the situation subsisting as at today, my lords and my lady, is that the National Security Council cannot deploy any national forces either for support operations within the country or international peace support operations. And I urge and respectfully submit to this court to take judicial notice that officers from the National Police Service are currently deployed in Haiti to support with peace operations. So that the argument by the petitioners that the office of the Deputy President can continue to remain vacant is not available, because these two critical functions provided by the Constitution and law would not effectively be carried out. On the second issue, my lords and my lady, I invite you to look at Article 3 and Article 4 of the Constitution, and particularly Article 4, subsection 2, which states that the Republic of Kenya shall be a multi-party democratic state founded on the national values and principles of governance referred to in Article 10. The words used in this section are shall, which is mandatory, and the first petitioner avers in his supplementary affidavit, and I wish to draw your attention to his supplementary affidavit in paragraph 17. That is a supplementary affidavit dated the 27th of October 2024. And on oath, he avers on paragraph 17 that I observe that in other open and democratic societies, and he goes on to say, unlike Kenya. So the first petitioner is averring on oath that Kenya is neither an open nor a democratic society. That is his own affidavit. It is our submission that conservatory orders would militate against legal realism to reinstate a person who cannot safeguard the oath he took as Deputy President, safeguard the Constitution, and who avers in open public that this country is not a democratic society. My lords and my lady, I also invite you to look at Article 130 and Article 131 of the Constitution, which provides that the head of state, the President is the head of state, and the Deputy President deputizes him. And in the authority of the President as provided in Article 131, particularly subsection 2C and D, is to promote and enhance the unity of the nation and to promote respect for the diversity of the people and communities of Kenya. It is our humble submission that any grant of conservatory orders that would sustain the first petitioner in the office of Deputy President would be a violation of this article. It would also be a violation of Article 147, which provides that the Deputy President is the principal assistant to the President and shall deputize the President in execution of his functions. And why this is important is because in the supplementary affidavit dated the 27th of October, we have deponed, or the 9th respondent has deponed, and particularly in paragraph 16, several averments by the first petitioner in which he infers that the President is responsible and must be held to account if anything happens to him. And I will not indicate the rest. You will find them in the supplementary affidavit. So that, my lords and my lady, pursuant to Article 147, it is now no longer tenable that the first petitioner, either at the interlocutory stage or on the final orders of the petitioner, can continue to be the principal assistant to the President. My lords and my lady, I also draw your attention to Executive Order number 1 of 2023, which stipulates that the Deputy President shall chair cabinet committees and shall coordinate issues of budget and policy making of constitutional commissions and other independent offices. Our first submission is that as we speak, there is no person who can execute the function of chairing cabinet committees. On the issue of constitutional commissions and independent offices, it is our humble submission that the Senate, having found the first petitioner guilty of violation of Article 160, then he cannot coordinate any functions with the judiciary effectively. The final thing, my lords and my lady, I would wish you to look at is the issue of political parties, particularly the role they have in policy formulation, political mobilization, and political democratization under Article 4 of our Constitution. The first petitioner was impeached by the Senate by a supermajority, which included members of his own political party and coalition. And I would want to draw you to a comparative analysis. When you retire, you will look at impeachment processes, which we have deponed to in the USA, in South Africa, and Brazil. But of instructive to note that closer home in South Africa, when Thabo Mbeki lost confidence of his own party, he resigned in 2008. And when Jacob Zuma lost the confidence of his own party, he resigned in 2018. So we respectfully submit, on behalf of the 9th respondent, that because of those two issues, conservatory orders cannot issue in this matter. Thank you, my lords and my lady.
Thank you. Thank you very much, my lords and my lady. I want to take 2-3 minutes to delve into the reasons why we support the applications to set aside the conservatory orders, and we pray that the applications for those conservatory orders be dismissed. My name is George Murugara, appearing with the team for the National Assembly of Kenya. I begin by drawing your attention to the provisions of Article 118 of the Constitution, which actually deals with the public participation, which has been debated on and argued on in the House. And what I wish to draw the attention of the court to is sub-article 1, paragraph B, where Parliament is mandated to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. What I wish to point out here is that not all business of the National Assembly or of Parliament has to undergo a public participation, because not all legislative duties nor other business actually does go through public participation. There are legislative processes in this country which need not be subjected to public participation, and also other business of the House which need not be subjected to public participation. What is important is the wording of that clause. The word "or" is not used, because if that was the intention, that everything that Parliament does has to undergo public participation, it would have been that in all legislative and in all other business of Parliament and its committees. However, I take you to Article 145, where there was public participation in spite of the fact that there is no provision that there ought to have been public participation when the motion was actually moved. The correct position is that any member of the National Assembly, on attaining the threshold, can actually move a motion that the President or the Deputy President be impeached. Once that motion is moved, then it goes to chamber, it is debated, and it is voted on. So it is actually for Parliament to determine when to take such a motion for public participation. And I confirm that here, out of abundant caution, Parliament did take this motion to public participation on 2 days, as was even ordered by the court. And after the public participation, there was debate on it in the Parliament. It is this debate that takes into account the public participation, the views that were collected from the public out there. Then after that, a vote was taken, and therefore that process cannot be faulted. It cannot be said to have been flawed in any way, because in spite of the fact that there was no requirement for public participation, it was done out of abundant caution. Finally, there has been an argument that under Article 149, there ought to have been public participation regarding the nominee who was taken to the House for voting. And here we must draw the distinction drawn that this is not an approval. Approval on appointments comes under different articles of the Constitution. It's clearly provided that the appointment would be with approval of Parliament or approval of the National Assembly. Here, what took place was just a vote. There was no motion, because there is no requirement for a motion. There was no debate, because there was no requirement for a debate, because what the law provides is the President nominates and the House votes. So the House sits, it's called to vote on the nominee on the basis that possibly the nominee is known to the entire country. And this is the reason why there is no public participation. If Parliament votes against that candidate, then the President would have to nominate another candidate and continue doing so within a span of 60 days until he gets a vote that is positive in his favor, not an approval. And we've said that approvals usually come under the Public Appointments Parliamentary Approval Act. This is the one that governs approval. This is the one which provides that there must be public participation in all public appointments when actually Parliament has to offer an approval. So finally, public participation here goes to Article number 1, where Parliament is exercising delegated powers of the sovereignty of the people of Kenya. It is presumed that when the Parliament votes, the candidate is known to the people of Kenya, and through their elected representatives, they have actually to cast votes which are in tandem with how their constituencies would have voted. So with these remarks, it is my submission that the nomination and the subsequent vote in his favor of Professor Kithure Kindiki was in order. It was actually appropriate, and it cannot be faulted
in any way, and therefore those conservatory orders should be removed. Thank you very much.
Distinguished members of the bench, Mahat Somane. For the record, I do appear with Dr. Willie Mutubwa and Mr. Hassan Noura for the IEBC. They are all here. Dr. Willie Mutubwa and Mr. Hassan Noura. We are the 16th respondent. We are not with the other respondents. We are the IEBC. We are on our own, and to clarify matters to the court. Distinguished members of the bench, just for the record.
We hope that you are not sharing the minutes, these 5 minutes.
Your Lordship, it's just me. We are not sharing.
All right.
We've decided we will not distribute the time. I will try to cover as much ground as I can on the time allocated. If I need 1 or 2 minutes, you will be kind enough to add me, but I will try to cover. I know it's very late. Just for the record, we rely on the replying affidavit sworn on the 25th of October 2024 by Hussein Marjan Hussein, who is the CEO of the Commission. We rely on the written submissions dated 27th of October 2024 in response to the various petitions and the applications. We rely also on the written submissions dated 27th October 2024 with regard to the application for conservatory orders, as well as the bundles of the authorities. They are on record, Your Lordship, and we have filed and served the same. Your Lordship, on preliminary issues, it's good I came last because it was a learning experience for me, but also for preliminary issues. To the extent that a lot of the petitioners and even some aspect of the respondent dwelt on merit review of the petition, when this is an application for conservatory orders, those submissions should be disregarded by the court. That's the first one. The second aspect, even though the decision or the petitioners is an application for their rights in personam, the fact that the IEBC is here and this is a public interest matter, your decision will be a decision in rem. So the IEBC will be asking that you clarify for it the applicable principle and guide it on first principles. The third one, and which is very important, is it seems that there's a general agreement that the law that will apply, and this is the only thing that all the lawyers agreed on, is Munya. Peter Gatirao Munya is the standard for conservatory orders. We believe the court should adopt that standard. I will not dwell much on the prima facie case, but I will dwell a little bit on the negatory aspect as it relates to my client. My client has been bundled up into these proceedings to establish the application for conservatory orders on 2 grounds, and this is important for the court to note this, on 2 grounds. The first one, the petitioner say that the IEBC has a constitutional role in filling a vacancy in the office of Deputy President under Article 149 of the Constitution. And this is important. The second aspect, they say that even though they have a role, they cannot discharge that role because they do not have the constitutional and legal capacity to function, as they don't have commissioners. This is very interesting. This is what my professor at Harvard Law will call, Mark Petitioner will call constitutional chaos. So they tell you there is a role to be played by the constitutional body. And then they say, once you establish there's a role to be played by the IEBC, IEBC cannot play that role. Your Lordship, In Peter Gatirao Munya, and this is a point that has not been made by most of the council, the issue of conservatory orders is not for the benefit of the private or the public party. Conservatory orders is for the benefit of the court. Because they are supposed to preserve adjudicatory capacity of the court. Just that. If a party benefits because of that, that is collateral. And that is really important for this court. Because once you establish it's for your adjudicatory capacity, two things fall away. The first thing that will fall away, if you find that there is a remedy, there is an alternative remedy in merit review when the petition is heard, there are remedies that subsist when the petition is heard, then that aspect falls away. The second aspect that will fall away, if you make a finding that there's a constitutional mandamus, and Your Lordship, I will refer to you to Article 145(7) of the Constitution. If you make a finding that there's a constitutional mandamus, injunction, edict, direction to the court, then you have to stop there. And Article 145(7) is in such mandatory terms that there is no other way that this court can interpret. X, the president shall cease to hold office. Constitutional injunction, mandamus. So if those two findings are made, then there is no way the petitioners can establish the negatory aspect. As it relates to the two issues, the gravamen of dispute, the position of the IEBC is that the IEBC does not play any role as it relates to vacancy through impeachment under Articles 99 and 137 of the Constitution. There is no constitutional role for the IEBC. There is no statutory role for the IEBC, and I'll come to that because we spent quite a bit of time. Just like the predicament the court is in, whether it should intervene under 165, we also had that predicament. Is there a role for the IEBC? That is the question the CEO of the IEBC asked. And we came to the very considered conclusion, there is no role for us because of constitutional design. And I'll come to that constitutional design. Unlike the court, the IEBC has been involved in a lot of litigation against itself. And there is directions from the Supreme Court of the Republic on what IEBC can do and what IEBC cannot do. I want to refer the court to paragraph 13 of our submissions, the BBI case, the Supreme Court one. An IEBC here can be substituted also for this court, because this court is a creature of Chapter 10 of the Constitution. The IEBC is a creature of Chapter 15 of the Constitution. And this is what the Supreme Court says. At paragraph 13 of we've quoted it verbatim. Number one, the Supreme Court said, the IEBC, being a creature of Constitution and statute, could only discharge mandate vested in it explicitly by law. This court, being a creature of the Constitution and statute, can only discharge mandate vested in it explicitly by the law and the Constitution. The second one, which is very important for this court, is the court said that this was direction given under Article 10(2) of the Constitution and the aspects of rule of law under Article 10(2). The third point that the court made, the IEBC, like other public bodies, could not by craft of innovation, and this is really important, Supreme Court, the IEBC, like other public bodies, could not by craft of innovation or interpretation extend its powers. So it is sufficient for the IEBC or even for this court to look at the constitutive document, the Constitution, and the statutory law, and not and exercise what is within the inner boundaries of that. And D, which is to this court, courts should not encourage extension of powers by constitutional or statutory bodies. And this is really important, paragraph 13 of our submissions, Your Lordship. So the constitution of my client, IEBC, is under Article 88.1, 253, and 259. The position of the IEBC relating to this matter is that Article 149, 145, 150 establish a complete self-contained code. It is a constitutional codified mechanism. It's not a statutory mechanism for governors, for members of National Assembly. It is a constitutional codified mechanism. So when this court is interpreting, IEBC is a creature of the Constitution. This process is a creature of the Constitution. You cannot get out of the Constitution for this process. This court is a creature of the Constitution. So as it relates to the nomination by the President, as it relates to the parliamentary vote, it is not envisaged there is an involvement of the IEBC. This is a constitutional mandamus. As against the IEBC, and I will say as against even this court. We also rely on the case of Engineer Geoffrey Sang versus the DPP and 20 others, your brother Justice Odunga, paragraph 18 of our submissions. And he says that the law is very clear that powers must be expressly conferred. They cannot be a matter of implication. You cannot imply powers. And this is the absurdity. If this court was to make a finding, for example, that IEBC has a role, the way IEBC conducts elections is known, or by-elections. So the second order question we'll be asking the court is, do we declare a by-election? Election by its nature is a contest. How will that contest of filling that office be had? Do we print ballot papers? Those are the secondary order questions that the absurdity of the finding of the court that IEBC has a role will entail to. The second thing, our position, is that this constitution is very detailed. It is very interesting. This constitution tells you how it should be interpreted under Article 10. It tells you under Article 201 how the principles of taxation that will apply. It has what we call constitutional carve-outs, the powers given to various entities. It will be high presupposition to assume that this constitution under 149 could have said that this process, it says for even members of National Assembly. It says for members of National Assembly, and even in the Elections Act we have that. For an office that is that high, there is, to say that the Constitution could not have said that IEBC has a role or this court has a role will be a very grand supposition. Your Lordship, we looked at, so we asked the question what the court should ask. If someone said IEBC has a role, we looked at the things that we will look at. So we'll say, what did the framers think? Can we look at constitutional history to say if there was a role for the IEBC? The IEBC looked at the Bomas draft, Article 168. It looked at the WACO draft, Article 159.1, and we looked at the Harmonas draft. And in all of them, there is no role for the IEBC. So even by constitutional history and constitutional design, there was no role for the IEBC. In fact, there was a role in the WACO draft for the Supreme Court, and those submissions have been made by Mr. Mudomi Tiankolu.
Thank you.
Your Lordship, just 1 minute, I'm almost winding up. Your Lordship, for you to, and then there's a second issue, and then the reason why the court should not interfere with this process, especially I would find there's a role for IEBC. For you to make a finding, for you that, the first finding that you have to make, there is, first, the people who hold public office, they hold what we call RETAC relationships. These are relationships of trust and confidence within our constitutional architecture. Relationship of trust and confidence within our constitutional architecture. So you have to make a finding first, there is a property in public office, Okay, number one. And that confidence is to the Constitution. Number one, you have to make a finding. There is a property to holding public office. Okay? Even when there is a breach of that trust. And a finding has been made by other organs of the Constitution. And the court, the test has always been threefold. Number one, total interference. Judicial fiat. And we don't do that. Our courts don't do that. Courts don't substitute their preferences to what other organs do. The second aspect has been total deference. Not to what other organs do, but total deference to the Constitution. And this is very funny. Professor Githu Muigai is here. I used to teach first year contract, and the case of Feldhaus versus Binley came to mind, that the Constitution is silent, so that means that we can read into things, or we can tell the court to intervene. The Constitution is silent on the court intervention under 149, so we read into it. So that's the second aspect. Total deference, if there is a constitutional injunction, constitutional mandamus, against a public body or against this court, then the court should be able to deal with that. The third one is the intermediate test. And this is what the court has applied, Your Lordship. The intermediate test is you do procedural constitutional compliance. This is our authorities in E181, Justice Majanja's judgment in the Finance Bill Act. In fact, the decision of the Finance Bill Act Supreme Court came down a few hours ago. I think we provide to the court should look at it. The threshold for public participation is not BAT, by the way. The threshold for public participation is even lower because of that decision. And when you look at that decision, which we have provided to the court does what we call procedural constitutional compliance. And what is that? You look at whether a vote happened and the threshold within the Constitution have been made. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, on that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of the, it is Your Lordship, the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer the court.
How is it reported?
It is reported as E031. Let me just, I'll get, it's not yet reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number?
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury versus Okia Omtata. I argued that, but I was led by Professor Githu Muigai. Mr. Ochiel Dudley is there, he can rebut, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic it quoted the case of International Trade Administration Commission versus South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law for you. It is a direction to you. And if you look at that case, if you look at Peter Munya, if you look at the negatory aspect, and if you look at the fact that there is, at what the submissions of Marjan Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against IEBC. Because if you told me this is an election you are able to clear, then I'll tell you, how am I supposed to conduct this nomination process? And what are the consequential orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
Oh.
Who has told you to step down?
I was being told by Professor Gideon Mugai, my professor is telling me to step down. But if I can, just a second.
It's okay, you can step down.
Yeah, not the court, but Professor. But our submissions are those ones, they are on record. And even if there is a role to be played by IEBC, our position is those are administrative roles, which we could still play. But, and that is provided for under Section 11 of the IEBC Act, Section 13(1) of the IEBC Act. The role that we have to do under 137 is to check the voters register. And we check voters register for even people who, for Kenyans every other day, it's a public document. There's no role for the IEBC to play. And if the court were to make there was a role for us, then we say those are administrative roles, but the court should not find a role for us.
Please supply authority you have quoted of E031 to E033 of 2024.
I will, it is hot off the press, I will submit it just now.
Submit to our assistants.
I will, Your Lordship. I will. Thank you so much for listening.
My Lord, I want to apologize if I appeared to take judicial discretion from you. It was intended to keep my promise to you that we will be brief.
We now get to know that every side has a prefect, and that this side, the prefect is Professor Gitu.
My Lord, I just want to also add my voice to the submissions that have been made by the respondents. And they should go on record as that my name is Shara, and I said the Solicitor General for the Attorney General, together with Professor Gitu Muigai and Charles Mutinda and the rest of the team. Yes, my Lord, to say one or two things so that we wrap up submissions from our end. My Lord, it is not any contestation that under Article 145(7) of the Constitution, a final decision of impeachment was made. It is not in doubt, and that has not been controverted by either side.
No, we have. That is what we are challenging.
A final order, at least, my Lord, was made. Secondly, my Lord, it is also not in contestation that a vacancy has arisen or arose in the office of the Deputy President. It's also, my Lord, not in contestation or in doubt that Article 149 of the Constitution was invoked in terms of the President nominating Professor Abraham Kithure Kindiki as a nominee to that position, and that Parliament voted on the same. And I would agree with my learned colleague who has just left the floor, Mahat, that the framers of this Constitution never intended that the IEBC plays a role when it comes to the issue of impeachment. And my Lord, if they so intended, nothing could have stopped them from expressly stating that position. And therefore, my Lord, I am submitting the interim orders
that were granted and are in place cannot cure that position. And therefore, my Lord, relying on the various authorities that have been cited, and more particularly, my Lord, the Munya case, which is a classic case in terms of what will be required in the grant of conservatory orders. It is my humble submission, my Lord, that that has not been made. And I would also submit, my Lord, that when you look at the greater public interest, my Lord, we want to persuade you with the very many other arguments that have been given by my learned colleagues, that you will find favor that the discharge, the vacating, or the varying the orders that have been in place would find greater good than holding those orders in place. And therefore, my Lord, to conclude, I would urge my lady and my lords to find that we cannot continue holding the country at ransom. We need to make a decision that some of the roles and the responsibilities that are played by the Deputy President, which are currently at a standstill, would be extremely good and critical, that the moment these orders are vacated, the rest of the processes should be allowed to be completed. I therefore humbly submit that you discharge the orders that are in place and allow the entire process to be completed. I submit, my Lord.
Thank you. My Lord, I want to confirm on behalf of the respondents that we rest there, but with your kind indulgence, if there is to be a reply, I think again we need to remind ourselves that it ought to be on points of law. If the case is rehashed afresh, we would still be here tomorrow and it would contrary to procedure.
My Lord, I also request a direction on whether persons who are not parties to the application, because there are only 2 applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Okay, 2 things.
Why are we being preempted?
No, two things on way forward. I think we still have to hear interested parties, or have we had them? Anybody? We finished with Dollar. Yes, now, the right to rejoinder is only limited to the applicants and not any other person supporting the application. So it will go only to the applicants. And in this case, we have 2, and they will have, how much do you need?
You had given us 30 minutes, if I remember. I am addressing the court, please. Yes. Reply to the court. You had given us 30 minutes.
My Lord.
Do we do 15-15 or 20-20?
No, my Lord.
Yes.
There is a lot that has been canvassed. In fact, they had given us the impression that they will need less than an hour. They have obviously done 4 hours and something. No. There was things that we
okay, let us have on time.
We can do within 30 minutes.
Let's
or less, depending on how much he's able to cover. The only issue, my Lord, that is the mischief, is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business, and we go.
Okay, this is the way forward. We will give the respondents the time they need. 30 minutes each. Not the respondent, but the applicant. 30. Let's go.
My Lord, may I please the court?
Yes, on what issue?
On the same issue, because I've been standing and I did catch your eye. Still on the issue of the right to reply. My lords, you might remember that I am, first of all, I am one of the unrepresented petitioners in petition 11. And for the My Lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My Lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications would be heard.
Now, Mr. Bosso, just a minute. We will restrict ourselves to the applications at hand. So if yours is not among the 2 applications, then you may have to address that later, not now. And the rejoinder should be on points of law. Rejoinder should be on points of law.
My Lord, I stand guided, but I'd still wish to point out that there are very specific issues that I raised that were not raised by the other applicants and which the other side has responded to and would leave the issues unresponded to altogether.
You can pass those submissions to their counsel for the other applicants.
Before counsel proceeds, I am Wangi Munga, counsel for the 43rd petitioner, Mr. Moraro Moke, and we also had an application which we believe we have a right to rejoinder, a brief rejoinder. And it was one of the applications that was canvassed. So we also have a brief right to rejoinder. We'll only take 5 minutes.
My Lords, Morara appeared in person and argued his own case.
And I am his counsel.
It is not possible.
We appear together with him in this matter.
Let us give directions, and we will proceed with these directions, which my Lord Judge Mrema is going to give. There must be order in every proceeding.
Who is starting? Is it Mr. Yes, proceed.
My Lord, my name is Ochiel Dudley, and it's a great privilege and honor for me to appear before you and to make the Deputy President's rejoinder. Ochiel Dudley is my name. My Lord, allow me to begin with where my very good friend Mr. Somane stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court has said this afternoon, that the framers of the Constitution made it possible for litigants, like our client, the Deputy President, without exception, to approach the courts for redress of fundamental rights and on issues concerning interpretation of the Constitution to determine whether any law or anything said to be done under the authority of the Constitution is constitutional. Paragraph 210, Supreme Court, this afternoon, the court says that this constitutional inquiry, the inquiry you're involved in, extends, the court, while conducting this inquiry, should bear in mind the unlimited reliefs contemplated under Article 23. My Lord, that's sufficient to clear any doubts about your jurisdiction and to clear any doubts about your power to give conservatory orders. If there are any doubts, the court should now feel comfortable. My Lord, during the break, I inquired from my learned friend, Mr. Thiankolo, a very good friend of mine, and I asked him, Dr. Thiankolo, who is the governor of Meru County? He told me, Kawira Mwangaza. Then I asked him, by what authority?
Is he still submitting on points of law, my lord?
You want to hear? When I asked him, by what authority, he told me, by a conservatory order. And so, my lord, this court can give conservatory orders against impeachment. The conservatory order we are speaking about, the one I was speaking to my colleague about, was given by this court not so far ago, on the 21st of August, 2024, in petition E429 of 2024. Let me come to the other case, the Kisii governor's case. My Lord Justice Ogola, you are familiar with that case. You're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place and that that matter would come before Justice Okwany, which is a decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. My Lord, that case is different from this one on the issue of delay. Under Section 32D of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Mora Kirera do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Monda on 14th of March 2024. So she was coming to court outside the 14 days. My Lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My Lord, if you look at page 233 of the CKRC final report, you find Kenyans speaking about, my Lord, the need to allow the transitional processes to be disputed. My Lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court like we have. And so, my Lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kirera conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. My Lord, allow me to concur fully with two things that my learned friends, Mr. Nyamodi and my good friend, Mr. Somani, said, that conservatory orders are really for the court, because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved here is an impeachment both at the National Assembly and the Senate, and the subsequent nomination of Kithure Kindiki to the office of Deputy Governor. And again, unlike Mora, he is yet to take oath here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petitioner more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders, as tools for preservation of the subject matter, hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Mwengi Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kithure Kindiki is sworn into office. My Lord, other cases we agree with, cited by the National Assembly's Kitale Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. The particular state of affairs, which so far you've preserved, is that our client is a deputy president of the Republic of Kenya. We ask you to sustain this conservatory orders. My Lord, County Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court would remain to the end of the term. It would remain unfilled. That time, we had not yet amended Section 32, capital D of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable. I reiterate that the timeline we have here is 74 days. We're yet to eat into a quarter of those days, my Lord. And from the posture taken by this court, it's possible to hear this case and conclude it within those 74 days. My Lord, this petition, within those 74 days, all the three chains of Kenyans court, when required, have risen to the occasion. BBI did not last the 3-5 years my friend Mr. Tiankolu spoke about. It lasted a matter of months. And so it's possible for this court to hold things in place and to expedite the main petition. My Lord, unless that happens, my becoming friend, Professor Githu Migai, spoke about the dissipation of the subject matter. He said this has already dissipated. My friend, Prof. Rejoinder, said, likened it to a death which has already occurred, and so there's no coming back from it. The Senate, in their submission, suggests damages. The petitioner has not pleaded for damages. In short, my Lord, if at this stage the respondents can tell you that the court cannot craft remedies, Dr. Tiankolu bases his preliminary objection on that point. He says that you should not touch this dispute because you would not be able to craft any remedies after hearing the case. My Lord, if at this stage, before you hear the case on the merits, you can be told that, what would happen when, without conservatory orders, you hear the case and the petitioners succeed? My Lord, as I move to conclude, the Attorney General urges you to find, on the basis of the vacancies in the IEBC, that there's public interest in allowing the process to conclude. My Lord, there is an authority, a court order by this court in proceedings to which the Attorney General was party. The Attorney General, in January of this year, 26th of January 2024, in the Banisa case, the Abdullahi versus Attorney General, was directed to reconstitute the IEBC. He has not done that. Today, the Attorney General stands before you and tells you that on account of his delict, on account of his and his client's contempt of court, you should exercise your equitable discretionary remedy of conservatory orders in his and his client's favor. My Lord, a party cannot benefit from their own wrongdoing. That fact of vacancy in the IEBC against an order of this court should not be evaluated in favor of the Attorney General and to the disfavor of the petitioners.
Mr. Dudley.
My Lord.
Are there any pending litigation on the IEBC constitution?
There are, yes, my Lord, but this order has not been stayed. It has not been appealed.
That's okay.
Yes, my Lord. My Lord, there's a case that we did with my good friend, Mr. Adrian Kamodo. It's called Itumbi versus Law Society of Kenya, where Justice Ongudi gave directions and orders to maintain the status quo pending the determination of the matter in court. Itumbi, through my good friend Adrian Kamodo Njenga, went to the Court of Appeal. The Court of Appeal, my Lord, affirming those orders, found that it was an act of mischief to ask the Court of Appeal to vacate conservatory orders meant to preserve the status quo pending the hearing of the matter in court. We submit that the application to vacate made before you is an act of mischief. There's another case, my Lord, on this issue of vacating conservatory orders. This case was argued by my good friend, Mr. Nyamodi, when he was still on the good side of things. And Professor Gidhumi Gai was also, those days, Nyamodi was a good guy. He had not joined the bad company of Mr. Gumbo, who is my friend. My Lord, this is what the Court of Appeal said. The Court of Appeal said that...
My Lord, he must be a bad guy if Gumbo is banned and is his friend.
The Court of Appeal said, my Lord, that when weighty challenges have been placed before you, before a court, and the court has issued conservatory orders, one requires a very strong case to lift those conservatory orders. My Lord, a very strong case has not been made before you to lift the conservatory orders. Instead, a very strong case has been made to sustain and to affirm and to reiterate the conservatory orders. My Lord, I close with the issue of public interest. And again, thanks to the doctrine of precedents, you do not have to think too hard on this. In Attorney General versus Matindi, shutting out 50 CISs whose appointment was questioned before the court, the Court of Appeal, my Lord, said that it would be no consolation to tell the Kenyan people that although service has been rendered, although unconstitutional service had been rendered, it's still service. The Court of Appeal said, my Lord, that service in violation of the Constitution is no service. And in a case that Professor Ojenda argued, the Ong'o case, when
I didn't cite that.
I am citing it, well, I am citing it in my reply.
In response, but I thought on points of law, you refer to cases that have been cited by the other side. I did not. You can't pick up my case. I didn't argue it.
My Lord, if he didn't argue it, he should have argued it. This is a point of law. My Lord, you are told about the public interest. The Court of Appeal in Ong'o.
I think you should respond to a case which has been cited, because otherwise he'll also have the right of reply, and we'll be here for a much longer time.
Back and forth. Just leave
My Lord, if that rule held true, my Lord, how would we have, for example, presented to you the Supreme Court President? Because the purpose of Rejoinder as well, my Lord, is to distinguish and to tell the court points which the other side have concealed.
Well, say it, then we'll give him a right of reply on that issue.
It's in our submissions. It is.
Do you accept that we'll give him a right of reply on that issue?
On this case, yes, my Lord, because it's in our submissions.
Okay, proceed.
The Ong'o case is in our submissions, my Lord, and he can distinguish it if he wishes to. My Lord, the court said, in short, that it is in the public interest to keep out a person if the validity of the appointment is questioned. He had wanted his client to assume office despite a court order to that appointment. And so, my Lord, the office here is a high state office. If Kithure Kindiki assumes office, he will make directives, he will make policies, he will commit omissions. My Lord, this court is yet to design a mechanism for reversing the policies, the decisions, the directives that you would make. If at the end you find that the impeachment and the nomination were both unconstitutional. The Constitution would have been irreparably violated. And my Lord, I close on the point that this case is arguable. In fact, the courts had to stop Mr. Milimo many times and was lenient to many others of my colleagues who strayed into the merits. Prof. Rejoinder being at the forefront of that, the council argued the merits on both sides of the aisle, my Lord. And so, my Lord, that demonstrates that parties are biting at the bits. They are ready to argue the petition and will do so at the earliest opportunity. We request you, my Lord, to allow the request for conservatory orders to please preserve the dispute and let our appearance, our further appearance before you be of some meaning under the Constitution. Thank you for the opportunity, my Lord.
Thank you.
My Lord, may I donate, if I still have it, 3 minutes to my colleague, Mr. Ogada, to say a word.
Lordship, I will be brief. I want to respond to the following points of law raised by the other side. From the other side, a lot of hue and cry has been made about Article 145, subclause 7, and the word shall. Your Lordship, the Black's Law Dictionary, Brian Garner, 10th or 9th edition, confers 6 different meanings to the word shall. So from the plain text meaning of the word shall, the dictionary in law gives it 6 meanings. So shall cannot only mean mandatory, it can mean any other thing. Black's Law Dictionary. In terms of the reading of the Constitution, the Constitution can be read multiple times. It's not only the textual reading of the Constitution that counts. If I had time, I would share with my friends that we drink uji once in a while on the other side. There's a book by Professor Philip Chase Bobbitt that canvasses 6 methods of reading the Constitution: textual reading, moral reading, structural reading, doctrinal reading, purposive reading. Purposive reading has been read in our Constitution, Article 259(1). It has about 4 elements. If we go to 259(3), living tree reading, first articulated by the case of Edward versus Sankey, 1930 Canada. What does that mean to this Honorable Court? There's more coming. So while they were telling us that we are running away from the case, we're telling them, Ngoja, bado mambo, we are ready. And we are going to explore the full depths of this Constitution on the merits. Please conserve the substratum. We are ready to go. The question, another point was raised here, that the President is protected by the Constitution in his role in appointing a prophylactic Deputy President in a nominating capacity, nominative capacity. The Constitution in that manner is deemed as a constitutive charter. It creates institutions. The Constitution, going by the violations that have been raised on this side, touching on constitutional rights, plays a protective capacity. So this court will, on the merits, be asked to balance those 2 shades of the Constitution. The Constitution as a constitutive charter, the Constitution as a protective charter. We will discuss that on the merit. My good friend, Senator Professor Tom Ojenda, expert orders need to be lifted for the reasons he raised. They have not answered to you, to your satisfaction, and we attached a case in our submissions. There's a decision of the Ghanaian Supreme Court, Barclays Bank, in our submissions. The test for overturning a decision made ex parte, they have not satisfied you as to why the decisions of Justice Mwongo in Kerugoya should be overturned. The issue here is broader than mere compensation by way of sums of money to an individual. The broader question here is the Constitution and how offices of the Constitution are occupied. Article 1, Article 2, Article 3 of the Constitution. My good friend and teacher, Mudhomi Thiankolu, that there is an absence of a specific textual authorization for judicial involvement in the court. Again, we refer to the various methods of reading the Constitution, such that if we go by their own arguments, and I had my good friend Mr. Somane talk of reading in, that's a remedy available to this court under Article 23. Reading in can be read into statute or any other constitutional methods here. We can use that as a remedy. So the absence of express textual bar in the Constitution does not preclude this court from reading the Constitution in any other way. Several documents are cited here, the Bomas draft, the Kilifi draft. What was missing from all that discussion is the commentary from individual delegates. Because if we were to look at the travaux, the preparatory documents, where are the comments from the delegates? Where is the report on for the committee of experts? And in any case, the Constitution 2010 enjoys its imprimatur, its force in law, by the seal of approval it was given by the citizens through a referendum in August 2010. And any law interpreted and read into the Constitution post the promulgation, that becomes law. These courts have been laboring to do that for some time. Finally, Mr. Milimo, the Senate sits in a quasi-judicial capacity. Yes, if the Senate sits in a quasi-judicial capacity, Article 47 kicks in. This court has to exercise judicial review. Madison versus Marbury, 1803. It is inherently the province of the judicial branch to say what the law is. I submit.
My Lord, for purposes of the second application, Mr. Ndegwa will, in about 5 minutes, will make some 2 points, then I will proceed with the remainder.
Thank you very kindly, my lords, my lady. Permit me just to indicate what Professor Githu Muigai Senior Counsel indicated, that the Senate is a chamber or is a political chamber. There can never be something that is far from the truth, because in the case of Governor Wambora, that is civil appeal number 21 of 2014, the Court of Appeal had the opportunity of evaluating that preposition, and it came to a conclusion that when the Senate is seized of a matter of impeachment, it's not just a political chamber, but it converts itself into a quasi-judicial process. And that is why, my lords, under starting order number 79, the Senate is required to take a special oath before constituting itself into a quasi-judicial chamber. On the question, one issue of about justiciability of the process, it's our humble submissions, my ladies, my lords, that was ousted by the enactment of Article 3, Article 1, Article 10, 27, 25, 50, 165, and 159 of the Constitution. When the people of the Republic of Kenya enacted Article 3, it bestowed upon all state organs, any individual, to protect the Constitution. And therefore, there is nothing that is far from the reach of this court, insofar as the protection of the Constitution and Article 3 is in issue, insofar as the upholding of the doctrine of sovereignty is in issue, insofar as the application of Article 10, the principles of and the values of governance are concerned, and most importantly, the rule of law. How can it be that justiciability can be pleaded as a defense, yet the court is being told to uphold the rule of law, good governance, democracy, and the participation of the people? How can it be that this can be a defense when Article 165, 3D calls upon this court to interrogate whether anything said to be done has been done in accordance to the Constitution. Was the impeachment of the Deputy President not done within the Constitution? Was it not sanctioned by the Constitution? How then can it be from the reach of this court? How then can it be a defense when Article 27 creates a doctrine of equality before the law? How can it be argued in that respect? Allow me to address what Professor Rejoinder addressed. The question of the two-tier trial. Yes, it was a two-tier trial, but was the Deputy President granted an opportunity to be heard? My Lord, my ladies, look at Article 1 and Article 94 of the Constitution as read together. Article 94 provides for the creates Parliament and provides that it's a representation of the people. How can it be a representation of the people and you lock them out when it comes to their participation on a question of the impeachment of the Deputy President? How can it be that Parliament can be immune from the application of Article 1 and usurp the people's power when the people are supposed to directly participate in giving their views under Article 118 of the Constitution? My ladies, my lords, you are invited to look at the trial at the Senate, and you are told that it was time-bound. My ladies, my lords, it's a misconception and misreading of the Constitution under Article 145. My ladies and my lords, the only time Senate was limited was when or if it constituted itself into a special committee. If what transpired in Parliament, in the Senate, was a matter that was under Article 145, Clause 6, then we could say that the 10 days period mattered. But it is important for us and imperative for us, my ladies, my lords, to note that when the Senate sat to hear the impeachment of the Deputy President, it is sat as a plenary of the House. And as such, the 10 days were not therefore applicable in that circumstances. Number two, my ladies, my lords, you have been told that the Deputy President avoided to appear for his defense and that he was represented. But my ladies, my lords, if my good learned friend, Professor, was carried with the truth, he would have drawn your attention to the provisions of the rules of procedure for the removal of the President and Deputy President, starting order number 78-9, and you would have drawn your attention to rule number 6. And on that rule number 6, he would have told you that the rule provides that where the President chooses to appear before the Senate, the President shall be required within 3 days of the invitation under sub-rule 4, or rule 4 on the date specified in the invitation to file an answer to the charge with the office of the clerk of the Senate in which the President shall set out. He would have told you the mode of appearance. 1, the President's response to the particulars of the allegations. Number B, how the President, and in this case the Deputy President, proposes to appear before the Senate. And that rule has created through mechanisms or through 3 ways in which the Deputy President could have appeared. 1, whether in person. 2, by advocate. 3, in person and by advocate. The operative word in our case, my ladies, my lords, is number 3, in person and by way of advocate. The Deputy President appeared in person and by advocate. And as such, my ladies, my lords, when he was taken ill, the question of then appearing in person and by advocate was an issue. And number 2, my ladies, my lords, he was a witness and the only key witness before the Senate. How then could you say that there was fair trial under Article 50 of the Constitution when the only fundamental infrastructure of the trial is unavailable? My ladies, my lords, permit me to address you on what was submitted by Mr. Somane. It's unfortunate that he has chosen to have a very lean and thin way of looking at the application of Article 149 of the Constitution. There can never be anything that is misleading to say that that article should be read in isolation of other provisions of the Constitution. If you choose to read Article 149 in isolation, you arrive at the absurdity that Mr. Somane and his colleagues have arrived at. I would urge this Honorable Court to look at the import of Article 259 of the Constitution, which provides for the manner in which the Constitution must be interpreted. If Mr. Somane was candid with the truth, he would have invited this Honorable Court to harmonize and to purposively read into Article 149. My ladies, my lords, the reading of Article 149 in a purposive and in a harmonious way would have told Mr. Somane that then Article 99 and Article 137 of the Constitution is imperative. And therefore to say that the IBC had no role in the process of the nomination of Mr. Kindiki is absurd, is not true. The fact is that if Mr. Kindiki was to successfully become the Deputy President of the Republic of Kenya, is it then true that he can become a Deputy President who has not qualified under Article 99 of the Constitution? Is it therefore true that he can become the Deputy President if he has not qualified under Article 137 of the Constitution? Who then determines this qualification? Is it the President? Is it Mr. Somane? Is it I Ndegwa? Who determines that qualification if it is not the IBC?
My Lord, there is something that Mr. Giro is submitting on, which touches on very critical facts concerning Professor Kindiki as to his qualifications. And we are all familiar with the qualifications of Professor Kindiki.
I think the last time Mr. Kamodo was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to act for the other client because it would have been illegal. But I have a client. So I'm properly on record. And it is important that the record be made straight with regard to Professor Kindiki's qualification, and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kindiki has acceded to. And secondly, it will be...
That's a merit issue that is being argued. So are we going to have the opportunity to answer it? Because the law is the opposite of what you say.
It was raised by Mr. Giro. I'm just clarifying, and then Mr. Giro will continue.
To raise that issue, that is my submission, my lord. He is going into the merits.
But then Mr. Giro may
just let's sort it. My lord, it's me who is on record for Professor Kindiki. I think if Mr. Ndegwa, my very good friend, I usually call him the Black Bull, could keep off rehashing his application.
The black what?
Bull. That's what Ndegwa means. If my friend, the Black Bull, could keep within the remit of a rejoinder and a reply, we will not be having all these interjections. I've been resisting the urge because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as the person on record for Professor Kindiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Njiro time to finish.
I am also obliged, my lords. My lords, finally, let us distinguish the Kisi case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kisii, my ladies, my lords, is that the Kisii deputy governor underwent the full trial at the Senate. And therefore, my ladies, my lords, those facts are distinguishable. Finally, my ladies, my lords, Mr. Gumbo urged you to find that there will be crisis if the position of the deputy president is not filled. I want to remind him that Article 139 and Article 146 has created an avenue and a remedy where if the president is even today impeached, the remedy is that the Speaker of the National Assembly under Article 146 takes over for 60 days, and under Article 139, if the two of them are not able to take office, again the remedy is that the Speaker takes over. So we are not in a crisis whatsoever, my ladies, my lords. I invite my learned friend, Senior Mr. Kibe, to proceed.
My Lord, I start with the assurance to my learned colleagues that I know what is reply to issues of law. So I hope I can proceed without a lot of interruptions. My Lord, I start with the submissions by my learned colleagues, Professor Muigai. I agree with him, my Lord, that you cannot be able, we are entitled to a legal opinion, but we are not entitled to a set of facts. And therefore, where the set of facts is as they are. But my Lord, in saying this, it is important to remember that what also litigants are not entitled to, and this is the reason for conservatory orders, is the fact that unlike in war, where you can change facts on the ground, the court does not accept a situation in which one party would be allowed to change facts on the ground in a manner that makes a mockery of the proceedings before it. That is to say, if we are before you on account of the fact that there have been violations in the impeachment process, my Lord, and the conservatory orders that have prevented the completion of those illegalities are in issue, this court should not permit a situation in which a party is able to say that let me change certain facts, as it were, by completing the violations. My Lord, there is a question of public interest. We don't have to say much about it, but coming from the Honorable Attorney General, my Lord, I would only urge that public interest from the Attorney General must also be read, apart from what is directly friendly to the government, must also be read to what is also friendly to the people of Kenya. And that is a desire to ensure that the impeachment process is done credibly and upholding all the rights and the procedures that are in issue, so that it is still possible for the Attorney General to say that public interest in this particular scenario would require that fundamental rights, the case on fundamental rights, be concluded before you can be able to say this or the other person should take office. My Lord, there is the issue of the conservatory orders. I've had to read them again. The one from Justice Muongo, because they have been called as orders of reinstatement or mandatory injunctions. My Lord, I believe and I have a lot of full confidence in the fact that it will not be possible for Judge Muongo to issue mandatory injunction on reinstatement at that level, and as a matter of fact, he did not. The prayers as framed is purely to preserve this matter pending hearing a determination of the petition. So it's a scarecrow argument to say you are seeking reinstatement, you are seeking mandatory injunction. There is no such thing, my Lord. Coming to Professor Rejoinder, he said many things. There are only two that I wish to respond to. One of these is the observation, his reactions to the fact that, to the Senate process and about the Deputy President. My Lord, I wish and I hope the court will note the substantial lack of empathy in the circumstances of the Senate about why the DP was not there, what remarks ought to be made and what ought not to be made. Second issue that we wish to make with regard to the issue of Professor Rejoinder, is, of course, this issue that he said there is no comeback from impeachment and all this, and we proceed and swear. My Lord, if that were to be the case, then it would mean that impeachment is not the legitimate subject matter of this honorable court. Yet we have had the decisions that they have read themselves from the Supreme Court on the issues of impeachment. My Lord, Mr. Muthomi Thiankolu, my friend, came with these interesting arguments that on the issues of jurisdictions. My Lord, these issues of jurisdiction is an interesting one, as we'll see it in a minute. My Lord, the first impeachment case that appeared before a three-judge bench was in Kerugoya. Kerugoya seems to favor a lot of impeachment stuff. And it related from the M cases. I don't know whether Professor Rejoinder was there. But, my Lord, it is important to say this with regard to that I actually made the precise argument that my learned friend Mr. Mugobi made about whether the question of impeachment under the constitutions of Kenya was justiciable or not. The three-judge bench held that it was justiciable, and it is on the basis of that because it relates to the issues of Bill of Rights and procedure. And
my Lord, let him also tell you whether it was the impeachment of the president, because my submission was not that impeachment is generally non-justiciable. Even the authority has cited it was about the impeachment of the president, whether that is justiciable.
I'll come to that in a minute. But the point I want to make, for purposes of the argument, the authority is there. For purposes of the arguments, those precise
cases are supplemented by the provisions of Rule 3.2 of the Mutunga Rules, which require you to apply the constitutional doctrine of proportionality in the grant of conservatory orders. So that, my Lord, it is a delicate balance. The court will be balancing the scales of justice to grant that remedy for conservatory orders. And there are factors then which you will consider when you are balancing the scale for the grant of these conservatory orders. And one of them is that you will have to look at the decision that is being challenged from a prima facie perspective. What is the decision that is being challenged in court? For purpose of laying basis for this doctrine of constitutional, the doctrine of proportionality from a constitutional angle. And then that will determine whether that remedy for conservatory orders is effective or not. Now, the first petitioner was impeached. The first petitioner was impeached on 5 major grounds. That is important for you to determine the effectiveness of the remedy and the prima facie case threshold. He was impeached on gross violation of the Constitution. On that limb, there were 3 grounds which were confirmed on gross violation of the Constitution. Secondly, the first petitioner was impeached on the ground that there are serious reasons to believe he's committed crimes under national law. In this case, crimes under the National Cohesion and Integration Act. And the last ground, he was impeached on gross misconduct. Now, in determining the effectiveness of this remedy, the petitioners are arguing that you issue conservatory orders that reinstate this person to office. And our position is that you cannot issue conservatory orders that reinstate this person back to office because of the reasons why he was impeached. So you have to examine the grounds for impeachment. Secondly, what is the decision that is before court? What is the decision that is before court? Have the petitioners amended their notice of motion application to reflect the grounds which they are not happy about? Because, my lord, we presume, my lady, that they are, of course, not complaining that the Senate dismissed some of the grounds. We presume that they are complaining about the decision of the Senate which is aggrieved to them. So which they are aggrieved. So, my lord, if you look at the motion, you will find particulars of matters which relate to allegations which the Senate dismissed. And they are laying that as a basis for the grant of conservatory orders. You will find dominantly material with respect to ground number 7, which the Senate dismissed. Then they are saying that is a basis for the grant of conservatory orders. And we are saying, my lord, to that extent, they have not completed the test in terms of putting an arguable case in court. They ought to have amended their pleadings to reflect the correct complaint which they have before court and which they ought to lay before court. Secondly, thirdly, in determining the threshold, in determining the arguability threshold, I just need to mention 2 decisions from the Supreme Court that you will have to consider. In determining whether they have a prima facie case, you will, of necessity, look at the decision of the Sonko, the Sonko judgment that has been famously described as the Sonko judgment. Now, this Sonko judgment contains principles when it comes to the threshold for all these 3 grounds that the Senate found to have been confirmed. So for purpose of determining an arguable case, the petitioners have not been granular. They have not complained for purpose of laying a basis with respect to these grounds on why, for example, when it comes to the question of threshold, are they complaining that these grounds don't meet the constitutional threshold? So I invite you to look at the case of Munya as well. And lastly, on the question of the grant of conservatory orders, the Kariuki Mate decision. There is a reason why the Supreme Court, in the Justice Kariuki Mate case, has asked the High Court to apply the doctrine of judicial restraint in granting ex parte orders. And we are arguing that if you look at that decision again, the same reasons why the Supreme Court informed the court not to grant conservatory orders with respect to active parliamentary proceedings. Those same reasons are available when you are determining the effectiveness of the remedy of conservatory orders. And it's our firm submission here that conservatory orders, if you look at the 4 corners of the Constitution, the provisions of Article 23, should not be granted in a manner that reinstates the impeached deputy president back to office. Because then what will be the purposes of granting that conservatory orders? He goes back to office, he's been impeached for violating national values and principles of governance. So where does the test lead to? We submit that the remedy for the grant of conservatory orders that reinstate is not available to them. The reason is that conservatory orders is a highly and ineffective remedy. Conservatory orders will mean then that this court intervenes on matters which are dominantly political. And in the Munya decision, there is a finding that you cannot intervene on matters which the Supreme Court has stated are supposed to be properly before the other arms of Parliament. It is only the Senate and the National Assembly, as it were in the first instance, that can determine the question of impeachment. Impeachment is about policy, political accountability, and governance responsibility. So to that extent, I wish to submit that the petitioners have not, in terms of the effectiveness of this remedy, laid before court enough material. And I wish to stop there and ask my colleague Mshemi to complete our other part of the submissions. Thank you.
My lords and my lady, my name is Michael Mushemi, appearing for the 9th respondent. On our part, we rely on two affidavits, one sworn on the 22nd of October, a supplementary affidavit sworn on the 27th of October, and submissions and list of authorities dated 27th of October. My lords and my lady, permit me to address you on two critical issues. One is the issue of public interest, and the second is the legal theory of realism as to why conservatory orders cannot issue, especially as to sustain the first petitioner in office as Deputy President. On the first issue of public interest, my lords and my lady, you have been told this morning by the petitioners that the office of the Deputy President can remain vacant for a period of even up to 60 days because there is no function that would not take place in government. It is our submission first, my lords and my lady, that the Deputy President is mandated to chair the Intergovernmental Budget and Economic Council, which is created by Article 6, subsection 2 of the Constitution and Section 187 of the Public Finance Management Act. And the Intergovernmental Budget and Economic Council coordinates government policies, legislation, and functions as between the national and county government. My lords and my lady, the law prescribes that the chair and convener of this council can only be the Deputy President. There is no other person in law that can convene the Intergovernmental Budget and Economic Council. Secondly, my lords and my lady, under Article 240 of the Constitution, there is established the National Security Council. And one of the members of the National Security Council is the Deputy President. And it is our submission, that pursuant to Article 240 of the Constitution, there is no other person or holder of any other office who can substitute the Deputy President as a member of the National Security Council. This is important, my lords and my lady, because the National Security Council exercises supervisory control over national security organs. This is a critical function of the state. In the absence of the Deputy President, there is legitimate reason to believe that the National Security Council is not properly constituted. And again, this is important, my lords and my lady, because if you look at Article 240, subsection 8, the Council may, with the approval of Parliament, deploy national forces outside Kenya for either regional or international peace support operations or other support operations. So that the situation subsisting as at today, my lords and my lady, is that the National Security Council cannot deploy any national forces either for support operations within the country or international peace support operations. And I urge and respectfully submit to this court to take judicial notice that officers from the National Police Service are currently deployed in Haiti to support with peace operations. So that the argument by the petitioners that the office of the Deputy President can continue to remain vacant is not available because these two critical functions provided by the Constitution and law would not effectively be carried out. On the second issue, my lords and my lady, I invite you to look at Article 3 and Article 4 of the Constitution, and particularly Article 4, subsection 2, which states that the Republic of Kenya shall be a multi-party democratic state founded on the national values and principles of governance referred to in Article 10. The words used in this section are shall, which is mandatory, and the first petitioner avers in his supplementary affidavit, and I wish to draw your attention to his supplementary affidavit in paragraph 17. That is a supplementary affidavit dated the 27th of October 2024. And on oath, he avers on paragraph 17 that I observe that in other open and democratic societies, and he goes on to say, unlike Kenya. So the first petitioner is averring on oath that Kenya is neither an open nor a democratic society. That is his own affidavit. It is our submission that conservatory orders would militate against legal realism to reinstate a person who cannot safeguard the oath he took as Deputy President, safeguard the Constitution, and who avers in open public that this country is not a democratic society. My lords and my lady, I also invite you to look at Article 130 and Article 131 of the Constitution, which provides that the head of state, the President is the head of state, and the Deputy President deputizes him. And in the authority of the President as provided in Article 131, particularly subsection 2C and D, is to promote and enhance the unity of the nation and to promote respect for the diversity of the people and communities of Kenya. It is our humble submission that any grant of conservatory orders that would sustain the first petitioner in the office of Deputy President would be a violation of this article. It would also be a violation of Article 147, which provides that the Deputy President is the principal assistant to the President and shall deputize the President in execution of his functions. And why this is important is because in the supplementary affidavit dated the 27th of October, we have deponed, or the 9th respondent has deponed, and particularly in paragraph 16, several averments by the first petitioner in which he infers that the President is responsible and must be held to account if anything happens to him. And I will not indicate the rest. You will find them in the supplementary affidavit. So that, my lords and my lady, pursuant to Article 147, it is now no longer tenable that the first petitioner, either at the interlocutory stage or on the final orders of the petitioner, can continue to be the principal assistant to the President. My lords and my lady, I also draw your attention to Executive Order number 1 of 2023, which stipulates that the Deputy President shall chair cabinet committees and shall coordinate issues of budget and policy making of constitutional commissions and other independent offices. Our first submission is that as we speak, there is no person who can execute the function of chairing cabinet committees. On the issue of constitutional commissions and independent offices, it is our humble submission that the Senate, having found the first petitioner guilty of violation of Article 160, then he cannot coordinate any functions with the judiciary effectively. The final thing, my lords and my lady, I would wish you to look at is the issue of political parties, particularly the role they have in policy formulation, political mobilization, and political democratization under Article 4 of our Constitution. The first petitioner was impeached by the Senate by a supermajority, which included members of his own political party and coalition. And I would want to draw you to a comparative analysis. When you retire, you will look at impeachment processes, which we have deponed to in the USA, in South Africa, and Brazil. But of instructive to note that closer home in South Africa, when Thabo Mbeki lost confidence of his own party, he resigned in 2008. And when Jacob Zuma lost the confidence of his own party, he resigned in 2018. So we respectfully submit, on behalf of the 9th respondent, that because of those two issues, conservatory orders cannot issue in this matter. Thank you, my lords and my lady.
Thank you.
Thank you very much, my lords and my lady. I want to take 2-3 minutes to delve into the reasons why we support the applications to set aside the conservatory orders, and pray that the applications for those conservatory orders be dismissed. My name is George Murugara, appearing with the team for the National Assembly of Kenya. I begin by drawing your attention to the provisions of Article 118 of the Constitution, which actually deals with the public participation, which has been debated on and argued on in the House. And what I wish to draw the attention of the court to is sub-article 1, paragraph B, where Parliament is mandated to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. What I wish to point out here is that not all business of the National Assembly or of Parliament has to undergo a public participation, because not all legislative duties nor other business actually does go through public participation. There are legislative processes in this country which need not be subjected to public participation, and also other business of the House which need not be subjected to public participation. What is important is the wording of that clause. The word "or" is not used, because if that was the intention, that everything that Parliament does has to undergo public participation, it would have been that in all legislative and in all other business of Parliament and its committees. However, I take you to Article 145, where there was public participation, in spite of the fact that there is no provision that there ought to have been public participation when the motion was actually moved. The correct position is that any member of the National Assembly, on attaining the threshold, can actually move a motion that the President or the Deputy President be impeached. Once that motion is moved, then it goes to chamber, it is debated, and it is voted on. So it is actually for Parliament to determine when to take such a motion for public participation. And I confirm that here, out of abundant caution, Parliament did take this motion to public participation on 2 days, as was even ordered by the court. And after the public participation, there was debate on it in the Parliament. It is this debate that takes into account the public participation, the views that were collected from the public out there. Then after that, a vote was taken, and therefore that process cannot be faulted. It cannot be said to have been flawed in any way, because in spite of the fact that there was no requirement for public participation, it was done out of abundant caution. Finally, there has been an argument that under Article 149, there ought to have been public participation regarding the nominee who was taken to the House for voting. And here we must draw the distinction drawn that this is not an approval. Approval on appointments comes under different articles of the Constitution. It's clearly provided that the appointment would be with approval of Parliament or approval of the National Assembly. Here, what took place was just a vote. There was no motion because there is no requirement for a motion. There was no debate because there was no requirement for a debate, because what the law provides is the President nominates and the House votes. So the House sits, it's called to vote on the nominee on the basis that possibly the nominee is known to the entire country. And this is the reason why there is no public participation. If Parliament votes against that candidate, then the President would have to nominate another candidate and continue doing so within a span of 60 days until he gets a vote that is positive in his favor, not an approval. And we've said that approvals usually come under the Public Appointments Parliamentary Approval Act. This is the one that governs approval. This is the one which provides that there must be public participation in all public appointments when actually Parliament has to offer an approval. So finally, public participation here goes to Article number 1, where Parliament is exercising delegated powers of the sovereignty of the people of Kenya. It is presumed that when the Parliament votes, the candidate is known to the people of Kenya, and through their elected representatives, they have actually to cast votes which are in tandem with how their constituencies would have voted. So with these remarks, it is my submission that the nomination and the subsequent vote in his favor of Professor Kithure Kindiki was in order. It was actually appropriate, and it cannot be faulted in any way, and therefore those conservatory orders should be removed. Thank you very much.
Distinguished members of the bench, Mahat Somane. For the record, I do appear with Dr. Willie Mutubwa and Mr. Hassan Noura for the IEBC. They are all here. Dr. Willie Mutubwa and Mr. Hassan Noura. We are the 16th respondent. We are not with the other respondents. We are the IEBC. We are on our own, and to clarify matters to the court. Distinguished members of the bench, just for the record,
we hope that you are not sharing the minutes, these 5 minutes.
Your Lordship, it's just me. We are not sharing.
All right.
We've decided we will not distribute the time. I will try to cover as much ground as I can on the time allocated. If I need 1 or 2 minutes, you will be kind enough to add me, but I will try to cover. I know it's very late. Just for the record, we rely on the replying affidavit sworn on the 25th of October 2024 by Hussein Marjan Hussein, who is the CEO of the Commission. We rely on the written submissions dated 27th of October 2024 in response to the various petitions and the applications. we rely also on the written submissions dated 27th October 2024 with regard to the application for conservatory orders, as well as the bundles of the authorities. They are on record, Your Lordship, and we have filed and served the same. Your Lordship, on preliminary issues, it's good I came last because it was a learning experience for me, but also for preliminary issues. To the extent that a lot of the petitioners and even some aspect of the respondent dwelt on merit review of the petition, when this is an application for conservatory orders, those submissions should be disregarded by the court. That's the first one. The second aspect, even though the decision or the petitioners is an application for their rights in personam, the fact that the IEBC is here and this is a public interest matter, your decision will be a decision in rem. So the IEBC will be asking that you clarify for it the applicable principle and guide it on first principles. The third one, and which is very important, is it seems that there's a general agreement that the law that will apply, and this is the only thing that all the lawyers agreed on, is Munya. Peter Gatirao Munya is the standard for conservatory orders. We believe the court should adopt that standard. I will not dwell much on the prima facie case, but I will dwell a little bit on the negatory aspect as it relates to my client. My client has been bundled up into these proceedings to establish the application for conservatory orders on two grounds. And this is important for the court to note this, on two grounds. The first one, the petitioner say that the IEBC has a constitutional role in filling a vacancy in the office of Deputy President under Article 149 of the Constitution. And this is important. The second aspect, they say that even though they have a role, they cannot discharge that role because they do not have the constitutional and legal capacity to function, as they don't have commissioners. This is very interesting. This is what my professor at Harvard Law will call, Petitioner will call constitutional chaos. So they tell you there is a role to be played by the constitutional body. And then they say, once you establish there's a role to be played by the IEBC cannot play that role. Your Lordship, in Peter Gatirao Munya, and this is a point that has not been made by most of the council, the issue of conservatory orders is not for the benefit of the private or the public party. Conservatory orders is for the benefit of the court, because they are supposed to preserve adjudicatory capacity of the court. Just that. If a party benefits because of that, that is collateral. And that is really important for this court. Because once you establish it's for your adjudicatory capacity, two things fall away. The first thing that will fall away, if you find that there is a remedy, there is an alternative remedy in merit review when the petition is heard, there are remedies that subsist when the petition is heard, then that aspect falls away. The second aspect that will fall away, if you make a finding that there's a constitutional mandamus, and Your Lordship, I will refer to you to Article 145(7) of the Constitution. If you make a finding that there's a constitutional mandamus, injunction, edict, direction to the court, then you have to stop there. And Article 145(7) is in such mandatory terms that there is no other way that this court can interpret. X, the president shall cease to hold office. Constitutional injunction, mandamus. So if those two findings are made, then there is no way the petitioners can establish the negatory aspect. As it relates to the two issues, the gravamen of dispute, the position of the IEBC is that the IEBC does not play any role as it relates to vacancy through impeachment under Articles 99 and 137 of the Constitution. There is no constitutional role for the IEBC. There is no statutory role for the IEBC, and I'll come to that because we spent quite a bit of time, just like the predicament the court is in, whether it should intervene under 165, we also had that predicament. Is there a role for the IEBC? That is the question the CEO of the IEBC asked. And we came to the very considered conclusion, there is no role for us because of constitutional design. And I'll come to that constitutional design. Unlike the court, the IEBC has been involved in a lot of litigation against itself. And there is directions from the Supreme Court of the Republic on what IEBC can do and what IEBC cannot do. I want to refer the court to paragraph 13 of our submissions, the BBI case, the Supreme Court one. And IEBC here can be substituted also for this court, because this court is a creature of Chapter 10 of the Constitution. The IEBC is a creature of Chapter 15 of the Constitution. And this is what the Supreme Court says. At paragraph 13 of we've quoted it verbatim. Number one, the Supreme Court said, the IEBC, being a creature of Constitution and statute, could only discharge mandate vested in it explicitly by law. This court, being a creature of the Constitution and statute, can only discharge mandate vested in it explicitly by the law and the Constitution. The second one, which is very important for this court, is the court said that this was direction given under Article 10(2) of the Constitution and the aspects of rule of law under Article 10(2). The third point that the court made, the IEBC, like other public bodies, could not by craft of innovation, and this is really important, Supreme Court, the IEBC, like other public bodies, could not by craft of innovation or interpretation extend its powers. So it is sufficient for the IEBC or even for this court to look at the constitutive document, the Constitution, and the statutory law, and and exercise what is within the inner boundaries of that. And D, which is to this court, courts should not encourage extension of powers by constitutional or statutory bodies. And this is really important, paragraph 13 of our submissions, Your Lordship. So the constitution of my client IEBC is under Article 88(1), 253, and 259. The position of the IEBC relating to this matter is that Article 149, 145, 150 establish a complete self-contained code. It is a constitutional codified mechanism. It's not a statutory mechanism for governors, for members of National Assembly. It is a constitutional codified mechanism. So when this court is interpreting, IEBC is a creature of the Constitution. This process is a creature of the Constitution. You cannot get out of the Constitution for this process. This court is a creature of the Constitution. So as it relates to the nomination by the President, as it relates to the parliamentary vote, it is not envisaged there is an involvement of the IEBC. This is a constitutional mandamus. As against the IEBC, and I will say as against even this court. We also rely on the case of Engineer Geoffrey Sang versus the DPP and 20 others, your brother Justice Odunga, paragraph 18 of our submissions. And he says that the law is very clear that powers must be expressly conferred. They cannot be a matter of implication. You cannot imply powers. And this is the absurdity. If this court was to make a finding, for example, that IEBC has a role, the way IEBC conducts elections is known, or by-elections. So the second order question we'll be asking the court is, do we declare a by-election? Election by its nature is a contest. How will that contest of filling that office be had? Do we print ballot papers? Those are the secondary order questions that the absurdity of the finding of the court that IEBC has a role will entail to. The second thing, our position, is that this constitution is very detailed. It is very interesting. This constitution tells you how it should be interpreted under Article 10. It tells you under Article 201 how the principles of taxation that will apply. It has what we call constitutional carve-outs, the powers given to various entities. It will be high presupposition to assume that this constitution under 149 could have said that this process, it says for even members of National Assembly. It says for members of National Assembly, and even in the elections that we have that. For an office that is that high, there is, to say that the Constitution could not have said that IEBC has a role or this court has a role will be a very grand supposition. Your Lordship, we looked at, so we asked the question, what the court should ask. If someone said IEBC has a role, we looked at the things that we will look at. So we'll say, what did the framers think? Can we look at constitutional history to say if there was a role for the IEBC? The IEBC looked at the Bomas draft, Article 168. It looked at the WACO draft, Article 159.1, and we looked at the Harmonas draft. And in all of them, there is no role for the IEBC. So even by constitutional history and constitutional design, there was no role for the IEBC. In fact, there was a role in the WACO draft for the Supreme Court, and those submissions have been made by Mr. Mudomi Tiankolu.
Thank you.
Your Lordship, just 1 minute, I'm almost winding up. Your Lordship, for you to, and then there's a second issue, and then the reason why the court should not interfere with this process, especially I would find there's a role for IEBC. For you to make a finding, for you that, the first finding that you have to make, there is, first, the people who hold public office, they hold what we call rhetoric relationships. These are relationships of trust and confidence within our constitutional architecture. Relationship of trust and confidence within our constitutional architecture. So you have to make a finding first. There is a property in public office, okay, number one. And that confidence is to the Constitution, number one. You have to make a finding. There is a property to holding public office, okay? Even when there is a breach of that trust. And a finding has been made by other organs of the Constitution. And the court, the test has always been threefold. Number one, total interference, judicial fiat. And we don't do that, our courts don't do that. Courts don't substitute their preferences to what other organs do. The second aspect has been total deference, not to what other organs do, but total deference to the Constitution. And this is very funny. Professor Gidhu Muigai is here. I used to teach first year contract, and the case of Feldhaus versus Binley came to mind, that the Constitution is silent, so that means that we can read into things, or we can tell the court to intervene. The Constitution is silent on the court intervention under 149, so we read into it. So that's the second aspect. Total deference, if there is a constitutional injunction, constitutional mandamus against a public body or against this court, then the court should be able to deal with that. The third one is the intermediate test. And this is what the court has applied, Your Lordship. The intermediate test is you do procedural constitutional compliance. This is our authorities in E181, Justice Majanja's judgment in the Finance Bill Act. In fact, the decision of the Finance Bill Act Supreme Court came down a few hours ago. I think we provide to the court should look at it. The threshold for public participation is not BAT, by the way. The threshold for public participation is even lower because of that decision. And when you look at that decision, which we have provided to the court does what we call procedural constitutional compliance. And what is that? You look at whether a vote happened and the threshold within the Constitution have been met. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, on that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of the, it is Your Lordship, the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer the court.
How is it reported?
It is reported as E031. Let me just, I'll get, it's not yet reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number?
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury versus Okia Omtata. I argued that, but I was led by Professor Gidu Muigai. Mr. Ochiel Dudley is there, he can rebut, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic it quoted the case of International Trade Administration Commission versus South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law for you. It is a direction to you. And if you look at that case, if you look at Peter Munya, if you look at the negatory aspect, and if you look at the fact that there is at what the submissions of Marjan Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against IEBC. Because if you told me this is an election you are able to clear, then I'll tell you, how am I supposed to conduct this nomination process? And what are the consequential orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
Oh.
Who has told you to step down?
I was being told by Professor Gidu Muigai. My professor is telling me to step down. But if I can, just a second.
It's okay, you can step down.
Yeah. Not the court, but Professor. But our submissions are those ones, they are on record. And even if there is a role to be played by IEBC, our position is those are administrative roles, which we could still play. But, and that is provided for under Section 11 of the IEBC Act, Section 13(1) of the IEBC Act. The role that we have to do under 137 is to check the voters register. And we check voters register for even people who, for Kenyans every other day, it's a public document. There's no role for the IEBC to play. And if the court were to make there was a role for us, then we say those are administrative roles, but the court should not find a role for us.
Please supply authority you have quoted of E031 to E033 of 2024.
I will, it is hot off the press, I will submit it just now.
submit to our assistants.
I will, Your Lordship. I will. Thank you so much for this.
My Lord,
Thank
I
you.
want to apologize if I appeared to take judicial discretion from you. It was intended to keep my promise to you that we will be brief.
We now get to know that every side has a prefect, and at this side, the prefect is Professor Gitu.
My Lord, I just want to also add my voice to the submissions that have been made by the respondents. And they should go on record as that my name is Shara Mosede, Solicitor General for the Attorney General, together with Professor Gitu Muigai and Charles Mutinda and the rest of the team. Yes, my Lord, to say one or two things so that we wrap up submissions from our end. My Lord, it is not any contestation that under Article 145(7) of the Constitution, a final decision of impeachment was made. It is not in doubt, and that has not been controverted by either side.
No, we have. That is what we are challenging.
A final order, at least, my Lord, was made. Secondly, my Lord, it is also not in contestation that a vacancy has arisen or arose in the office of the Deputy President. It's also, my Lord, not in contestation or in doubt that Article 149 of the Constitution was invoked in terms of the President nominating Professor Abraham Kithure Kindiki as a nominee to that position, and that Parliament voted on the same. And I would agree with my learned colleague who has just left the floor, Mahat, that the framers of this Constitution never intended that the IEBC plays a role when it comes to the issue of impeachment. And my Lord, if they so intended, nothing could have stopped them from expressly stating that position. And therefore, my Lord, I am submitting the interim orders that were granted and are in place cannot cure that position. And therefore, my Lord, relying on the various authorities that have been cited, and more particularly, my Lord, the Munya case, which is a classic case in terms of what will be required in the grant of conservatory orders. It is my humble submission, my Lord, that that has not been made. And I would also submit, my Lord, that when you look at the greater public interest, my Lord, want to persuade you with the very many other arguments that have been given by my learned colleagues, that you will find favor that the discharge, the vacating, or the varying the orders that have been in place would find greater good than holding those orders in place. And therefore, my Lord, to conclude, I would urge my lady and my lords to find that we cannot continue holding the country at ransom. We need to make a decision that some of the roles and the responsibilities that are played by the Deputy President, which are currently at a standstill, would be extremely good and critical that the moment these orders are vacated, the rest of the processes should be allowed to be completed. I therefore humbly submit that you discharge the orders that are in place and allow the entire process to be completed. I submit, my Lord.
Thank you. My Lord, I want to confirm on behalf of the respondents that we rest there, but with your kind indulgence, if there is to be a reply, I think again we need to remind ourselves that it ought to be on points of law. If the case is rehashed afresh, we would still be here tomorrow and it would contrary to procedure.
My Lord, I also request a direction on whether persons who are not parties to the application, because there are only 2 applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Okay, 2 things.
Why are we being preempted?
No, two things on way forward. I think we still have to hear interested parties, or have we had them? Anybody? We finished with Dollar. Yes, now, the right to rejoinder is only limited to the applicants and not any other person supporting the application. So it will go only to the applicants. And in this case, we have 2, and they will have, how much do you need?
You had given us 30 minutes. If I remember. I am addressing the court, please. Yes. Reply to the court. You had given us 30 minutes.
My Lord.
Do we do 15-15 or 20-20?
No, my Lord.
Yes.
There is a lot that has been canvassed. In fact, they had given us the impression that they will need less than an hour. They have obviously done 4 hours and something. No. There was things that we
let us have on time.
We can do within 30 minutes.
Let's
or less, depending on how much he's able to cover. The only issue, my Lord, that is the mischief, is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business, and we go.
Okay, this is the way forward. We will give the respondents the time they need. 30 minutes each. Not the respondent, but the applicant. 30-30. Let's